Everyone. We are on day 9 of the hearing in the supplemental requirements for water reuse rule. This is docketed by the Commission Administrator as WQCC 23-84. This is one of many public comment sessions. It's the first of 2 today. The next one will be at 1 p.m. So I have 4 names here for the 9 o'clock hour, and then I'll issue a general invitation in the event anyone hasn't had a chance to reach out to Pam to offer their name. Just a couple of things. I will ask you to spell your first and last name. My name is Felicia Orth. I might have forgotten to mention that. I will ask you to swear or affirm that you will tell the truth. I will ask you to keep your comments to 3 minutes or less. Please collect your thoughts. I only invite public comment from each individual once. And if you have more to say than can be said in 3 minutes, please write it up and send it. Email is fine to Pam Jones. So the names I have are Paula Claycomb, David Snyder, Vicki Gottlieb, and Erlene Grossclose. I'll call them in that order. Paula Claycomb. Okay. Ms. Claycomb, can you hear me? Ms. Claycomb?
Yes, I'm sorry. I wasn't able to unmute and realized that I could do it.
All right.
Can you hear me now?
Yes, I can. If you would spell your first and last name for the record, please.
Thank you. My first name is Paula, Paula. Last name Claycomb, Claycomb.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Thank you very much. Good morning to everyone. I am 71 years old and a 23-year resident in Taos. I want to thank you for providing different options for the public to comment on the proposed water reuse rule. I wish to cite an editorial by native New Mexican Paul Pino in the July 10th issue of the Santa Fe New Mexican. Quote, "Why on God's green earth would anyone think we want to irrigate with oil field waste that contains, on average, 195 picocuries per liter of radium? That is 3 times the level at which the Environmental Protection Agency characterizes a substance as radioactive waste," end quote. Do you really want our farmers and households to use water that is known to be dangerous to human, animal, and planet health? The proposed rule would also allow for produced water to be reused for industrial and demonstration projects off the oil field. It would increase the transportation and handling of produced water and thereby increase the likelihood of accidents and spills. And there are already an average of 4 toxic spills from oil and gas per day in New Mexico. When U.S. Senator Jim Inhofe died a few weeks ago, all the obituaries and remembrances that I read highlighted his denial of climate change and his fight against climate science. Is that how you want to be remembered? Offering the oil industry, which has rarely been held accountable for cleaning up the messes it leaves behind, a way to offload its radioactive, sickness-producing, and deadly waste for use on our beloved lands? Please, I respectfully request that you return to the 2022 report by the New Mexico Water Task Force. It includes many recommendations which the state has not implemented or fully funded. I do not want my 11-year-old granddaughter or any of your children or grandchildren to live in a Mad Max world. Accepting the rule as proposed would contribute to that horrible scenario. I urge the committee to support a rewritten rule that clearly prohibits the discharge, disposal, or reuse of produced water off the oil fields. Thank you very much.
Thank you, Ms. Claycomb. David Snyder.
Yes.
Hello, would you spell your first and last name for the transcript?
DavidSnyder.
Thank you. And do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes.
Thank you. My name is David Snyder. I grew up in Albuquerque and my daughters were born there. And I have many family members of several generations who live in New Mexico, many of them native New Mexicans. I clerked for New Mexico Supreme Court Justice Richard Bosson in 2008 and 2009. I now live in California, where I'm a lawyer and I lead a nonprofit organization that advocates for government transparency and First Amendment rights. My testimony is only on my own behalf, not that of my organization. Transparency is the lifeblood of any democracy worthy of the name. That means transparency in how the government itself operates and how private industry operates when its work is regulated by government. There's far too little transparency surrounding PFAS and other contaminants involved in fracking. There should be public hearings on this issue, and the Commission should require the industry to disclose what it knows about these contaminants before any rulemaking. Far too much is at stake to take industry's word for it. The people of New Mexico, including generations of future New Mexicans, deserve more. Thank you.
Thank you, Mr. Snyder. Vicki Gottlieb.
Yes.
Oh, yes. Hello. Would you spell your first and last name for the transcript, please?
Vicki, V-I-C-K-I, Gottlieb, G-O-T-T-L-I-E as in every, B as in boy.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
When we moved to El Rito, New Mexico in 1970, we occasionally went to Los Alamos to buy the lab's used and leftover project items, which were all sold by weight. I recall hearing then that the incidence of cancer there was statistically high due to the use and handling of radioactive material. When my husband had the choice of relocating to Grants or Roswell as medical director of a small, loveless primary care group practice, I influenced his choice to be Roswell. I was pregnant with our second child, and to protect my growing family's health, I knew I didn't want to live near where uranium was or had been mined. I recognize that regardless of our financial resources, about $2,500 annually in the early 70s to a single salary in Roswell in the early 80s, that equaled our combined salaries in DC. We had the privilege of choosing where to live. Many New Mexico citizens do not enjoy that privilege. I believe we can learn from our mistakes. Regulatory responses are key, and wastewater reuse rule WQCC 23-84, as drafted, lacks the important health protections all citizens require. Please include the following. No person shall discharge, dispose of, or reuse treated or untreated produced water off of the oil field. The department shall deny certification of any federal permit proposing to discharge, dispose of, or reuse treated or untreated produced water off of the oil field. To avoid further degradation of the environment and ensure the public's health, safety, and welfare. Thank you.
Thank you, Ms. Gottlieb. Erlene Gross-Close. Okay, and I don't see her in the room. All right. Michael Sauber.
Yes, I'm here.
Great. Would you spell your first and last name for the record, please?
Michael Sauber, Michael Sauber.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
All right. I'll start your 3 minutes now.
Okay, thank you. As one of 2 million taxpayers paying everyone's salary there, for the purpose of protecting us from harmful pollutants and protecting our water supplies, I'm pretty upset. First of all, I'm upset because you're using the industry language of produced water instead of really calling it what it is, toxic fracking fluids. Their waste should never leave the oil field, and it's your job to ensure that. I'm upset because no credible scientific evidence exists that toxic fracking fluids can be cleaned to any health standard, especially at scale, when considering it contains uranium, plutonium, arsenic, lead, benzene, toluene, xylene, PFAS compounds, to name just a few. It's not like we don't have enough of our neighbors suffering the effects of cancers and immune system disorders that we need to create new ways to kill us or reduce health and life expectancy. It should be up to the industry to produce peer-reviewed scientific evidence that it's safe and at the scale they are proposing. And it's your job to your responsibility to ensure that before any decisions are made. I'm upset that the state has never enough personnel to monitor and increase and ensure the safety of fracking wastewater. Spills have increased in the last year. And if we don't have the personnel to sufficiently monitor something so critical that affects citizens' health, should we really be allowing it? I hope you would agree. I'm upset because the law clearly states that use of any fracking water shall obtain a permit from the Department of Environment. And a permit is necessary, and it's right to require one. I'm upset that you're considering spending taxpayer money on something that should be a cost of doing business. I've run 2 businesses in my 46 years in New Mexico, and I've never been the recipient of any taxpayer-funded bailout of something that should be a cost of doing business for the oil and gas industry. It needs to either stop fracking or find an acceptable way to deal with their toxic fracking waste on their own oil fields. As regulators who ensure the safety of our health, I want each and every one of you to state clearly that if this passes, you and your children will be the first to drink a tall glass of this healthy treated water before any is used in any shape or fashion on land outside of the oil and gas industry land. Thank you very much. It's appreciated.
Thank you. Is there anyone else on the platform who would like to offer and who has not already offered a comment, would like to offer a comment during this session? There will be another session at 1 p.m. today. Please put something in the chat. I'd like to comment. Okay, let me ask if there's anyone in the room who's here to offer comment during this session. No? All right, then we're going to return to the technical case. And again, there will be another public comment session at 1 p.m. So, Ms. Fox. We have just a little administrative matter to.
Is this working? Yes,
It is.
Pardon me? It's good. It's just a minute 18. Good morning, commissioners. I'd like to move to admit ABSC Exhibit 18 Rev, which I passed out this morning to the commission and served on council last evening and put in the Dropbox. And Commissioner Brancard has asked that that exhibit be supplemented with another page from the Excel spreadsheet that is referenced in Mr. Jacoby's testimony on page 7, line 134. It is data underlying NMED exhibit 140, and I move to admit.
I'll pause in the event there are objections.
We understand that the entire thing is in the record. So, and we understand this then to be a demonstrative exhibit, and on that basis have no objection.
Okay. Anything else? All right, it's ABSC 18 Rev is admitted.
Thank you.
So we have Mr. Wexler and Mr. Jacoby at the presentation table, and we need Ms. Nanasi in the cross-examiner's seat.
As we're setting up, just to, yesterday there was some discussion about our order. I just want to make clear our order for everyone so there's no confusion going forward.
Great.
After Mr. Jacoby, Mr. McCurdy, who's here in the hearing room, will testify. After that, it will be Mr. Balch, who is testifying remotely. He's in Pittsburgh. His only limitation is he has to be off the stand by Friday at 11. After Mr.
I'm sorry, but is your microphone on?
I think so.
It is? Could you just say, I'm so sorry, I didn't hear. Right after Mr. Jacoby, who goes next?
So after Mr. McCurdy is, after Mr. Jacoby is Mr. McCurdy. He'll be here live. Mr. Balch will then testify remotely. After Mr. Balch, we have Mr. Tischler, who is from Austin and is here in person. So we're hoping to have him on and off by the end of the week, by Friday. And then finally will be Mr. D'Antonio, who does have limitations on Friday. So we'll see how long it goes on Friday. Thank you.
Thank you for that. Oh, Commissioner Brancard, are you?
It's making it confusing to me to figure out just what NMOGA's position is in this matter, because we're not hearing from your primary witnesses.
Understood. So let me be clear about the reason for doing that, Commissioner Brancard, and apologize for any of the inconvenience. It has to do with the schedule of witnesses and travel and that sort of thing. So to be clear about NMOGA's position in this case, we support reuse. We support the development eventually of standards. We think that the technology exists to meet just about any standard that exists or could be adopted. I think the primary difference that we have with the Environment Department is we support the December version of the rules as originally proposed. We do not support, and we don't think it's either legally or factually supported, the idea that there would be a prohibition on all discharges of treated produced water. We think that the existing standards and the process for discharge permits is sufficiently protective as standards are developed, because it gives the flexibility to the department to develop the record, understand what's being discharged, what the plan for discharge is, ensure that all the standards will be met. If there are additional concerns for the Environment Department, they can, of course, add conditions, and then there's monitoring. So we think that that whole process is safe, protective of human health and the environment. And while the commission is waiting for new standards to be proposed, either by the department or some other entity, we think that discharge permits ought to be permitted.
Madam Chair, now I'm really confused.
Okay.
Because Mr. D'Antonio's direct testimony stated one position on this rulemaking, and then his rebuttal testimony stated a new position, and now we seem to be going back to his original position.
I don't think that's, so let me try and
Excuse me,
reconcile.
Madam Hearing Officer.
Yeah.
I think this is inappropriate this is a lawyer testifying at this point.
Okay, thank you.
I
Mr.
object.
Okay, thank you. Mr. Brankard, let me ask Mr. Wexler a question here.
Certainly,
My memory is that NMOGA has not yet made its opening statement.
that's correct. Yeah.
Okay, perhaps, Mr. Brankard, we could wait for that. And
Okay,
I think
it seemed like an opening statement here, but.
Well, you were just asking me to.
you
explain-
invited
Yeah.
that. I'm just saying, let's get through Mr. Jacoby.
So we're gonna have all the witnesses before they give their opening statements?
Well, our hope is to put the witnesses on today because we have time considerations. And then we're happy to fill in the gap with our position statement. I was simply trying to reconcile. I don't think it's obviously not evidence. It's simply
It's a statement, I understand.
correct.
I would still like to hear the opening statement, though.
Happy to do that. Yeah.
Okay.
And when do you want us to put that on?
Well, how about we get through Mr. Jacoby and then do it?
Happy to do that.
Okay, thank you. A lot of this, Mr. Bankert, is just driven by the scheduling constraints of NEE's witnesses, the scheduling constraints of NMOGA's witnesses. There's just been a lot of accommodation.
I do have one request on can we put Mr. McCurdy on first and do the opening after lunch, only because we just changed law firms. Right now, I'm unable to access my system, and I will be positive I can have that system after lunch. So
Okay, all right.
I appreciate that. Thank you.
All right, we're going to go back to Mr. Jacoby's questioning. Ms. Nanafsi.
Thank you so much.
Can you hear me this morning? I understand yesterday the reporter was a little put out with me by the end of the day. I apologize.
Ms. Nanafsi.
Good morning. Ms. Jones, may I ask you if you could please pull up New Energy Economy Exhibit 23 again? Thank you. And it's PDF page 5 that I'm looking at. Mr. Jacoby, I just have a couple of questions about this when this gets pulled up. Yes, please, PDA. Right there, to that picture. Actually, no, I'm wrong. That doesn't seem like the picture that I want. I think it's the next page. Yeah, thank you. So if you look at the picture on the right, it has a radioactive symbol on a yellow background that's on that container. Do you see that?
I do.
Okay. Have you ever been to this West Texas site?
I'm sorry, I didn't hear you. What was it?
Have you ever been to this West Texas site that's maintained by Lotus LLC?
I have.
And did you see containers like the one that is depicted in the picture here and the one that we saw yesterday?
Occasionally I do.
Madam Hearing Examiner, once again, I'd like to move the admission of New Energy Economy 23.
I'll pause for objections.
We object on relevance grounds. I'm not sure whether or not Mr. Jacoby has been to this site and seen this yellow mark has any tendency to prove or disprove a fact that's at issue in this case.
He just said that he was at the site.
I'm
And he
sorry?
saw, Mr. Jacoby just testified that he has been to the site and has seen containers that look like this there.
Okay, and the relevance to this rulemaking then?
Well, I believe that Mr. Jacoby is a lobbyist, has been a lobbyist, and is a consultant currently for Lotus LLC. He has talked about basically in his testimony that Mr. Noble's allegations, as he calls them, are fraught with misrepresentations, and I believe that the standard is relevance. This is clearly relevant about kind of work that Mr. Jacoby does, and I think the commission will find it useful if they decide to look further into this article. And Mr. Noble presented this as part of his testimony and exhibits.
Oh, Mr. Noble spoke to this?
He did refer to this body of work, including in his book, which I can hold off because I will go into that further in my cross-examination.
All right, why don't you do that?
Okay. Could we go to your rebuttal, please, sir?
Respond to one thing you just said. I was a lobbyist. I am a lobbyist, but I did not lobby for Lotus in the 2023 session, and I'm not currently retained by them as a lobbyist.
Could you please go to your rebuttal, sir?
May take me a minute to find all this. Oh, here we go. Okay.
Okay, so if you go to page 15, I think we addressed your Mr. Noble's allegation number 1, and now I'm going to go through the rest of them. Could you go to Noble's allegation number 2, and particularly, I'm wanting you to read, if you would, the sentence that begins on line 2299.
He anecdotally describes a fire in a facility located in West Virginia that was damaged by fire in May 2023 and where produced water was processed previously.
Thank you. May I approach, ma'am? Officer? I've now tendered to you previously marked Exhibit 11, and this is regarding this is the EPA bulletin concerning the Fairmont brine site in West Virginia from September 22nd, 2023, correct?
That's correct.
And sir, could you please read the commission under 1.1.2.2 description of threat? Could you please read that?
Before we read it, may I ask, has this already been admitted?
Yes, it has. Okay.
Very well, thank you.
May I ask, whose Exhibit 11 are you talking about?
This is we handed it out when Mr. Noble was testifying, the highlighted version of Exhibit 11, which is part of his testimony that was also admitted into the record. I wait.
Give us just a second.
Yeah, please.
But every party is using numerical numbers. So whose Exhibit 11 are we talking about?
NEE.
Any
NEE. Okay,
This
thank you.
actually Justin Noble's Exhibit 11, which was attached to his rebuttal testimony. However, we also, when he testified, gave out a copy that was highlighted to all the commissioners 2 days ago. Yes, sir. Thank you. I'd like to repeat my question if I can. Could you please read under 1.1.2.2 the description of the threat from this EPA bulletin?
Uncontrolled release of CERCLA hazardous substances, primarily the release of radionuclide radium-226 from a former brine processing plant.
And could you turn to the next page, please? And read where I've highlighted the first two highlights under paragraph G and H.
G reads, as described in A above, a tank in the upper complex caught fire on 5/30/23 and the contents exploded, launching the tank top over a building and landing approximately 100 yards from its original location. H reads, readings collected around the tank using field radiation survey equipment indicated levels of gamma radiation of approximately 1 MR per hour at the time of the fire. The data collected indicated the radionuclide released was radium-226. Radionuclides, including radium-226, are hazardous substances listed in 40 CFR 302.4.
So your claim that this was just a mere anecdote by Mr. Noble, wouldn't you say that that's a misrepresentation?
Not at all. My complaint about how Mr. Noble wrote about this is he compared it to Chernobyl, a reactor in Ukraine that blew up and spewed radiation all over Europe. That's not this facility. Now, granted, this was a mess and it needed to be cleaned up, but it was not Chernobyl. He overstated it, helped him sell his book, I presume, but that's simply not true.
And other than your complaint that it was overstated by Chernobyl, you're not saying that the radiation and the fire and the fact that this is cordoned off now, this whole site, you're not saying that that is meaningless for this commission to understand when this was about a produced water recycling facility, right?
No, I would take this very seriously. This is a mess. But this is not indicative of what goes on in New Mexico or Texas. This is a facility in West Virginia.
Here, later on that same page, at the bottom of 15, you make that kind of relationship, which is like, while we have no evidence of New Mexico produced water treatment facilities failing, you would agree that we must take care to prevent such an occurrence from happening here, right? Like what happened in West Virginia.
Well, of course, and that is the second thing I think should be noted. This facility is regulated by the regulators, radiation control regulators in West Virginia. And it should never have been allowed to get into this condition to begin with. I've worked with the New Mexico Radiation Control Bureau, and I can tell you they're among the strictest in the nation. I don't believe this would happen in New Mexico.
Let's go to allegation number 3. And that is this is about the Aqua Salina, where they used that contained radiation, where it was on the shelves of Lowe's and Hartsville Hardware. Again, you acknowledge that this is not a mere allegation, right? This actually happened.
Let me refresh my memory on this. Oh, this is the Ohio use of produced water for treating ice on the roadways. I'm a Texan, so I don't really know much about ice on roadways, but
they found
yeah.
that to be radioactive, right?
Pardon me.
They found that to be radioactive, correct?
It did contain some radioactivity.
Yeah. Not just some, it was something like 1,000, more than 1,000.
It contains some radioactivity.
Okay. And in fact, the department, the state of Ohio since banned that Aqua Salina.
The Ohio Bureau of Radiation Control did their own analysis and determined that it contained that the using ResRad, which is a computer model to predict dose to the public, that the dose was about 0.4 millirem per year, I presume. Yeah, 0.441 millirem per year, which is well within acceptable levels. My impression is there was some further political and other concerns coming from other areas, and the Radiation Control Bureau said, we're going to shut this down until we resolve it.
I assume you are concerned about the health and welfare of the workers who handled and stocked that de-icer Aqua Salina, correct?
The workers that handled it did what? I'm sorry.
The workers that handled that Aqua Salina, you're concerned about that, correct?
Well, if it's sold as a commercial product and there's no dose exceeding the allowed dose of the public, I don't think you need exceptional radiation control.
Could you please go to Justin Noble's exhibit number 12, which is New Energy Economy exhibit number 5, I believe. Could you go to that peer-reviewed article? It's Justin Noble 12.
12, the Burgos paper.
Yes.
Okay.
So the title of this peer-reviewed article that appeared in Environmental Science and Technology from 2018 is called Environmental and Human Health Impacts of Spreading Oil and Gas Wastewater on Roads. Is that correct?
Yes.
Could you read the abstract for us, please? And please speak closely to the microphone.
You want the entirety of the abstract?
Yes, please.
So the abstract says 13 states in the United States allow the spreading of oil and gas wastewaters on roads for de-icing or dust suppression. In this study, the potential environmental and human health hazards of this practice are evaluated. Analyses of oil and gas wastewater spread on roads in the northeastern U.S. show that these wastewaters have salt, radioactivity, and organic contaminant concentrations, often many times above drinking water standards. Bioassays also indicated that these wastewaters contain organic micropollutants that affected signaling pathways consistent with, let me find my, consistent with xenobiotic metabolism and caused toxicity to aquatic organisms like Daphnia magna. The potential toxicity of these wastewaters is a concern as lab experiments demonstrated that nearly all the metals from these wastewaters leach from roads after rain events, likely reaching ground and surface water. Release of a known carcinogen, e.g. radium, from roads treated with oil and gas waders has been largely ignored. In Pennsylvania from 2008 to 2014, spreading oil and gas wastewater on roads released over 4 times more radium to the environment, 320 millicuries, than oil and gas wastewater treatment facilities, and 200 times more radium than spill events. Currently, state-by-state regulations do not require radium analyses prior to treating roads with oil and gas wastewaters. Methods for reducing potential impacts of spreading oil and gas wastewaters on roads are discussed.
And sir, you're familiar with this study, correct?
Yes.
And it was largely cut as a result of a number of the universities in Pennsylvania that collaborated on this. Is that correct? You see it here at the Pennsylvania State University, a couple of people from that institution, and then also actually from Canada, different scientists from there participated in this. Is that right?
That's correct.
You know that subsequent to this study, that not only Pennsylvania, but 3 other states banned de-icing and dust suppression using treated produced water.
Yes.
So if we could now go back to your testimony and go to allegation number 4. This is referencing Mr. Noble's testimony and the linkage here between radium and carcinogenic material. That's what you're talking about here, right?
Yes, this is, I believe, his allegation that ingestion caused childhood cancer, if I remember correctly.
Yes.
Okay.
And so you're a radiation specialist, wouldn't you say?
I am.
Okay. And you're familiar, in fact, with EPA's facts about radium, correct?
I am.
And so, according to the EPA, quote, if inhaled as dust or ingested as a contaminant risk, there's an increased risk for several diseases, including lymphoma, bone cancer, and hematopoietic, which is blood formation diseases. And I'll spell that for the record, HEMATOPOIETIC, such as leukemia and aplastic anemia. Would you say that your understanding of contamination by radiation and its effects on human health is consistent with the EPA facts about radiation?
I don't know the specificity as you read it, but I do know that radiation could be a cause for cancer.
It goes on to say that, quote, risks of cancer is increased in essentially all tissues and organs. Is that your understanding as well?
That is a possibility.
So let's go to allegation number 5.
But before we go to 5, I think
know what?
it's important to know he was
Excuse me?
talking about Ewing's sarcoma.
Okay.
And the
Excuse
medical
me?
doctors,
Oh,
not
madam,
me,
Hold
medical
on.
doctors believe that's not correct.
All right, hold on. We have to speak one at a time in order for the court reporter and interpreter to catch our words. Ms. Zanasi, I think you should let him finish what he started. Mr. Jacoby, please finish what you were starting there.
Thank you. My concern about allegation number 4 is that Mr. Noble focused on Ewing's sarcoma, which is a cancer in children. I presume I'm not a medical doctor, but the American Cancer Society and several other medical journals reported that there is no known connection between radiation exposure and Ewing sarcoma. That was my concern.
thank you. If you go to your Nobel's allegation number 5, here you criticize Noble for relying mostly on his book and his interviews with workers. Is that essentially what this allegation number 5 is about?
Yes, let me review it quickly, if you don't mind. My concern about this number 5 is that he had these anecdotal conversations with workers and others about detriments that they had from their employment. He, however, did not bounce that, I believe, by checking with the company's environmental health and safety officers or other medical doctors that could have given a more balanced viewpoint.
Madam Hearing Officer, may I approach?
Yes.
This page.
Okay.
So I have just tendered you the book that Justin Noble just published in April of this year. Could you read the title of that book?
The title of the book is Petroleum 238.
Okay, could you read who the book is dedicated to? Just the first bold section up there.
It says, there are a number of people whose words and stories are included in this book and informed my reporting, yet passed away before the work could be completed. This book is dedicated to them.
And sir, could you go to where yes, right where your hand is, right there. Starting on page 351, is it correct, if you just look briefly, that his book cites almost 75 pages of citations? And if you look at page 423, you started on page 351. If you go to page 423, there are a total of how many sites there?
336 sites.
And could you read the blurb about Mr. Noble on the right-hand flap of that book jacket?
Justin Noble writes on science and environment for U.S. magazines, investigative sites, and literary journals. His work has been published in Best American Science and Nature Writing and Best American Travel Writing, a book he co-wrote with a death row exoneree. The story of Dan Bright was published in 2016 by University of New Orleans Press. His 2020 Rolling Stone magazine story, America's Radioactive Secret, won an award for the long form writing with National Association of Science Writers and inspired this book. Justin's writing has helped lead to lawsuits, academic research, public dialogue, and has been taught with Harvard School of Public Health.
Before we go on to your allegation number 6, could you tell?
Are you done with this?
Yeah, thank you. Before we go on to allegation number 6, could you tell us how much you're being paid for your testimony in this case?
$400 an hour for testifying.
On allegation number 6, this is about your critique of Mr. Noble for including information about the fact that New Mexico, no, strike that. In allegation number 6, you're not denying that New Mexico still continues to suffer from the uranium mining and milling injuries that have happened here nearly 50 years ago.
I think that's stated poorly. I wouldn't use the word suffered. I think there are still some sites that need to be cleaned up. To the extent anybody suffers from them, I just don't know. I suspect that's not entirely true.
Do you know that the Church Rock uranium mill spill was the largest release of radioactive material in U.S. history, having released more radioactivity than the 3 Mile Island accident 4 months earlier, and that happened on Navajo Nation tribal land, tribal trust land.
I know of the incident. I think trying to compare it to 3 Mile Island might be misleading because the isotopes are different. The release is different. There's a lot of differences. I'm not downplaying the release. It's unfortunate that it happened.
You should definitely take that up with Wikipedia. Let me ask you this. Do you know that the breach released more than 1,100 short tons of solid radioactive mill waste and 94 million US gallons of acidic radioactive tailings into the Rio Puerco?
I read that in Mr. Noble's book, but I haven't validated it.
And again, have you ever been to Church Rock where it happened?
Pardon me?
Have you ever been to Church Rock?
I have not. I'm familiar with it, but I haven't been there.
There's an annual march to commemorate that site, and that site is still there, right? It hasn't been cleaned up.
It's been stabilized, but it's not been entirely removed.
Not entirely, but not removed at all, correct?
Not removed at all, but it is stabilized.
Again, this history is instructive for us to learn from and take caution. You're not asking this commission to ignore both the incidents in the past 50 years ago and radioactive spills and contamination, or the West Virginia incident in 2023. You're not asking the commission to ignore that, right?
I wouldn't ask the commission to ignore that, but I would ask the commission to realize that was 50 years ago, and the industry does a lot of things differently now to make sure those things don't ever happen again.
But this happened in 2023 in West Virginia. You've already testified to that.
The incident that occurred in West Virginia occurred because, in my opinion, the regulators should have done a better job of overseeing that facility. I don't think that would happen in New Mexico.
Because the regulators did a good job, right?
They do a very good job in this state. They're among the most difficult to deal with in the United States, believe me.
Now, if we go to,
Hold on. Yes. Yes, we have to take care of an interpreter issue.
Amelia, we aren't able to hear you anymore in the Spanish channel. No, we're still not able to hear you. We can hear you now. Thank you. Apologies.
Yep. Thank you very much. Go ahead, Ms. Nasi.
Thank you. If we go now to allegation number 7, you sort of you dispute his testimony regarding salt water disposal wells, but again, you don't have any citation or justification here, right? It's just you don't agree with what he said, and that's it.
Um, I don't think I agree with what he said, but I don't think that's really an issue in this proceeding. So I just didn't spend much time on it, to be frank with you.
Okay. So your allegation number 8, you say here on line 415, you're concerned about you restate Mr. Noble's concerned about radioactive contamination, and then you say he creates, quote, a concerning and liability stoked legal landscape due to contamination. Due to aforementioned widespread contamination. Is that right? That's what you say here?
A liability stoked legal landscape due to aforementioned widespread contamination, yes.
If contamination occurs in New Mexico, do you not anticipate there would be litigation?
No, I'm certain there would be. There always is.
Isn't Mr. Noble's message to avoid such harms by enacting precautionary safety regulations for oil workers before damage happens?
Objection, I'm not sure Mr. Jacoby can say what Mr. Noble intended with his testimony.
Would you rephrase that question?
I believe it's completely relevant. Mr. Jacoby, were you here when, may I ask another?
Just rephrase the
okay.
question, that's all.
And Mr. Jacoby, you were here when Mr. Noble testified, right?
I was.
And you heard him repeatedly say that he was really concerned that these regulations don't protect worker safety, correct?
I did hear him say that.
And you also heard him say that it was incumbent upon this commission to enact regulations that would take into consideration both norm, that if the fact that it exists, and also that the workers who work in produced water, having anything to do with produced water, might be radioactively poisoned. Is that also true?
Can you say that again, because I get a little lost there? Are you suggesting that, well, I don't want to ask what you're suggesting. What point were you making?
Mr. Noble was asking this commission to enact regulations that recognize the existence of norm in produced water, correct?
Yes.
And he was also asking this commission to only pass regulations that would protect worker safety in the event that there was any reusable, any reuse of produced water. Is that also correct?
I believe that's what he said, yes.
Nothing further.
All right, thank you. Ms. Nasi. Mr. Wexler, do you have any redirect?
Just a couple of questions. Good morning, Mr. Jacoby. Commissioner Patton yesterday asked you about the possibility of radium accumulating in the soil after application to land for agricultural purposes. You recall that?
Yes.
And in your response, you discussed the 515 rule, but really about when a well is decommissioned. Would the same process apply to agricultural lands?
Yes, it does.
And can you describe that process, please?
So here's what is commonly done if you have radium on the surface of the land that exceeds the 5 picocuries per gram limit. You would go out, with a radiation detector of some sort, survey the area, find those areas that happen to be exceed the regulatory limit, stake them, mark them in some way, go back and do further surveys to understand the extent of the contamination, where it is and what it is. You would then go out and you do a grid and it's normally a 100 square meter grid. It's 10 meters by 10 meters on a side. Mark it off, and then you would take a number of samples appropriate to evaluate what the radiation level is in that area. And normally it's what they call a 5-spot. You would take one sample at each corner of the grid and one in the middle, send that to a laboratory, get a accurate measurement of the radioactivity. If it's above the limit, you would take some action to decontaminate that area, if you will. Normally, you do that simply by disc plowing the area, because if it's not extremely contaminated, if you plow the area so that you churn the radioactivity into and mix it in a soil, it will usually be below release limits. If it's not below release limits, when you do that, you have to excavate it and send that to a disposal site. And that's what's done. When you get through, the land meets the criteria for clean soil.
This morning, Mr. Jacoby, you were asked about some 3 or 4 examples of other spills or untreated produced water for purposes such as de-icing. To be clear, is it your testimony that produced water can be treated to appropriate standards for radiation?
Yes.
And if treated to standards, the treated produced water is safe for the human health and the environment?
Yes.
No further questions.
Okay, any reason not to excuse Mr. Jacoby? Right, thank you very much, Mr. Jacoby, for your testimony.
We'll call Mr. McCurdy to the stand, and Ms. Olson will be presenting him.
All right, thank you. Should we take 5 minutes?
That'd be great, thank you.
All right, just 5 minutes to change witnesses. Okay, let's come back from the break, please. All right, we are back after a very short break to have a new counsel and new witness at the presentation table. See here, I think this is Mr. McCurdy. Would you spell your first and last name for the transcript, please? Thank you, and do you swear or affirm to tell the truth? Thank you very much. Oh, you're going to have the mic.
Okay,
Ooh,
now it's on.
reasonably close, but not too close.
Let's try to find a good balance here.
All right.
Would you need me to repeat that? It's
No,
nice.
it's fine. Ms. Taylor.
Order is.
Yes, oh, for cross, it's the same as we always do.
Okay.
Mr. Maxwell, you, Mr. Cox, Mr. Hightower, Mr. Davis, Ms. Nanasi, Ms. Fox, Mr. Knight.
Okay. Yeah, I just put it in. I just put it into presentation mode. Okay. On our screen.
It's in presentation mode on your computer, yes.
It's in presentation on our computer. Doesn't look like it's showing up in presentation on there. So do you think that might be like a lag or?
Try going to the next screen on. No.
Sometimes hitting the plus sign helps.
Are you talking to me?
Yeah,
This is mirroring.
I don't see a.
there, up at the top, there's a plus sign.
Oh,
Sometimes hitting that makes things bigger.
it's just in the.
We're currently in presentation mode on this laptop, but it's not showing up there in presentation.
Should be mirror. Stop sharing. So do share again. Oh wait, that's not. Share on. And you want to.
Sorry, hit the word slideshow. I think that might help. It's up at the top.
And you can get out of this.
Oh, from beginning.
Madam Hearing Officer, we can see the presentation on the platform.
Thank you very much, Commissioner McWilliams. Did you hit from beginning?
Yes,
Okay.
it's on
Okay.
the beginning of our.
It's-
It's not on the.
So I think this.
Well, I'm advancing this.
I see.
I'm just.
Oh. I was just going to say, instead of advancing, sometimes you can just hit the slides along the left-hand margin.
The presentation is showing. Screen showing as it's not showing the same on this screen.
Okay.
I'm not sure why.
Okay.
I'm gonna try doing entire screen. That doesn't seem to be. You may have to just control your slides. No. So it's doing it in that mode, it just won't do it in presentation mode. Is that okay with you?
Yeah. We'll bypass some of the animation. No notes. No, they're just animation, but we may have to just bypass the animation.
Okay.
It'll be a little bit smaller, so it'll be.
This may be the best we can do for now. I think people can see it, though.
Whatever works best for the hearing and for the public.
I think this is fine if you all are okay with that.
I think it is fine. All right. So let's, Mr. McCurdy has spelled his name and been sworn in. Go ahead, Ms. Olson.
Good morning, Mr. McCurdy. Can you hear me okay? I'll go closer. Is that better? Okay. Mr. McCurdy, what is your current position?
I'm currently Vice President of Innovation and Sustainability for Select Water Solutions.
And do you have before you what has been marked as NMOGA Exhibit 6? That's NMOGA Exhibit 4?
Yes, I do.
Do you recognize that as your direct technical testimony that was pre-filed in this matter?
Yes, I do.
And was that testimony prepared by you or under your direct supervision?
It was prepared by me.
Do you have any substantive changes to that direct testimony?
No.
Is that direct testimony true and accurate to the best of your knowledge and belief?
Yes.
If you were asked those same questions today under oath, would your responses be the same?
Yes, they would.
And do you also have before you what has been marked as NMOGA Exhibit 11?
Yes.
Do you recognize that as your rebuttal technical testimony that was pre-filed in this matter?
Yes.
Was that testimony also prepared by you or under your direct supervision?
Yes, it was by me.
Do you have any substantive changes to that testimony?
No.
Is that testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked those same questions today under oath, would your responses be the same?
Yes, they would.
So now I'd like to turn to those summaries of Mr. McCurdy's testimony. He's prepared demonstrative PowerPoints to assist with those summaries. Each were uploaded into Dropbox and made available to all parties, the commissioners and the hearing examiner. Mr. McCurdy, I believe the commission has access to your direct testimony and the commissioners have reviewed that. So I'd like to just highlight some of the key points in your direct testimony. But before we get there, can we start with your background? You've provided a copy of your resume as NMOGA Exhibit 7, is that correct?
That is correct.
And again, just highlighting a few areas relevant to the testimony you're providing today, can you briefly summarize your relevant education and professional experience?
Yes, I can. I've already stated my current position. As of this year, I have 44 years of experience in the U.S. oil and gas industry. Primary focus throughout my career has been on oil field chemistry and produced water treatment. Currently, in my role within Select, I represent Select on all of the state and federal associations devoted to looking at produced water. That includes the New Mexico Produced Water Consortium, and I'll speak a little bit deeper about these a little later on in the testimony.
And would you slow down, please?
Yes, I can.
Thank you.
I'm also represent Select on the Texas Produced Water Consortium, as well as the recently stood up Colorado Produced Water Consortium. And additionally to that, Select is a member and I represent them on the National Alliance of Water Innovation. During my career, I've given presentations on produced water to the US EPA, the Department of Energy, the Government Accountability Office, the National Academies of Science, Engineering, and Medicine, as well as the Energy Information Agency.
And can you briefly describe Select Water Solutions?
So Select is what is commonly referred to these days as a midstream water provider for the oil and gas industry. This is something that didn't really exist several years ago. Now it is, and what midstream water companies do is they tend to gather in produced water from various operators, clean that water to a condition to where it can be reused in ongoing hydraulic fracturing activities. And where there is not an access or an outlet for that water in completions, then we dispose of that water in Class 2 UIC wells. UIC.
And can you briefly describe your role as Vice President of Innovation and Sustainability?
So I do several different functions within Select. One of them is such as what we're doing here, be an advocate for our industry and help promote that. I've already mentioned that I represent Select on all these produced water consortiums, as well as attend all the associated produced water conferences that are circled around that and present often at those individual things as well. And then a third hat I wear within the company is we have a small team of 4 individuals who are devoted to looking at new technology and innovative technology focused on treatment of produced water. And I'm one of the 4 people in that group that are actively looking at new technology on a day-to-day basis.
And just to clarify for the record, it's a little bit confusing. Is Select a member of NMOGA?
Yes, Select is a member of the New Mexico Oil and Gas Association. And since you mentioned that, I would like to point that out that I'm here representing NMOGA, not as a representative of Select Water Solutions.
That was going to be my next question. And then briefly, can you just describe your role on each of the state produced water consortiums?
So I'm an active participant within the water consortiums. When New Mexico was originally stood up in 2019, I was there for that event rollout and have been a member of several of those different working groups within the consortium since then. I've also been involved with the Texas consortium since the day it was stood up and am active on all of their different governing groups, as well as their stakeholder board. And then the newest one, the Colorado. Colorado is a little different. It was really heavily structured by their legislature, and it has a finite number of individuals. You're only allowed 33 seats, and you have to be appointed. And I'm one of 4 appointed seats representing expertise in produced water.
Mr. McCarty, I'd like to now turn to the substance of your direct testimony. Can you please provide a summary of the purposes of your direct testimony?
Yes. The testimony I provided is, as I said, supporting NMOGA's position on the proposed Part 8 through my testimony as follows. Number 1, historical treatment of produced water in the United States and current discharge of treated produced water in various areas.
Mr. McCurdy, slow down.
Okay. State and federal efforts to promote and regulate use of treated produced water. And lastly, the potential role of produced water in the production of hydrogen as a source of green energy.
And as mentioned, the commission has access to your full direct testimony. So I just want to go through some of the key points on each of those issues. Can you please summarize the highlights of your testimony on historical and current discharges of produced water?
Yes, I can. Briefly, just some history, and I think it's been mentioned before. Wyoming has been allowing discharge of treated produced water for decades now. But to be fair, this is a relatively low TDS water. It generally is associated with unconventional coal bed methane production. And typically in many areas, the coal seam where it comes up into the ground, that is the source of groundwater for those particular areas. The Fayetteville Shale, that was an attempt in the 2010, not an attempt, but a successful attempt in the 2010s, where an operator was using a distillation process referred to as vacuum distillation, mechanical vapor recompression to treat Fayetteville Shale water. And then eventually, once approved through a whole effluent toxicity test, that water would be discharged into the White River. That has since no longer occurred, as the Fayetteville Shale eventually become an unproductive play in the U.S. And then lastly, ongoing to this day in the Marcellus Shale, an water treatment operator in Wysox, Pennsylvania, is also using that DD/MVR process I just mentioned, along with full crystallization to take Marcellus Shale water all the way down to a solid salt. The distillate from that process has to meet a set of 39 criteria established by the Commonwealth that's referred to as WMGR 123. Appendix A, which I'll show here in a minute. Once you meet that criteria, it is relabeled as a beneficial reuse water, and then they, through a NPDES permit, are able to discharge that water into the Susquehanna River. And that is currently ongoing today. And here are the 39 constituents under the WMGR 123 Appendix A that's established by the Commonwealth of Pennsylvania. Just because of some of the previous testimony, I'd like to draw everybody's attention. There is a requirement on here for radium, and that in order to be discharged, radium has to be below 5 picocuries per liter.
Okay, and similarly, can you walk us through a couple of the key points on your testimony on current state and federal efforts toward beneficial use of treated produced water?
Yes, I can. So briefly, we've talked about the New Mexico Consortium. I would like to take a minute to congratulate New Mexico. You were the first state to set up a research consortium focused on produced water and have done a wonderful job in doing that. Several of the other states that I will be talking about here are following your lead and really paying close attention to what has been developed within this consortium. This consortium, as you're aware, was announced in the fall of 2019. It's a joint effort between the New Mexico Environment Department and New Mexico State University. Primary focus has been the potential to safely augment existing freshwater supplies with desalinated and polished produced water. Next up was Texas. Texas Senate Bill SB 601 established the Texas Produced Water Consortium hosted at Texas Tech University. Their first year deliverable was a white paper on feasibility of safely using treated produced water outside of oil and gas. And I was part of the group that helped contribute to that white paper that went to the legislature. They're currently in their second year. The second year is devoted to an RFP to select pilot projects to support with analytical testing. I was part of the group that helped set up that RFP and evaluate the responses to that RFP. Some of those pilot projects have been carried out and they're in the process of going through the analytical phase now. And I would like to note that there was a 3-tiered analytical process developed by New Mexico State or by the New Mexico Produced Water Research Consortium. And the Texas Consortium did use that exact 3-tiered approach for their analysis process for the pilot projects that they were overseeing in Texas. And then lastly, I mentioned the Colorado Consortium. It's the newest. It's in its first year of operation at present. This consortium is, like I said, a little bit more structured. It falls under the Division of Energy and Carbon Management in Colorado, which is a part of the Colorado Department of Natural Resources. Their first year, numerous deliverables almost monthly or every other month back to the legislature regarding different aspects of produced water. The initial focus has been minimizing freshwater usage in oil and gas operations because they're not quite advanced in that area as both New Mexico and Texas are. The later focus, probably mid-year next year, will be to focus on the potential to treat and beneficially use produced water outside of oil and gas operations. And then lastly, I mentioned earlier on the slide, the National Alliance of Water Innovation, commonly referred to as NAWI. This was established in 2020 with a 5-year, $110 million DOE grant. It is hosted at Lawrence Berkeley National Lab. There are 14 university partners plus Oak Ridge National Lab. New Mexico State University is a member. Additionally, Bergendorf is an aligned research partner of this association. The focus has been on improved desal for 11 different water streams, with 3 of those associated with oil and gas. The DOE apparently liked what was occurring at NAWI because this past year they received an additional $75 million extension for another 5 years.
And for the benefit of the court reporter transcribing, can you, I believe Bergendorf is an acronym. Can you provide that?
It is the Brackish Groundwater National Desalinization Research Facility, and it is here in Alamogordo, New Mexico.
Thank you. And finally, I think your testimony provides a lot of detailed information about green hydrogen production. Can you summarize the key points of your testimony addressing produced water as a potential source of water for green hydrogen production?
Yes, I can. There's a tremendous amount of interest these days in hydrogen, and that's primarily due to the fact that within the Inflation Reduction Act, there was an opportunity to get up to a $3 per kilogram credit for hydrogen production, provided you could meet certain criteria with regard to release of carbon dioxide. Without going into all the details in this, it would be appropriate to mention that apparently at this point in time, and I'm going to briefly discuss the various forms of hydrogen production and how they go by color, but green hydrogen will likely be the only hydrogen that will qualify for this $3 per kilogram credit. I should point out that if you applied for this credit and received it, if you applied for this credit and received it, you would receive this credit for a period of 10 years, provided that the production of the plant or the construction of the plant that was going to generate this hydrogen occurs before 2033. I won't go into all these. Depending on how hydrogen is produced and depending on what you do with any associated carbon dioxide that is produced with it, that determines how you label a hydrogen with a color. For the purpose of this discussion today, let's just stick with green. Green is hydrogen that is produced through an electrical process called electrolysis, where you essentially are going to take pure water and split it into hydrogen and oxygen and recover the both. But the electricity used for this process must come from renewable sources, such as wind, solar, hydro, geothermal. It cannot come off the grid and not still be considered green hydrogen. I won't bore the commission with going into all the stoichiometry of how hydrogen is produced and how much water is required for some of the different types. But what I would like to point out is we're referring to green hydrogen. I've already talked about those first two bullet points. Just from a chemical standpoint, you need 9 kilograms of water for every 1 kilogram of hydrogen that's produced. But that's not everything. You're also going to need water it's a very heat extensive process. You're going to need water for cooling throughout this process. Typically, a green hydrogen production process needs somewhere between 16 and 25 gallons of water for every 1 kilogram of hydrogen that's produced. This may be a little bit hard of an example to everyone to read, particularly in this small format, but it's a diagram that illustrates all the pathways in green hydrogen production where water is needed and where water is rejected. You will have a concentrated stream off some of these processes that will come out and have to go to disposal. And as I mentioned, there's going to be a considerable amount that's used for cooling throughout the process. In this example here, they use reverse osmosis, regardless of what water source you start with, whether it be municipal, surface, groundwater, it would have to go through reverse osmosis first to ensure it was a quality ready to be moved to an electrodialysis process. Electrodialysis process is what will ultimately get it to what we will talk about later is ultra pure water, which is what is needed for hydrogen production. I'd like to point out here that many of the thermal distillation process, membrane distillation process that we discuss regarding produced water could be substituted for this reverse osmosis process here and give you a distillate water that would be suitable to go into that electrodialysis unit. or electrodeionization, sorry. In this example here, I believe we've got 59 kilograms of water on the front end to produce 1 kilogram of hydrogen coming out of this plant. Again, a lot of information here that I prepared previously for a conference that I had attended, but let's focus on green hydrogen, which is the bottom row that has data in it. For green hydrogen, we're going to need somewhere between 380 and 600 barrels. And I apologize, but that's the world I live in and think constantly in terms of barrels of water, which is 42 gallons of water in the US. But somewhere between 600 barrels of water for every metric ton of hydrogen that's going to be produced. Now, if we were to look at oil and gas produced water, we on average in the Permian Basin believe that we could get about a 50% recovery of a distillate out of this produced water. So if we had a plant that was going to produce 100 metric tons per day of hydrogen, we would need somewhere in the neighborhood of 75,000 to 140,000 barrels of produced water a day to be treated to provide the water for that plant. Just briefly, I talked green hydrogen, what it does. We use these what are called PEM membranes, proton exchange membranes. That is what is used to split that H2O into hydrogen and oxygen. We have to put ultra pure water up against these membranes or they will foul very quickly and have to be replaced, and they are very expensive. Ultra pure water is commonly defined as 18.2 meg ohm, OHM, resistivity measurement. With this kind of resistivity, this water cannot conduct an electric current. I oftentimes say that if we had a wading pool of this water in here, you could stand in it barefoot and I could drop a toaster in that was plugged in and you would not feel any harm, because there are no salts or electrolytes in the water to conduct electricity. TDS, the total dissolved solids of this water, is typically measured in nanograms or picograms per liter. Now, approximately 1/2 of the needed water at these plants will be for electrolyzers. The other half will be used for cooling. That water will not have to be treated quite to this quality. We can probably get by with something in the neighborhood of 250 milligrams per liter, which would still be a relatively low TDS water. If produced water was used, then we could take the concentrate back from that cooling process and either dispose of it in a class 2 UIC well or reuse it to be used in ongoing hydraulic fracturing completions. One of the reasons there's such a strong demand and strong interest, particularly in New Mexico, for green hydrogen, is here's a map prepared by the National Renewable Energy Lab that demonstrates the best areas in the U.S. for both solar and wind renewable energy production. Obviously, if you look at the map, particularly the eastern side of New Mexico tends to fall into that desirable category for renewable energy production. However, there is one small problem with that. I just pulled a typical drought monitor map from roughly 1 year ago. And as you see, that eastern 1/3 of New Mexico, and as I'm sure many of y'all are aware, it's not a question of if it's going to be in a drought, or a question of when it's going to be a drought. It's just a question of how, right? So how? Because it's very common for the eastern half of New Mexico as well as the western part of Texas to commonly be in drought conditions, meaning that we have a scarcity water issue. I believe this is the last slide I have on hydrogen production. I'd like to point out that the current U.S. hydrogen production is roughly 10 million metric tons per year. However, the projected growth for hydrogen in the U.S., particularly in light of these incentives that have been put in place for it, is expected to grow by 55% between now and 2030, which could put us approximately in the U.S. at a hydrogen production rate of 220 million metric tons per year by the year 2030. Now, if that's all green hydrogen production, and that alone would require between 454 and 721 million barrels per day of treated water. And to put it in more common hydrological terms, somewhere in the neighborhood of 58,000 to 93,000 acre feet of water per day for the hydrogen production in the U.S.
Thank you. And just to recap, can you please provide the summary conclusions from your direct testimony?
So with regards to my concluding remarks, New Mexico is currently leading all other states in researching beneficial use of the highly treated produced water. And again, you're to be commended for taking the lead on that. Using treated produced water for hydrogen production would offer economic development opportunities to the state, but would not alleviate future freshwater concerns. Using treated produced water to offset current freshwater usage does. If we can treat produced water to an ultra pure status, and we can, why would it not be possible for industry to treat to a level that was set for safe for discharge? NMOGA does not believe that there is a basis for banning discharge of a treated produced water at this time, as the New Mexico Environment Department can simply deny a permit request under the existing regulatory framework if they are not satisfied with the quality of the treated water. And then lastly, I would like to thank the Water Quality Control Commission for the opportunity to present direct testimony on behalf of the New Mexico Oil and Gas Association for consideration regarding the proposed rule.
I'm just going to switch to your rebuttal PowerPoint quickly. I may have to.
Ms. Olson, we're going to need a break soon. Would this be a good time?
Sure. I anticipate this would be another 20 minutes. So if we want to take a break.
Let's take a break
that sounds
now.
great.
All right, let's come back at 11. Okay, let's come back from the break, please. All right, Ms. Olson, I see you have you're sharing slides for Mr. McCurdy's rebuttal testimony. Go ahead.
Thank you. So we finished direct testimony. Moving on to the summary of your rebuttal. Can you briefly provide the purpose of your rebuttal testimony?
Yes, I can.
You can skip through
I
this.
think, okay, I'm just going to briefly say I'm submitting rebuttal testimony on behalf of the New Mexico Oil and Gas Association, and I've previously provided this written, which is, actually, this is NMOGA Exhibit 11.
Yeah.
On the slide here, it says NMOGA Exhibit 4, but my rebuttal was actually NMOGA Exhibit 11. All right, so the purpose of my rebuttal is to respond to the direct testimony of the New Mexico Environment Department and other parties to this proceeding. I will address their testimony focused on 4 topics. Topic 1, contention that there is no way of knowing what contaminants may be in produced water. Topic 2, federal and state bans on discharge of produced water, particularly from hydraulically fractured wells. Topic 3, disparity of peer-reviewed papers on untreated produced water versus papers on treatment and use of a highly treated and polished produced water. And again, talk briefly about the quality of water needed for green hydrogen production.
And Mr. McCurdy, can you please identify the documents and information that you reviewed and relied on in preparing your rebuttal testimony?
So I have reviewed the proposed regulation. I have reviewed the written direct technical testimony and exhibits related to topics covered in my direct testimony submitted by the following: the New Mexico Environment Department, Amigos Bravos and Sierra Club, New Energy Economy, Wild Earth Guardians. I have reviewed numerous peer-reviewed published studies focused on quality and utilization of treated produced water. Several examples are provided as NMOGA exhibits 75 through 127.
And Mr. McCurdy, briefly regarding the papers that you identified and attached to your to NMOGA's NOI and your rebuttal testimony, can you explain how you selected the papers that you identified?
Okay. Yes, I can. Some of the stuff or some of the papers and exhibits that we included were projects that I worked on, along with others, such as the Groundwater Protections Council's 300+ page report on produced water. Several of them I helped participate in gathering data for and stuff, though I was not an author. And then other of the papers were part of my job is to routinely keep up with papers that are being published and put out regarding advances in produced water treatment. And so I tend to gather those, keep them on file, read them. The ones that particularly really apply to what my company or others around me may be looking at, I read thoroughly. Others that may advance one small part of a piece of the puzzle, I'll tend to scan and keep copies of them.
And Mr. McCurdy, have each of these papers gone through the peer review process and been accepted and published in a journal?
Yes, of the papers that I submitted as exhibits for this testimony or for this hearing, everyone has went through a peer review process.
And have you personally reviewed each of these papers?
Yes, I have, and I have notes regarding each one of the papers. What were some of the significant findings, and what were the focus of the papers?
Okay, I'd like to turn to your rebuttal opinions. To give us a roadmap, can you please just summarize your rebuttal opinions?
Absolutely. We'll start with the New Mexico Environment Department can evaluate and deny discharge requests for produced water under existing regulatory framework. Technical testimony submitted by New Mexico Environment Department and others does not support a statewide ban on discharge of treated produced water at this time. Adopting such a ban would only extend the time for New Mexico to possibly access a new water source for the state. This is due in part to the time and effort needed to repeal such a ban once analytical data suitable to NMED was available. Other states who have authorized or considered authorization have done so without the need for an upfront ban.
And similar to your direct testimony, the commission has access to your full written rebuttal testimony. So I just want to stick to the key highlights of the issues you've identified. Can you briefly summarize your testimony refuting other participants' testimony on unknown contaminants in produced water and unavailability of analytic techniques for contaminants in produced water?
Yes, I can. So with regard to that, the direct testimony of meaning, including NMED, that discharge is not possible as approved analytical techniques are not available for many contaminants in the high salt matrix produced water. My response is on down two possible avenues. One, reduce the salt content of produced water so more approved analytical techniques are available for characterization of the produced water, and utilize newer instrumentation that's coming online that allows for more thorough characterization of the treated produced water. There's a concept out there that's been discussed. It's been discussed with the EPA, and they're interested in it. The most common method of determining effluent guidelines is you have to know what's in the wastewater precisely up front to where you can develop guidelines. The high salt matrix of produced water makes that difficult, but industry is not going to intentionally discharge a high salt or a high TDS produced water. One of the things that's going to have to be done is through a desalinization process, we're going to remove or reduce the amount of salt that's in that water. Once we do that, many analytical techniques are available out there to look at that, what I would refer to as desalinated produced water. Once you take a look at that water, you will be able to set effluent guidelines for either a dischargeable produced permeate or distillate, which would be a desalinated produced water that now meets discharge criteria. In addition, new instruments and techniques are improving analysis of produced water, particularly for unknown contaminants. Among these are high performance liquid chromatography, as well as mass spec instrumentation with time of flight analysis. These instruments enable us to look at contaminants down to the nanogram per milliliter or picogram per milliliter concentration accurately. And now we have talked about non-targeted analysis. These are instrumentations that you don't tell them what to go look for. They just go look for anything in the water. They take the results of that search, and then it gets parsed through newer databases that have organic structures identified in them, and they're able to match up those unidentified compounds with those organic structures and give us a definition of what that is. These are done through a process called ultra high performance liquid chromatography. And I mentioned the software and databases have been developed to go hand in hand with that. New Mexico State University has used non-targeted analysis in the new software on a distilled and highly polished produced water. That's been this past year. Out of that analysis, they did identify 12 unknown composites in the distillate. However, all 12 of those were in the picogram per milliliter range, so somewhere in the 1 part per billion or slightly above range.
And I believe the next section of your rebuttal testimony responds to NMED and other party testimony addressing regulation on discharge of treated produced water in other jurisdictions. Can you please provide the highlights of your testimony on that issue?
So when we look at potential bans, what exists currently is there is a federal ban on discharge of an unconventional produced water to publicly owned treatment works facilities in the U.S. This resulted from untreated unconventional water in the Marcellus. Historically, many of the operators up in the area, that's how they'd handled their produced water, because if you're not aware, the Commonwealth does not have a good disposal network within the state. There's actually I think now today, 8 disposal wells all throughout the state. Conventional operators would take their produced water to a public POTW. It would go through minimal treatment within that facility and then be discharged along with municipal waste into a riverway. As the Marcellus was developed, unconventional operators were doing the same thing and handing their water off. Studies demonstrated that downstream of these effluents, they were starting to see things that were characteristically found in produced water in the stream bed sediments, such as barium, strontium, radium. That's led the EPA to ban that practice. Should have never been done to start with. Also, California has a ban on water from hydraulically fractured wells being used for irrigation. However, California for decades now has been allowing conventional produced water to be used for irrigation. And with regards to hydraulic fracturing, we often seem to think that that's something that's relatively new. But oil and gas wells in the U.S. have been stimulated via hydraulic fracturing since 1947. The majority of the wells producing in the Permian Basin that have been drilled since the 1950s have all been hydraulically fractured, whether conventional or unconventional. States do allow discharge of some volume of produced water, and we've talked about these previously. Wyoming has done it in the past, though this was unconventional coal bed methane, relatively low TDS water. And then we discussed currently what's going on in Pennsylvania, where Marcellus shale water is being treated, taken to salt with the distillate meeting those 39 criteria I mentioned earlier, and that water being discharged to the Susquehanna River. Additionally, I would like to point out that our sister state to the east of us here, Texas, the Texas Department or Texas Commission on Environmental Quality, TCEQ, has recently approved a discharge of a treated produced water for South Texas, relatively small discharge, less than 400 barrels of water a day. They have a second discharge permit for the same area that's currently under final draft review. They have 2 additional permits that are going through the review process now. One will be for a 20,000 barrel a day discharge into the Pecos River tributary north of Pecos, Texas. And the last one is a request for a permit to dispose of a maximum of 400,000 barrels of treated water per day into Red Bluff Reservoir just south of the state line. I would encourage the New Mexico Environment Department to collaborate with TCEQ on Pecos River discharge parameters. If that water can be treated to a status acceptable to TCEQ, this would allow NMED to follow the same criteria and allow for discharge into the Pecos River on the New Mexico side, thus aiding the state in meeting the Pecos River compact requirements.
Mr. McCurdy, the third section of your rebuttal, I think we're on, responds to NMED and other party testimony regarding availability of peer-reviewed published research addressing water quality treatment and utilization of treated produced water. Can you please provide the highlights of that testimony?
Yes, and one of the things I would like to point out is the disparity between the number of papers addressing effects from raw produced water versus a produced water that has been treated to a low TDS quality and with removal of organics and other contaminants. The majority of published papers out there, peer-reviewed papers over the last decade and a half, have been focused on raw produced water and the effects that it could possibly have to the environment. Fewer papers were focused on the potential to recover a beneficial water from that produced water, primarily due to the fact that disposal was relatively cheap and abundant, and that was considered a perfect option for that produced water. There was not a consideration amongst operators to consider looking at potential treatment to reduce disposal volumes and recover fresh water. A couple of things have changed that. Number one is we've seen induced seismicity. We're currently seeing it just south of the state line here in New Mexico. But previous to that, it has followed this unconventional development is these larger water volumes required disposal. When the Barnett Shale was initially in its heyday in North Texas, we had 2 disposal wells there linked to induced seismicity. few years later, as the Fayetteville shell that I mentioned earlier was kicked off in Arkansas, again, two disposal wells there were linked to induced seismicity. Many of you may be aware that Oklahoma went through a rash of seismic events back in the mid, say 2013, 2014 period, which ultimately resulted in the Mississippi Lime being a uneventful play because it required a lot of water disposal, and yet the water was going into wells that were contributing to induced seismicity. Now we're down and it's Texas' turn. We've had 3 active seismic areas within Texas. A 4th one just recently popped up, which was interesting. The one east of Snyder, Texas, because there is no unconventional development over there. So in conjunction with induced concerns with induced seismicity, and then also with concerns that when we look at various state future water plans, New Mexico, Texas, Colorado, all of those states have concerns over whether or not they are going to have fresh water to meet the demands of the citizens of the state in the future. That is what is leading us today to see more and more papers. So I would I'm opposed to the concept that there are no peer-reviewed papers out there that look at treatment of produced water, highly treated produced water, and what can be done. Thus why I've submitted several of those papers as NMOGA exhibits 75 to 127, because those papers do exist.
And addressing those papers recently, and again, these are the exhibits identified on page 11 of your rebuttal testimony, and also listed and provided with NMOGA's rebuttal NOI, NMOGA exhibits 75 through 127. So we've gone over your familiarity with these papers. Can you please explain the purpose of identifying these papers in your rebuttal testimony and providing them as exhibits in this proceeding?
So the purpose, as I mentioned, was to make sure the commission is aware that there is research ongoing about the possibility of recovering a low TDS beneficial water from a produced brine. We understand the concerns that have been presented here earlier by some groups about the contaminants that are in produced water. I would like to point out that when you go through these treatment process, typically it's a train. There's a pre-treatment process on the front end. There is a distillation process in the middle. And then there is typically a polishing process on the end, depending on what particular contaminants you're targeting. But if most of the contaminants that have been discussed from a concernable standpoint, radium, uranium being one, do not make it through. I just recently referenced the Commonwealth of Pennsylvania's WMGR 123 Appendix A. You have to be below 5 picocuries per liter in order to discharge that water.
And can you please provide for the commission the high-level takeaways from these papers?
High-level takeaways from many of the papers demonstrate that water can be effectively, either through a membrane distillation or a thermal distillation process, can be polished to a point to where we recover some volume of a very good, clean, low TDS water that could be beneficially used. We believe some of the papers that were submitted there demonstrated through greenhouse studies how this water could potentially benefit growth of plants in a given area in irrigation.
And Mr. McCurdy, are the papers you selected and included with NMOGA's rebuttal NOI intended to be an exhaustive list of published research on developments in characterization, treatment, and utilization of treated produced water?
No, it is not. I did not have the time to put that exhaustive list together. There are hundreds of papers, peer-reviewed papers out there that have been published looking at the potential to recover this low TDS water. One of the technologies I'm a fan of, membrane distillation. There are over 200 papers associated with the results from different membrane distillation lab and research pilot tests regarding treatment of produced water.
And Finally, moving on to your last topic covered, do you have any additional points you want to state from your rebuttal testimony regarding quality of water needed for green hydrogen?
So I will try not to be redundant on some information that I provided earlier regarding green hydrogen. Just would like to point out that green hydrogen can be produced through many different methods. We're focusing on green here today because that's the one that would garner the largest credit through the Inflation Reduction Act. Again, green hydrogen uses electricity along with a proton exchange membrane to separate a water molecule into hydrogen and oxygen, and the hydrogen being gathered. Again, I talked about ultra pure water and what condition that water had to be to where you could use it with these proton exchange membranes. And I did point out that the other quality of water would be needed for cooling, but it would not necessarily have to be released to the environment once you were done with the cooling process. It could be returned back to oil and gas operation. Again, I will not go all the way through all the requirements. I would point out for ultra pure water a couple of additional necessary needs. The total organic carbon of that water must be less than 10 picograms per liter, and the bacteria count for that water must be less than 10 colony forming units per milliliter. I would also like to point out, because people have said, well, instead of produced water, we could utilize fresh or brackish water for hydrogen production, and that is true. However, both of those are going to have to go through an extensive cleaning process prior to being handed off to that electrodeionization unit. And if that's the case, then why not use produced water and put it through a distillation process and utilize it? I've oftentimes, and just so you'll know, I grew up on a small farm just east of Midland, Texas. The water well that we had at our farm was drilled into a brackish aquifer. We could not drink it. We could irrigate with it. And what I tell communities is the brackish water is your lifeline. When we get to a position to where fresh water is not available for the community, that's the easiest source for a community to find water and treat it, is that brackish water. Or if you're going to do it for consumption. So save that brackish water wherever you can.
Thank you, Mr. McCurdy. And can you please just provide the conclusions briefly from your rebuttal testimony?
Yes, I will. Thank you. New Mexico is currently leading all other states in researching beneficial use of a highly treated produced water. Again, you should be commended on that. There is no technically supportable basis for banning discharge of a treated produced water. The technology exists to take produced water to an ultra pure status. And if that is possible, why would we not consider that that water would be suitable for discharge to the environment? In fact, that water would be so pure that if we were going to use it for irrigation, we would have to add some minerals back into it prior to it being used for irrigation. Lastly, again, I would like to thank the Water Quality Control Commission for the opportunity to present this rebuttal testimony on behalf of the New Mexico Oil and Gas Association.
Madam Hearing Officer, that concludes the summaries. I do have a very brief line of questioning on Sir rebuttal before I tender him for cross-examination.
That's fine.
Mr. McCurdy, the first topic that I want to briefly address in Sir rebuttal is the need for additional research. One of the department's positions throughout this hearing, echoed by other parties, that there simply is not sufficient data on characterization of produced water to allow the commission to pass a rule at this time that opens the door for possibility of discharge. At the hearing specifically, the department witnesses witnesses from other parties pointed to the Danforth paper, which I believe is NMED Exhibit 133, to support these positions regarding variability and unknowns of produced water. Are you familiar with Dr. Danforth's literature review?
Yes, I am.
And do you have a response to that rebuttal testimony relying on Dr. Danforth's literature review to support the rule proposed?
Yes, I do. And I would like to state for the record that Dr. Chloe Danforth is a friend. I've known her for numerous years, going back to her time with Environmental Defense Fund. And in my previous role with Chesapeake Energy Corporation, we worked closely with Environmental Defense Fund on a number of projects. However, a couple of things I would like to point out about this Dr. Danforth's paper. One is it was a literature review focused on all the potential contaminants that could be found in produced water. This was literally across the United States. That doesn't mean that those contaminants are all going to be found in the Permian Basin, because it was focused on the Marcellus and different areas and such as that. Of that literature, some of those contaminants were only found in one piece of literature article. It doesn't mean it was found all throughout everything else. There was a large focus on the fact that, if I remember the number correctly, that out of the 1,200 plus contaminants listed in the literature, there was only toxicological information available for, I believe, 170 of those, thus raising a concern about all the others that we did not have information on. Two things to point out: just because toxicology information doesn't exist doesn't mean that that particular contaminant poses a toxicological hazard. Number two, that is raw, untreated, produced water. Many of the contaminants listed in that paper would not make it through this treatment process I just described of pre-treatment, distillation, and polishing. Therefore, we only need to worry about any contaminants that could make it through that process. The instrumentation available to look at produced water when this paper was produced is not as accurate as it is today. Thus, I believe the research that's currently being done today, as I referenced earlier for New Mexico State University, is allowing us to really zero in on any potential unknown contaminants that could possibly make it through this treatment process. It was a valuable paper and a lot of effort went into it. Once again, Dr. Danforth is a friend, and I commend her for all the work that she put into that paper.
And carrying on with the papers and questions about available research, we discussed the journal research papers that you provided with your rebuttal. I think you've alluded to other projects that you're aware of through your experiences on the New Mexico Consortium, as well as your professional responsibilities. Is that accurate that there's new additional research addressing the variability and characterization of produced water, supporting safe utilization of treated produced water?
Yes, and I've mentioned several times, I'll reiterate it again today, I think New Mexico State's taking a wonderful lead in a lot of this and the analysis that they're doing, but other academic institutions are as well, both here within the state, in Colorado, and in Texas as well.
And briefly regarding the ongoing research from the New Mexico Consortium, which I think is the New Mexico State research that you've alluded to, has the New Mexico Consortium presented on some of this new research?
Yes, just recently with the New Mexico Consortium's mid-year review, there was a presentation given on some of the latest research that they've done regarding a distilled and highly polished produced water from one of the pilots. That presentation was again referenced with this State of the Science Symposium that was hosted by NMED here back several weeks ago. And I also believe that presentation is scheduled to be presented next week at the Produced Water Society's Permian Basin Conference in Midland.
And Mr. McCurdy, were you present at that State of the Science conference for those presentations?
Yes, I was. I was present at the State of the Science Conference, as well as I spoke on a panel there during the symposium.
And I believe you said that that conference was maybe hosted by the New Mexico Environment Department.
That is correct.
And so this may be self-evident, but were members of the New Mexico Environment Department there for those presentations?
Yeah, yes, they were. All the way from Secretary Kinney to several individuals underneath him were there at that symposium.
Okay, thank you. That's the questions I had on that topic. Turning to my other topic of rebuttal, regulation of discharge and pilot projects in Texas. And this is in part intended to be responsive to Commissioners Thompson and Armstrong questioning of Ms. Courier. So going way back to day 2 of this hearing, the department witnesses provided testimony in response to questions from, I think it was Commissioner Dominguez, regarding Texas's approach for reuse of treated produced water for projects on land applications. She suggested in that testimony that Texas allows for demonstration projects for a very limited amount of time, both based on your knowledge and experience with the Texas Produced Water Consortium and your professional responsibilities. Are you familiar with the this process that the department witnesses were testifying to?
Yes, I am.
And just to provide some clarity and background, is it your understanding that the Texas Railroad Commission has jurisdiction over land applications?
Yes, I do. Currently, it's clearly delineated within Texas that the Texas Commission on Environmental Quality will have jurisdiction over all surface applications, surface discharge of a treated produced water to a waterway or a surface or a water body. Currently, the Texas Railroad Commission is taking the lead on jurisdiction over any land application of a treated produced water.
Okay, and going back to Ms. Fulham's testimony.
would-
Go ahead, sorry.
Sorry to
No,
interrupt you.
please.
I would state that that could change in the future. They have a kind of a memorandum of understanding between the two groups now that that's how they're going to let it proceed for now. These are, and we're going to get into the details on that in a minute, but as these grow to a larger future project, that could change with TCEQ taking a more stronger role.
And going back to Ms. Fulham's testimony at hearing, and I'm attributing it to her. I believe there are other department witnesses who chimed in on this. The demonstration projects regarding land application that she was talking about, is it your understanding that is before the Railroad Commission?
Yes, it is. The Railroad Commission currently is, they're not really referring to them as a permit. They're referring to them as a letter of authorization, which would allow these land applications of a treated produced water on a small scale. They tend to be 5 to 10 acres or smaller, but they are taking jurisdiction over or setting up those letters of authorization.
And can you elaborate on the duration of those projects?
Yeah, that once you receive a letter of authorization, it's good for 1 year. There are certain criteria within that LOA, monitoring requirements for the land application. Not only that, but when you apply for it, you have to demonstrate this is what we're going to do. This is the plan of the project. This is what we're going to monitor. This is how we're going to take soil samples and take a look at effects to the soil. LOAs are good for 1 year. However, at the end of 1 year, you are allowed to apply for a 1-year extension.
And has the Railroad Commission actually provided authorization for projects?
Yes, yes, they have. The first one was done roughly, the letter of authorization came out a year ago. However, there's a conflict between the technology provider and the landowner that has resulted in that moving forward. But there now are other applications before the Railroad Commission that they are considering now at looking at different projects. There has been one carried out so far looking at a much smaller, like a 1 acre alfalfa plot.
And addressing only these railroad commission authorized projects for land application. I believe your testimony was these are smaller scale projects. Are you aware of the approximate level of investment for these studies?
So I believe it's been discussed in here a few times during this hearing. There are analytical requirements of the water quality that's going to be discharged. These are these full-blown suites that we talked about earlier, the three-tiered approach. Typically, those are $15,000 a piece to do that. There's multiple of those that are required throughout the pilot project. In addition, depending on the size of the unit, small scale unit could be relatively cheap, like $100,000 to build a pilot. A larger one that say was going to produce 500 barrels of produced water or treated produced water per day. There's one of those piloting right now, not on a land application, just piloting on testing water just outside of Midland that I'm personally aware the capital cost of that unit was well in excess of $5 million.
And Mr. McCurdy, now turning to the discharge permits that you referenced in your rebuttal testimony, that you testified are currently under the jurisdiction of the Texas Department of Environmental Quality, TCEQ. Is that correct?
That is correct.
And this is different from the pilot studies referenced by in the department testimony that you discussed. Is that correct?
Yes, it is.
And these are larger scale projects. Is that correct?
That is correct. The ones that I referenced earlier regarding the Texas Commission on Environmental Quality discharge permits, these are not pilot projects. These are larger scale. The two I mentioned for South Texas are not pilot projects. It's just they're not treating that much water. So they tend to be less than 400 barrels of water per day being discharged.
And this again may be self-evident, but I'm assuming these discharge permits have conditions.
Absolutely. That's the way TCEQ is set up. Typically applying for one of these permits, you have to supply their requested suite of information regarding what is the raw produced water, as well as analysis of the treated produced water to demonstrate what you would be intending to discharge. If my memory serves me correctly, you're required to do this 4 times throughout the permitting process to do that. So and then once a permit is applied, depending on the size of the project, receiving body that it's going into, the TCEQ will dictate, here's what we want you to sample, and here's how often we want you to do the sampling.
And based on your experience sitting on the consortium of Texas, is Texas looking to the monitoring and reporting data from these projects as another source of information regarding reuse of produced water, informing reuse of produced water?
Yes, they are. Texas is in the similar process to New Mexico right now, is doing the best they can to gather as much data as possible from these pilot projects and these ongoing permitted projects once they're actually up and running to generate as large a database as possible.
And do you have a sense of the level of investment for these larger scale projects?
So when I'm looking at technology available for these larger projects and fabricating equipment to reach these type of volumes, I have an ideal number in mind from a capital investment. Ideally, I would like to spend no more than $1 million for 1,000 barrels of distillate provided on a daily basis. That's an ideal number. Many of the various technologies we've looked at do not reach that level, but that's a goal. But let's just look at that goal. If I had a plant that was going to discharge 10,000 barrels of treated water per day, the capital for that plant would be $10 million, ideally. Not to mention operating costs, just the capital investment. There are one of the discharge permit requested for the Pecos tributary just north of Pecos. That's a 20,000 barrel per day discharge. So at a minimum, that company will be looking at least a $20 million capital investment. There's another company I'm aware of that is considering the possibility of a plant that will produce 30,000 barrels of treated produced water per day. Again, most likely a minimum of $30 million investment. So these are going to be large scale infrastructure investments on the part of the oil and gas industry.
Are you aware of whether NMOGA members are considering pilots or projects on the scale you've discussed for Texas?
Yes, they are. It's obviously in southeastern New Mexico, particularly in the Delaware Basin. Everyone's well aware that there's a large volume of produced water that moves from New Mexico into the Texas side, across into the Texas side of the border for disposal. That disposal is being very restricted. All deep well disposal has essentially been shut in what is referred to in that North Culberson Reeves seismic response area. And so New Mexico producers, members of NMOGA, are getting very concerned about the availability of long-term disposal in that area to keep up with oil and gas activities. So many of those operators are looking at these potential treatment pilots as a way to help alleviate some of those disposal concerns.
In addition to the investment of money that you've spoken to as another benefit of these projects, if they're happening in New Mexico, contribution of data and information regarding or related to treated produced water.
Rephrase that again.
Sorry, I did a bad job on that one. In addition to investment, are there other benefits to these projects for providing data to the state on related to reuse of produced water?
Absolutely. I mean, obviously the data that comes out of these pilots and out of these projects will be valuable in determining that this can be done safely for the environment and for the citizenry of the state. As I mentioned earlier, particularly if we're in the Delaware Basin, if surface water discharge was allowed to the Pecos Water tributary, and as you're well aware, once you get below Malaga, that water in that river is basically unsuitable for anything. Typically 7,000 milligrams per liter. You get milligrams per liter, sorry. A Red Bluff Reservoir, I believe, is closer, somewhere in the neighborhood of 10 to 15,000 milligrams per liter now. So not really suitable for any freshwater fish. So any amount of a lower TDS water coming into that water stream would likely be beneficial to it, as well as, again, there is a compact between New Mexico and Texas regarding or requiring a certain amount of water to move from the state of New Mexico through the Pecos River into the state of Texas. Treated produced water could help with that compact requirement.
And if the Water Quality Control Commission were to adopt the proposal before them, which puts a moratorium on discharges of produced water, will that have a chilling effect on investments in the large-scale demonstration projects that are needed to advance that research in New Mexico?
So I would not flippantly, but I would say that just common sense, the answer to that would be yes. If you have an operator or you have a service company that's going to provide one of these treatment facilities and they have activities both in New Mexico and in Texas, and all of a sudden it seems like Texas is more acceptable to taking a look at this process and New Mexico is more opposed to it, then the investment dollars will move into these projects in Texas.
Thank you for your testimony, Mr. McCurdy. I would now pass you for cross-examination or examination by the commission and then cross-examination by
And we already admitted exhibits 4 and 11.
Madam Hearing Examiner, I was going to wait to the end of his testimony to move for exhibits because some of them have been objected to, but I'm happy to proceed as you ask.
No, that's fine. Thank you. We have about 15 minutes. Commissioner Zemlich, would you like to start off the questions?
I don't have any questions at this time. Thank
All
you.
right, thank you. Commissioner Fry?
Thank you. So I'm really interested in how Texas is proceeding with oversight and reporting in the cases that you described. So is it they receive a letter of authorization? Is that to an actual permit request, or what is their process?
So for the Railroad Commission, you do make a request directly to them. Ideally, they would like that request to come to a landowner who says, we are willing to host this demonstration project. Along with that, though, whichever company is providing the technology and providing the produced water, they have a requirement to include that information within that LOA request. And then the Railroad Commission will consider it, make sure all the boxes are checked regarding what they are requiring to be. And then they will go through the process. And then once they do that, they approve the letter of authorization. The one or two I've seen so far have been approvals straight to the landowner to move forward.
Okay, thank you. And then just in terms of terminology, you talk about land application. I believe New Mexico would call that surface discharge then.
That would be correct, yes.
Okay. Let's see here. So in the case of the rules as proposed, they want to set up a notice of intent process. And in that notice of intent, well, in the process, it's expected then that data is given to NMED, all data. Do you see a difficulty in really getting all of that data from the companies?
Not if they're going to participate through the notice of intent process. Some of the pilot, I'll be honest with you, some of the pilot projects that are closed loop, meaning none of this treated water is leaving the system. It's all being perhaps separated, analysis gathered, and then this water combined back together to be used to be disposed of via a class 2 UIC well. Those that I've seen done, there are companies that are not releasing that information. They're keeping it proprietary for the time being. Part of the reason for that is some of this is newer technology that's coming on for these pilots. These companies they're looking at it from a competitive standpoint, that they want to make sure that this is exactly what they want it to do. But now, obviously, when they get to the point to where they want to move to discharging this water, whether it's land application or surface discharge outside of the oil and gas industry, they will be required to submit that data. So in the case of New Mexico, where we have the NOI process, companies, if they're going to participate in that, will have to release that data to the state.
Yeah, I guess I'm asking because there's some skepticism, I think, among other parties that they would actually do that.
I do believe I heard perhaps some testimony yesterday of some comments regarding that, well, they wouldn't release the data that perhaps was unfavorable to the outcome. I think that's up to the state. The state is going to specify this is the data we want to see. We want to know what these contaminant levels were found in this water. And I don't think whether it's an operator or a service provider, you're going to be allowed to submit the data and go, we've got 5 lines here that are blank. I don't believe that's going to be the case.
Okay. And then going back to the case of Texas, so are they required to give all data in their activities?
Yeah, yes, they are. And in retrospect, because that letter of authorization process has been published by the Railroad Commission, so it is available for public review. Should have submitted that as an exhibit, but it specifically spells out, here's the data that we want to see, here's the frequency that we want to see it during this potential 1-year pilot project. And then, as I mentioned, TCEQ for surface discharge to a waterway, they again have a specific set of criteria on here's all the information we want and here's how often we want to see it. And in addition to that, both instances, I should make sure we point that out, the data that they're requiring, the analytical data must be through a lab that is certified under the National Environmental Lab Accreditation Program, so a NELAB lab.
Right, yeah, okay. Are there other requirements in terms of state or other oversight of, like, are there inspections or anything of facilities?
The Railroad Commission is very interested in seeing these pilot projects. So I know a couple of their individuals that are involved with it, and they have said that they will want to come out and take a look at various times throughout the project. Within the TCEQ discharge permit process, that is a built-in portion of it that at any time you could be subjected to an inspection unannounced.
Okay, so there's the unannounced inspections, but also they're looking to have invitations
Yes.
to look at the
Yes,
sites.
you are
Okay.
correct.
Have you seen companies resisting that in any cases?
Again, Commissioner, that if companies are wanting to move forward with this, that resisting it is not going to be a good way for them to go about it. So the ones that are actively pursuing this are accepting that as that's going to be a part of it.
Okay. And then you were talking about the amount of investment in either of these cases, either in Texas or in New Mexico. Well, I guess you did talk about New Mexico already. Are you seeing companies resisting investing on that LOA process?
No, we're not. Matter of fact, as I mentioned, there are two that I'm aware of already. So they've invested into technologies that would treat that volume of water. In transparency, there's one that my company is involved with that will likely come to fruition sometime later this fall and move forward. And in addition to that, there was another one we're considering possibly for next year. So no, I think the companies understand that that is the first step that's going to potentially allow for larger projects in the future, for larger land application projects over a larger area. And so you have to go through this process properly, the way it's outlined, to produce the data before you're ever going to be allowed to go to that next step.
Okay. Are you familiar with any cases where companies have not met the requirements?
No, I'm not. I will say anecdotally that is a concern that industry has. I think the phrase has been that there's going to be some wild cowboy out there. And industry is opposed to that. We don't want to see that happen. We all know that not in this instance, but many others, all it takes is one bad apple to upset the apple cart for everybody else. So we tend to try to monitor ourselves and be sure that there's nobody out there that is trying to go rogue and go outside of the existing regulations. I remember a couple of years ago, I had one individual say that he was tired of waiting on a permit, so he was just going to move forward. This was in Texas. And he asked me what I thought would happen. And I said, well, I think first of all, you're going to get a cease and desist letter from, I'm not sure if it'll be the Railroad Commission or TCEQ. And they're going to tell you, you must cease and desist discharging this water immediately, or you're going to be fined so much a day. When you continue to no longer do that, I said, then the next thing will be probably the county sheriffs, or most likely the Texas Rangers will show up on location and you will go to jail.
Yeah, okay. Thank you. No more questions.
welcome.
I
Thank you,
appreciate
Commissioner.
testimony.
Okay, Commissioner Patton.
No questions.
All right, Vice Chair Armstrong.
Thanks. Just a few questions for me. I appreciate your focus on something that you've noticed the commission has interest in the Texas process, and appreciate you including on your PowerPoint slides the permit numbers for the TCQ permits that you've described today. Did you, I don't think any of those permits or documentation on those permits are included as exhibits though, are they?
No, I do not believe we included those as exhibits. You can go to TCEQ's site and you can download them based on those permit numbers that there, and they will give you, you can download the actual application itself as well as a current status of the process of where it's at within the review process.
Okay, thanks. My question on these is how is TCEQ asking for the when and how is TCEQ asking for characterization of the water?
So my understanding, and to be honest with you, my company is also in the process of preparing initial applications for several different discharge locations. So we're working with an engineering firm that specializes in that. It's a minimum 330-day process for review. And throughout that 330 days, along with several different public comment periods, there are specific timelines in there when you need to have this analytical data to us by this time. You have to have a description of your technology to us by this time. You have to have additional analytical data to us by this time. And it's spelled out within their permitting process.
And is that analytical data before or after treatment?
So both. You have to provide a certain amount of raw data, of raw produced water data ahead of time, but then you also have to demonstrate through like a pilot project what's the quality of water that you're going to be able to provide or discharge to that receiving stream.
And on the front end of that, before treatment, how are we sure that we're identifying all of the potential contaminants in the water?
So they have a process similar to, they're not looking for 400 different contaminants in the water. They're looking for essentially, I believe it's something like 70 different primary contaminants in the water. Then they look for a more extensive list once you get on the process where the water has been desalinated and there are approved analytical techniques for that water.
Okay, what concerns have been raised in Texas about whether that leaves something out?
That I'm not aware of. I have no doubt that there are concerns that have been raised from some groups, but I'm not aware specifically of what those concerns are.
Okay, thanks.
Thank you, Vice Chair.
Thank you. I think we'll break for lunch now. And Commissioner Dominguez, when we return, we'll have the 1 o'clock public comment session, and then we'll go to your questions. I know you're anxious. Thank you all. 1 o'clock. Let's come back from the lunch break, please. It's 1 p.m. on day 9 of the hearing in WQCC 23-84. These are proposed rules relating to water reuse. My name is Felicia Orth, hearing officer appointed by the commission to conduct the hearing. This is our second public comment session of the day. The next public comment session will be at 9 a.m. tomorrow morning. Just a few things about public comment. One, we can invite folks to go just once, so please collect your thoughts. We have to limit comment to 3 minutes. If you have more to say, we're happy to have it included in the record. We would just ask you to write it in an email to Pam Jones, who's behind me. I will ask you to spell your first and last name for the transcript, and I will ask you to swear or affirm that you will tell the truth, because the commission rules call for everyone to make that statement. So I have a number of names here. Lou Bays Guerra.
Yes, ma'am, I'm here.
Oh, thank you. And I'm sorry. Hold on just 1 second. I forgot to ask Ms. O'Grady to make her statement. The entirety of the hearing is being captured by our court reporter, Teresa, and also by a team of interpreters interpreting between Spanish and English.
Thank you, Madam Hearing Officer. For anybody who is appearing on WebEx and would like to access the Spanish channel, all you'll need to do is go to the bottom of the screen and there's a globe. Click on the globe and choose Spanish. Si hay alguien que está participando vía WebEx y quisiera acceder a los canales de español, nada más tiene que buscar el globo que está al pie de su pantalla y ahí puede seleccionar español. If anyone would like to make their public comment in Spanish, we would appreciate you letting us know. And if you have your comment written, we would like to have that beforehand as well. Si hay alguien que quisiera dar o hacer su comentario público en español, les pedimos con mucho respeto que nos avisen y que nos proporcionen su comentario por escrito si es que lo tengan, y así nos podemos interpretarlo. Gracias.
Thank you. Let's see, Ms. Guerra, would you please spell your name for the transcript?
Yes, it's L-U, B as in boy, A as in apple, E as in Edward, Z as in zebra, G as in giraffe, U as in umbrella, E as in elephant, R as in rover, R as in rover, A as in apple, and it's pronounced Lu Baez Guerra.
Thank you very much. Do you swear or affirm to tell the truth?
I swear to tell the truth.
Thank you. I'll start your 3 minutes.
Shikande yeche, poshed yen bikan and ye. I am speaking Navajo. I am saying, help me speak for my ancestors. Thank you for this opportunity to speak here today. My great-great-grandmother and great-great-grandfather were native to the land currently called New Mexico. Apache and Navajo, they were stolen from their tribes as children and placed in settler homes as servants, only allowed to leave those homes after converting to Catholicism and marrying each other. I speak on their behalf, their daughter's behalf, her son's behalf, and his daughter's behalf. I speak on behalf of all my ancestors who are not able to speak for themselves today. We ask, with your great responsibility, that you make all of your choices with all the lives, health, and happiness of New Mexicans in your heart. Deny this proposed rule. We need a rule, but not this rule. The Commission should instead approve a clear rule that states no person shall discharge, dispose of, or reuse treated or untreated produced water off of the oil field. The department shall deny certification of any federal permit proposing to discharge, dispose of, or reuse treated or untreated produced water off of the oil field. Produced water is toxic, radioactive, and possesses serious risks to public health and the environment. This is not just an experiment with the water, it's an experiment with our health. This rule is not just a no discharge rule, it's also a produced water reuse rule, and it authorizes reuse with no science-based evidence or credible standards to ensure safety. This rule as written will lead to contamination through accidents, spills, and waste generation. Workers at treatment plants are especially vulnerable. Water is life. It impacts human life, wildlife, and plant life, our farms and our foods. Our Mother Earth will always heal herself. The question is, will we heal ourselves? Without clean water, we do not live. New Mexico and all of its inhabitants must live. Once our water is contaminated, there is no going back. This land has been here before all of us, and it will be here long after we are all gone. Thank you.
Thank you, Ms. Guerra. Carolyn Hoses?
Was that?
Yes, I see that you're on the platform. If you would please
Okay.
spell your first and last name for the transcript.
All right. My name is Carolyn Houses. First name spelled Karilyn. Haozous.
Thank you. Do you
Okay.
swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes.
All right. To introduce myself, my name's Carolyn Houses. I'm of the Navajo and Taos Pueblo. I have lived on the Navajo reservation. I grew up on there. I also lived in Taos Pueblo. I currently live in Albuquerque, New Mexico. For my Navajo relatives that may be listening, I'm of the Salt Clan and born for Kowatni, which is another word for Taos Pueblo. Many years ago, I'd say about 5 to 8 years ago, we went on a tour, a group of us went on a tour to the fracking wells near Counselor, New Mexico with Mr. Daniel So. I frequently traveled that Highway 550 and I'd see a few of the fracking wells to the left and right of me. But once we traveled on this trip, this tour, to the west side of the road, I was astounded by the many wells that I could see interspersed with the people that were living there. The first thing that immediately struck me was the fumes, and they made me nauseated. I was told about the possible, the detriment that it was causing to our environment and our health. We even saw a pond. I don't know if it was just a watering hole or maybe one of the, but anyway, it was contaminated by the fracking process. I also saw how close a fracking structure was near to a home, and it was reported in the newspaper that there was an explosion. And so that also shows the dangers of fracking. Also, it is a danger and it is an offense to do that fracking so near our sacred sites of Chaco Canyon, as well as other sacred sites held dear and special to the Navajo and the Pueblo people. So I want to end that part there and just talking about the water, fracking wastewater reuse that we're talking about today. First of all, I use that term instead of produce water, because when I think about produce water, I think about the creation of water, H2O. But that is not what we're talking about. we're talking about fracking wastewater reuse, which is H2O plus whatever chemicals that we don't know about, toxic chemicals, forever chemicals, plus the water, plus salt that is used in this fracking process.
Ms. Houses, please wrap up.
Okay, so basically, now that went fast, sorry. But basically, I support the petitions sent forward to you all today. And please do what you can to follow the standards, to involve the scientific community and the public in this process. It is very important for our health, our future, and consideration of 7 generations ahead of us. Thank you. Go ahead.
Thank you very much, Ms. Houses. Melissa Homan. Melissa Homan.
She is on the plan.
Ms. Homan, can you hear
there.
me?
Yeah, so I just was hitting the microphone, but it just finally acknowledged.
All right. Would you spell your first and last name, please?
My name is Melissa Homan, MELISSA HOMANN.
Thank you. Do you swear or affirm to tell the truth?
Yes, I swear.
All right. I'll start your 3 minutes.
Thank you very much for allowing me to speak. I'm sorry, but I get very emotional. I fell in love with New Mexico in the early 1970s. I retired here in the fall of 2014. There is no question that so-called treated produced fracking water is still chemically laced with toxic poisons such as arsenic, mercury, benzene, radioactive isotopes, just to name a few. I can't imagine how in your right mind you would allow this proposed rule to have poison water not to be scientifically regulated and then to be reused for agriculture, irrigation, portable water, aquifer, recharge, and environmental restoration. Beyond me that you would allow this rule. We need credible standards to ensure safety, to protect public health and the environment, and not recklessly dumped. I retired here to the stunning land of enchantment, not to be poisoned. Thank you very much for allowing me to speak.
Thank you, Ms. Homan. Barbara Weisoff. Ms. Weisoff?
Here I am. Can you hear me?
Yes, thank you very much. Would you spell your name for the record, please?
My first name, Barbara, B-A-R-B-A-R-A, last name, Wissoff, W-I-S-O-F-F.
Thank you. Do you swear or affirm to tell the truth?
I swear to tell the truth.
I will start your 3 minutes.
My name is Barbara Wissoff, and I am a low fixed income senior living alone in Albuquerque. My 2 beloved toddler-aged grandchildren, my son and daughter-in-law, and other family members also live in Albuquerque. I want my family and all people to have a healthy present and a healthy future. The radioactive waste from fracking is unsafe for workers, our water, and our air. There is no science supporting that fracking waste in the Permian Basin is any different from fracking waste in Pennsylvania and Virginia. Rebutting Justin Noble's research and facts in defense of the oil and gas industries, despite the known untreatable toxicity of fracking waste, speaks to the Commission's allegiance to oil and gas industries. The current pilot projects in the water reuse rule are in violation of the law because there is no permitting requirement. The Water Quality Commission is obligated to protect water quality for human beings and the environment. Business owners and investors in the oil and gas industries have a conflict of interest deliberating and ruling on the water reuse rule. The term produced water is deceptive and it's gaslighting. Produced water can contain toxic levels of salt, elevated levels of lead and arsenic, and dangerous amounts of the radioactive element radium and its daughters. Treating it has been shown to concentrate these poisons, not get rid of them. In what way is it acceptable to consider reusing fracking's toxic waste and expose more people to harm? I'm vehemently against using fracking's radioactive toxic waste off-site because it is untreatable. Even pilot projects on the oil field have failed, and treatment plants have failed and closed. There is no reason other than profiteering at the expense of the population to build another treatment plant or allow a pilot project. Persons who need work will take jobs at proposed treatment sites, and they and their families will get sick and might die. Read Justin Noble's book, Petroleum 238. Our governor shouldn't propose further enabling corporations and related labs and industries to profit from abusing the population. Apparently, some of New Mexico's laws were made to benefit oil and gas companies while harming the legislators' and rulemakers' constituents. These industries are poorly regulated. Their incessant appeals to avoid complying with existing regulations are on record. There is no reason to think the fracking companies would comply with any regulations now or in the future. The royalties New Mexico receives from oil and gas are paltry compared with the company's profits in the billions. I'm done. Thank you for listening.
Thank you, Ms. Wisoff. Cheryl Gardope. Who's here on the platform? All right. Gracie Aragon.
Hi, I'm here. Can you hear me?
Yes, very clearly. Thank you. Would you spell your names for the record, please?
Yeah, so it's GRACIE ARAGON.
All right. Do you swear or affirm to tell the truth?
Yes,
Thank you. I'll start your 3 minutes.
thank you. Good afternoon, Commission members. My name is Gracie Aragon. I am from the Pueblo of Acoma, and I am giving a statement on behalf of my organization, Pueblo Action Alliance, to oppose treated produced water being discharged into ground and surface water. Our organization started in 2016 during the No DAPL movement, an attempt to sacrifice our northern relatives' water. Our organization fights to protect cultural sustainability and community defense by addressing environmental and social impacts in Indigenous communities. PAA is a matriarch-led organization in which our roles to protect Mother Earth are complementary to our roles as water carriers in our communities. PAA is the founder of the New Mexico No Fault Solutions Coalition and has been fighting against the promotion of a hydrogen economy in New Mexico. The governor's strategic water supply plan and the proposed water reuse regulations would continue this legacy of false solutions for New Mexico, as this concept, under the guise of, quote, new water supplies, would tragically recycle, reuse, sell produced water, which is toxic wastewater from oil and gas extraction, for energy development and, quote, augment the supply of fresh water for communities, farms, aquatic ecosystems, and interstate compact compliance. Yet, it is important to understand the environmental and public health risks that come with the reuse of produced water. There is not enough scientific evidence showing that produced water can be treated or is up to par with the state's water quality standards. Fundamental to our organization is advocating for the protection, reclamation, and rematriation of our water resources. Therefore, we have serious concerns about produced water plans that will impact our communities, health, fields, and livestock. For generations, our communities have been exposed to these extractive and experimental practices, where that oil and gas wastewater can contain
Ms.
carcinogens
Aragon?
like benzene, to which there is no safe level of exposure. Yes.
Ms. Aragon?
Yes.
We lose a few words occasionally. We've heard about 99% of it. We've lost a few words. If you would just finish a little more slowly, and if you have your statement in writing, it would be great if you would email it to Pam Jones.
Okay. So just continue.
Please.
Okay. Exposure to benzene can cause cancer and other diseases, harm bone marrow, and damage your immune system. Acoma, with no running water or electricity atop the mesa, has utilized and still utilizes centuries-old water systems to sustain our traditional lifeways. Below the mesa, we protect the water runoff from the Zuni Mountains, better known as the Rio San Jose, to be able to continue and pass down our traditional agricultural practices to the next generation of Acoma farmers and ranchers. Spring, summer rain, and melting Mount Taylor snowpack provide the remaining water supply to my community. I am therefore deeply concerned as the strategic water supply plan is a direct threat and disruption to our natural network of water. Are we going to continue the legacy of experimentation and use our sacred lands and waters as testing sites? Are we able to give full faith that the private public sector is going to drive solutions for New Mexico? This role is a misalignment with the vision we have for our community. This commission, the governor, and the New Mexico Environment Department to properly consult with all sovereign tribal nations in New Mexico and call off all plans to discharge treated produced water into our precious waterways. Thank you.
Thank you, Ms. Aragon. Do you have Ms. Jones's email address to send to her? I think you might have muted her, Pam. Yeah.
She has my.
Oh, okay. So thank you, Ms. Aragon. Ruth Striegel? Okay.
I'm here. Can you hear me?
Yes. If you would spell your name for the transcript.
Yes, my name is Ruth, R-U-T-H, Striegel, S-T-R-I-E-G-E-L.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Thank you for the opportunity to speak. My name is Ruth Striegel. I live in Albuquerque and serve as the co-chair of the board of directors of the New Mexico and El Paso chapter of Interfaith Power and Light, where we work on climate issues from a moral and ethical perspective. Having studied produced water and observed how the incredible amounts of this industrial waste are all over the landscape of southeast New Mexico, I am very concerned about the idea that produced water can be cleaned to a standard that would allow its use outside the oil field. Setting aside the problem of trade secret chemicals in this liquid, the amount of energy required to clean it up makes it totally impractical to say that we can clean large amounts of it. I'm quite alarmed by the idea that California is allowing a less toxic version of cleaned produced water to be used in agricultural settings, especially because so much of our produce comes from California. We cannot let this happen here in New Mexico. Please write the rule to include a clear prohibition on the discharge of both treated and untreated produced water to our ground and surface water. Keep it out of our ecosystem. The rule should not allow authorized use of produced water in industrial projects, which carry the risk of accidents, spills, or other unplanned discharges into public wastewater systems. We do not have sufficient evidence that this use is safe. I'm very concerned that such projects would further entrench the oil and gas industry at a time when we should be moving away from the use of fossil fuels as quickly as possible to limit the disastrous impacts of climate change. Thank you for your time.
Thank you, Ms. Striegel. Eddie Holsgrove?
Hello, yes, that's me.
Terrific. Would you spell your names for the transcript?
Sure. Eddie is E-D-D-I-E, and Paulsgrove is P-A-U-L-S-G-R-O-V-E.
Thank you. Do you swear or affirm to tell the truth?
I do.
I'll start your 3 minutes.
Thank you, and thank you to the commission for allowing time to receive comments. I'm a geologist. I have a degree from Tulsa University, and I retired from the U.S. Army Corps of Engineers. My experience was in geotechnical, environmental, hazardous, toxic, radiological waste, and I retired as a senior project manager administering and enforcing part of the Clean Water Act in the regulatory division. It's my opinion that New Mexico should start slow in this process and not be influenced by the economic threats kind of described this morning. Pilot or demonstration projects should be confined to the oil fields and go through the permitting process, including public notices. The rule is fatally flawed as proposed based on the fact that there isn't a permitting process including public notices. Rather, there's a notice of intent. That's unacceptable. There should be no discharge until we're satisfied with all results. All data derived should become publicly accessible. Only after the data is fully vetted should we consider the terms and conditions for surface discharge. Beneficial use of fully treated produced water could be a game changer, but that remains to be seen. Today's presenter talked about peer-reviewed papers he provided to the Commission, but those papers may not include peer-reviewed papers critical to the produced water treatment. We should attempt to get a 360-degree view of the issue. One issue of concern of mine is the final disposition of the produced water treatment waste stream. This hazardous material would be significant recurring quantities. As a retired Section 404 regulator, I'd recommend requiring the permits for individual projects and very closely monitoring data and on-site activities. There aren't second chances for mistakes. The quantity of unknowns and the clear danger these unknowns represent require us to apply the precautionary principle to the proposed processed water treatment pilot projects. We have to prevent exposure or an unauthorized release. There isn't coming back from that kind of a negative outcome. Thank you very much for your time.
Thank you, Mr. Paulsgrove. Okay, Alexis Martinez Johnson. I think we decided the mic on that side was superior. There, yeah. And if you may sit down, certainly, and just make sure it's green. Right. Did you press the button? There you go. Spell your names for the transcript, please.
Me llamo Alexis Martinez Johnson. That's ALEXIS MARTINEZ Johnson, JOHNSON.
Thank you.
Muchísimas gracias.
Hold on. Do you swear or affirm to tell the truth?
Yes, I do.
I'll start your 3 minutes.
Thank you very much for being here, and thank you for your service to New Mexico. I am a generational New Mexican, and in my professional capacity, I worked in the environmental engineering sector. I graduated from New Mexico Tech, and I thank all the previous presenters for their very heartfelt comments. And we also need to do a reality check, and that is New Mexico is an energy powerhouse. We have over $6 billion in revenue that come in for paychecks, for our public education system, for the public safety here in Santa Fe, where I live with my 4 children. We are deeply committed to ensuring that our environment is safe for our children and that our water is clean. If the United States does not produce energy, there are serious geopolitical factors at stake, such as Iran, and Russia. You need to think very seriously about the decisions you're going to make here. The scientists and engineers can work with water molecules. We're working with water molecules. There's chloride attached to it. That's salt. We can remove that. We will later have an effluent stream. Now, that effluent stream is injected into the subsurface, and you're talking there will never be a time that it's going to ever migrate anywhere out of there. Currently, you have companies that are extracting lithium and other heavy metals from that effluent to use for our EV, our voltaic cells, such as we use for electric cars. Instead of getting those heavy metals from other countries, which have serious environmental issues, we could use that effluent to do that. There are other states that are doing this now. It is my opinion that you should be critical, be very critical with the data and ensure that these companies are meeting those regulations. But we also need to make sure that we are producing energy in the United States. It's not just for New Mexico. We hold the key for our global security. And I also want to say that we have to work together. We have to work with the community, our native community, and scientists are some of the activists. We need to come together instead of this side and this side. We all have to work and live in this environment. We need to be safe. We need to educate our children. And I would just plead with everybody to, don't you think it's time that we work together and do the best for our community, irrespective of you're on this side, I'm on that side? Thank you very much for your time.
Thank you, Ms. Martinez Johnson. Lolly Hathorn. If you would spell your name for the transcript.
Okay, it's Lolly, last name Hathorn, 2 H's in the middle. Anyway,
do you swear or affirm to tell the truth?
I do.
Thank you. I'll start.
As much as I know. No, I'm just kidding. My opinion on this is that we all have problems with regulations, and somebody needs to be in charge of this. And whoever's in charge, I think my opinion would be they're the ones that are responsible for any errors that happen because they're obviously not doing their job or not doing it correctly. I have to say that the oil and gas industry puts a lot of money into a lot of communities. I see it going throughout the state of how much money is coming in. There are workers. If they are stopping any fracking, it's going to put a big, big hole in a lot of people's pockets. And I think that is very important. That's what keeps this country going. And, we need, like Alexis said, we need to work together and try to understand both sides of the coin. Nobody's right, nobody's wrong. There's a little bit of blame to go all the way around. We can't all be perfect, except me. But no, I'm just kidding. But, we have to work together. That is the most important thing, and try to find a resolution and a solution for the issues. And I say keep on fracking. And if you don't like it, frack you. Thank you.
Tracy Major. If you would spell your name for the transcript.
Tracy, Tracy, Major, Major.
Do you swear or affirm to tell the truth?
Yes.
I'll start your time.
I'm Tracy Major. I'm running for House District 20. I do understand the concerns from many people, especially the Native Americans on the reservations. But I also understand how much we depend on oil and gas. For our schools, they have given $13.9 billion. Where are we going to get that if oil and gas goes away? It seems from the past, they have really cut down on freshwater use to 3%. What can oil and gas do to improve, I guess, views or make people happy? They've been proactive, it seems to me, but I'm asking to let oil and gas be part of the decision and don't exclude them. New Mexico relies on the revenue. Thank you.
Thank you, Ms. Major. Erlene Gross Close. If you would spell your names for the transcript. I don't think your mic's on.
There we go. Earlene, last name Grossclose, Groseclose.
Do you swear or affirm to tell the truth?
Yes, I do.
I'll start your time.
I'm Erling Grossclose. I've been a citizen of New Mexico for 40 plus years. I'm a retired commissioned officer of the Public Health Service and an RN. I am a vivid outdoor person who enjoys exploring our forest and state lands for recreational purposes. I would like to thank the Commission for your roles in managing and protecting New Mexico's water resources. Having lived in New Mexico for well over 40 years, I recognize water continues to be a precious commodity for New Mexicans as it has been for generations. As New Mexicans say, agua es vida, that is, water is life, which is no truer yesterday than it is today. We must conserve, protect, and manage this valuable and essential resource above all other resources of the state. Water conservation and proper management of water resources cannot be overemphasized, especially for the protection of public health. The availability of clean water over the centuries reduced waterborne illnesses like cholera, giardia, dysentery, and typhus fever, and improved public health. Conserving and protecting our fresh water supply at all times, especially during times of drought, cannot be stressed enough. It is imperative that the Commission look at all options available that allow for the conservation of fresh water supplies. Reuse opportunities to utilize produced water from oil and gas operations for the purpose of manufacturing and cooling industrial processes is an undeniable step forward to protecting and conserving quality fresh water for human consumption and agricultural food production. I encourage the Commission to support this produced water reuse initiative. In closing, I would like again to thank the Commission for your roles in managing and protecting New Mexico water's resources. My plea to each of you is that reuse of produced water in a safe and consciously applied manner is a critical measure to extend our fresh water supplies for the protection of public health. Failure to do so places an unreasonable demand on our precious freshwater supplies that can be reasonably and responsibly implemented. Thank you.
Thank you, Ms. Gross-Close. Would you provide your written statement to the court reporter?
Sure.
Thank you. Sherry, I'm having trouble reading the last name. Perhaps Morris or more?
Just press the.
If you would state and spell your name for the transcript.
My name is Sherry Morrison, Sherry, Morrison, Morrison.
Thank you. Do you swear or affirm to tell the truth?
I swear to tell the truth.
Thank you. I'll start your time.
Yes, I am a resident of New Mexico. I've been here 22 years. And I'm a concerned citizen. I don't profess to know everything, and I respect
the commission and I respect everyone that has spoken so far and with passion and knowledge. And I just want to reiterate that it's important that we all work together, because I think the people of New Mexico are very smart, intelligent people. And I think that we need to work together. Both sides have their good points and their bad points, but we have to work together to solve this problem. Water is going to be our most critical resource in the future. And we need to make sure that we can utilize water. And I've heard that water can be, the recycled water can go way, way down and will have no effect on any agriculture or anything like that. And I've heard the other side that it could affect our agriculture. But I think there's a way to compromise and do the best thing. And I think by talking to the geologists, the environmental engineers, everyone, to get their pros and cons so that an equitable solution can be found. I want to thank everyone, and I appreciate all the knowledge and study that has gone into this. Thank you.
Thank you, Ms. Morrison. Linda Tiano. Okay. Joey Tiano. Alrighty. Jay Grossclose. Freddie Lopez. Oh, you're Jay? Okay, great.
Traffic jam there.
Okay. If you would spell your name for the transcript. Yes. No. Okay. If you already gave comment in May, we're just taking it once. I don't remember.
I have a couple of additional comments I would like to make.
So you have additional comments you'd like to make? That's fine. Could we accept them in writing, please?
You could.
Okay. They're given the same weight. And if you just give it to the court reporter,
Okay.
it'll be included in the record.
Let me provide those. Some of this is handwritten notes, and I haven't typed it up to submit it that way.
Okay. As long as you type it up by tomorrow, we'll take it.
Okay.
Thank you very much.
Thank you.
Freddie Lopez. If you would spell your name for the record.
Freddie Lopez, FREDDIE LOPEZ.
And this is your first time commenting?
I do have additional comments, but I did speak back in May.
Okay, I'm sorry. I feel like I repeat myself a lot, but maybe I don't say it often enough. We really have time just to accept verbal comments once from everyone. And if you have more to say, we'd love to have it, but we need it in writing.
All right.
So if you would just send an email.
Sounds good. Thank you.
Thank you. And it goes to Pam Jones.
All right.
Okay. Jeffrey Key or Kai? Okay. Is this your first time speaking? Great. Thank you. If you would spell your name for the transcript.
Yes, hello, my name is Jeffrey, Geoffrey.
last name Kai, K-I-E.
Right? And do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes.
Watitseopa, Inme Sotie Yakahanuksta Kwekame. My name is Jeffrey Kai. I'm Bighorn Clan and Little Turquoise Clan from the Pueblo of Laguna, and that was my traditional introduction in Karis. I completed my master's in communication at Northern Arizona University. My thesis work focused on indigenous food sovereignty, topics such as seed rematriation, historical trade routes, as well as international communication. I am now with the communications team with Pueblo Action Alliance. I stand in opposition to the reuse of toxic oil and gas wastewater outside of the oil field. The strategic water supply plan that Governor Grisham announced is not a real solution, as it seeks to use contaminated water for agriculture, irrigation, potable water supplies, aquifer recharge, industrial processes, and environmental restoration. As stated in the proposed rule by the New Mexico Environmental Department, the new regulation being proposed, which is named Ground and Surface Water Protection Supplemental Requirements for Water Reuse, comes as a result of surplus amounts of wastewater from oil and gas fracking, which is the result of irresponsible practices from the industry and the state. For generations, our Native communities have been exposed to these extractive and experimental practices. Laguna Pueblo is home to one of the largest Superfund sites designated by the Environmental Protection Agency, and to this day has disrupted our water tables. Natural springs have been compromised. So we did entrust, energy companies, but that trust was squandered. Don't let this false solution be a decision that you regret in the future, just as our water tables in Laguna are still compromised. This plan does not address the first-in-time water rights that are historically with tribal nations. There is no new water. Energy barons come into our communities disguised in suits to try and convince us they are the experts. They are the ones who have disrupted our ancestral 5,000-year plan to build sustainable communities, restore aquifers, and honor traditional ecological knowledge. There is the consultation with tribal communities to address these water rights. The precedent in working with these tribes effectively referred to the United Nations Declaration on the Rights of Indigenous Peoples, which most countries in the United Nations have already agreed to. Honor tribal sovereignty by presenting this at village meetings, tribal councils, working with all Pueblo Council of Governors and Indigenous scholars who are from the stakeholder communities. This plan does not take into account the ecological impact of our endangered species, traditional medicines, and seasonal pilgrimages. I do not believe the safety standard will not be met and will be treated with ignorance and non-compliance. A violation of our traditional water table disrupts our harvesting cycles, which are granted to us via the American Indian Religious Freedom Act of 1978, which protects the rights of Native Americans to exercise our traditional religions by ensuring access to sites, use and possession of sacred objects, and the freedom to worship through ceremonies and traditional rites. The Strategic Water Supply Plan is sacrilegious. Pueblo Action Alliance is born by defending water, and I will continue to speak until our water is protected. Wahime, thank you.
Thank you very much. Cheryl Lowry. Okay. Is there anyone else on the platform who has not yet offered comment, who would like to make comment during this session? The next public comment session is 9 o'clock tomorrow morning. Please either raise your hand, reach out in chat, or otherwise contact Pam Jones. See anything, Pam? Okay. Is there anyone else in the room who has not yet offered public comment, sir? And then ma'am, come up to the microphone. You would please state and spell your name. You look familiar.
Good afternoon. My name's Rusty Rodke, Rusty Rodke. And it's great seeing you again,
Nice to see you.
Madam Hearing Officer.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead. I'll start your 3 minutes.
Well, good afternoon. Good afternoon, Professor Thompson, others that I've met. It's good to be here. I appreciate the work you do. I had a career in state government, 13 years with the Interstate Stream Commission as a civil engineer, 9 years at Environment Department. We had a hearing in the Rhino landfill with the eminent hearing officer Orth in presiding. Now I teach at the Santa Fe Community College. Okay. I teach now at the Santa Fe Community College. I teach water and wastewater classes. And, balancing public health versus public economic welfare, social welfare, is a balance that has been the basis of my career and probably many of yours. And from serving legislators and other public health and environment careers. And one man's trash is another man's treasure, is an old truism. Well, wastewater, is it a waste or is it a precious resource? The wastewater from oil and gas, if it can be used through regulations such as you're promulgating, I think that it shouldn't be just wasted. It needs to be used. And New Mexico is kind of like the Garden of Eden. You just have to add water. The green of all the river valleys testifies to that. And limiting the oil and gas industry is kind of like killing the goose that lays the golden egg. For example, New Mexico education is suffering and not educating the children according to the Constitution, according to the recent lawsuit. It's hurting enough without robbing it of its funding. So that's another consideration. The oil and gas money builds all kinds of drinking water systems around the state. So being concerned about drinking water is good, both in terms of these regulations and being able to provide competent potable water to everybody. Currently, there's some ongoing research by Dr. Aishan Ghost. He's a professional engineer and actually won the New Mexico Society of Professional Engineers Engineer of the Year Award. And he's an assistant professor at New Mexico Tech. He recently received $200,000 award grant for creating new fresh water from brackish and seawater.
Would you wrap up? I'm sorry.
Sure. And that was from the New Mexico University Team Pitch Award Pilot Program. The governor is very proud of. So I think if you have competent regulations, I think if everybody's held accountable like we tried to do when I was with the Environment Department, then I think that we shouldn't waste this water. We should use it.
Thank you very much. You would state and spell your name.
Good afternoon. My name is Sofia Martinez. Sofia, S-O-F-I-A, Martinez, M-A-R-T-I-N-E-Z.
Ms. Martinez, I believe you also testified.
No, I haven't testified.
You haven't?
No, I haven't.
Okay. Do you swear or affirm to tell the truth?
Yes, I do.
All right, I'll start your 3 minutes.
I'm COVID coordinator of Los Jardines Institute in Albuquerque and president of the Concerned Citizens of Wagon Mountain, Mora County. Yes, I tire of these hearings. Once again, I'm co-coordinator of Los Jardines Institute in Albuquerque and president of the Concerned Citizens of Wagon Mountain, Mora County. Los Jardines is also a member of the No Falls Solution Coalition. I speak today on behalf of those communities which I represent. Collectively, we have over 50 plus years of direct environmental justice work in New Mexico.
Ms.
Our
Martinez.
indigenous sisters and brothers.
Ms. Martinez, please. Both the court reporter and the interpreters are trying to catch your every word. You must slow down.
Okay. Collectively, we have over 50 plus years of direct environmental justice work in New Mexico nationally and internationally. Our indigenous sisters and brothers and land-based communities have generations of environmental stewardship on this, their land. We stand in opposition to this rule, docket number WQCC 23-84R, for its many deficiencies, lack of sound scientific methodology, and legal protections. Although we have no problem with projects, pilot projects, and research, we know that faulty research has always been used to steal, sicken, and kill our communities and resources for a profit or to bail out industries, as this regulation also does. We are not newcomers to this land. We are intimately bound to it and know the damage to our communities and natural resources that we have suffered, the result of ongoing colonialization and industrial profit. Once again, we are asked to bear the cost and risks of pilot projects that will clean up the good water that the oil and gas industry has been allowed to poison. And now our tax dollars are used to attempt to clean these billions of gallons of fracked oil wastewater. With an impending climate crisis, we know that it is the fossil fuel industry, the oil and gas industry, that is the most culpable for the destruction that climate change is revealing to us with tornadoes, hurricanes, fires, floods, and climbing temperatures. And then, of course, there are the increasing earthquakes where fracking is used to produce even more and more profit for the oil industry. This is a bad regulation, and I'm sure it is supported very much by industry. We do not, the Permian Basin, which covers southeastern New Mexico, has made us the first in the last several years in terms of oil and gas production, second only to Texas. We don't want to be first in that, and we would like to be at least second in education, minimum wage, less homelessness, more mental and drug health support. Those are the things that we want to be second and first in.
Would you please wrap up?
The Water Quality Control Commission and the New Mexico Environment Department were set up to protect the resources of the people and the resources of New Mexico. We would like to see the New Mexico Environment Department promulgate rules and push hearings that talk about how we can keep our fresh water fresh rather than trying to clean it up after it's been poisoned. It is basically New Mexico, we can't seem to figure out how to rework our budget, our livelihood to get off the tit of the oil and gas industry and serve our people with a sustainable transition to renewable energy. We continue to be the neo-colony, the guinea pigs for what others do not want to experiment. We say no to fracking, nuclear, hydrogen, and produced water. And no, we will not water our farm produce with poisoned water. Thank you very much.
Thank you. I believe we've come to the end then of those on the platform or in the room who would like to offer comment in this session. The next session is 9 a.m. tomorrow morning. There'll be another session at 1 p.m. tomorrow afternoon. Thank you all. We'll resume then the technical case. Let's see, we need Mr. McCurdy and Ms. Olson at the front table. We're going to resume questions by the commissioners and start with Commissioner Dominguez.
Someone may have left their notebook up here. This is not mine.
There's a notebook on the presentation table. We'll just remind everyone to keep it nice and slow. All right, Commissioner Dominguez.
Thank you, Madam Hearing Officer. Good afternoon, Mr. McCurdy. Thank you for your testimony today.
Thank you, sir.
I'll try to get us out of here before dark. So, want to kind of circle back and cover a little more of some information that you touched on during your rebuttal testimony. So you've probably listened to quite a bit of the testimony, and you've probably heard comments about there's a gap in data out there, and probably some of the questioning coming from the commission. So with the current proposed rule, it's got places in there for bench scale projects, pilot projects, etc. And it appears part of that is to try to fill some of those data gaps. So if this rule is properly constructed and done correctly, will the rule help fill some of those data gaps regarding research and technology advancements? What's your perspective on that?
Yes, sir. I do believe that is the case. Hopefully, I kind of outlined in my testimony that I realized and acknowledged that we have had some data gaps in this in the past. The research is getting much better. There are alternatives to some of the research that allow us to get around some of these analytical techniques. And let me rephrase that, not to get around them, but figure out a way to make them be done accurately. And so what we see is we're seeing this data gap narrow as we're coming down. My personal opinion is we're getting very close to having full-scale knowledge of what this treated water looks like. My reason for testifying on behalf of NMOGA here is to encourage that we keep moving in that direction and not place a ban in place that would just basically stop the clock to a certain extent, because then essentially what we would have to do is look off to other states that are continuing to pursue this to bring data back into New Mexico. I think if the regulations are promulgated properly, that we can continue to do small scale pilot projects within the state and continue to build the data that the state needs.
Okay, and you actually beat me to my next question of if this rule stalls out or is done improperly, will it force the research and technology advancements to the east and to the north or elsewhere rather than New Mexico?
So, and hopefully I respectfully conveyed earlier that I wasn't trying to be flippant, but obviously that would be the case. We've gotten an abundant number of what I call small scale closed loop pilots, meaning where we've run small scale distillation projects. We've gathered that distillate, concentrated brine, analyzed them, and then simply put them back together and put them down a disposal well so it stayed within the oil and gas industry. We're getting to the point now as we narrow that data gap down. Now we need to start looking at alternative uses for that distillate, but similar to what Texas is doing on a small scale. Let's go pick out a small scale of land, Let's monitor it accurately, apply a certain amount of this water, grab samples, make sure we're doing no harm to the environment whatsoever, and build that data along with the additional data associated with the water that we're seeing. So if we can't move forward in New Mexico because we put regulations in place that are going to put up a barrier to that, then obviously the research is going to start. Most likely for now, we'll fall to Texas. Colorado is behind both Texas and New Mexico at the moment. Their problem now is they're still at a point where they're using a ton of fresh water in oil and gas. So the goal is to get them caught up with New Mexico and Texas on replacing fresh water with produced water in oil and gas operations.
Okay, let's switch gears. Talk a little bit about some of the land application side through the Texas Railroad Commission. So you referred to the letters of authorizations and that, you know, some of those have stalled, but there may be some actually moving forward for application to crops.
Yes, sir.
Are there restrictions within those letters of authorizations for type of crop that the reuse water is used on? I maybe say not to be used on edible crops. Could you elaborate on that?
Yes, sir, there is. There's actually a hierarchy within the intended uses for a treated produced water. I've heard comments about drinking this water. That is at the very end of the scope that would ever be considered, because there are so many avenues in between to where this treated water would not directly affect a public or an individual. Ideally, at the very low end would be something along the line of irrigation of a non-consumable crop, such as cotton. Right? Next up from that could be a consumable crop, a livestock consumable crop, such as alfalfa or something like that. Well, now we've got indirect exposure to humans if we're going to eat the cows that graze on the alfalfa. Moving along up from that would be discharge into the surface water stream or something like that, because while you have some sort of dilution effect, now you've also got exposure to fish and other things, possible downstream withdrawals from that waterway. So what we're trying to do is take a look at the opportunities for the time being that have a less chance of exposure to humans as we continue to build this database, but at the same time, prove out the data. For example, can you irrigate a cotton crop with this water and get the kind of growth and improvement you would if you did with the same amount of fresh water? Prior to joining Select, so back prior to, well, now you're making fun of my accent. Prior to joining Select, so this would have been the spring of 2021. Any of y'all that have worked in the Carlsbad to Hobbs area or been in that area, if you'll remember, that area received an abundant amount of rainfall that spring. Literally like a 20-year rainfall cycle. I was in that area often because I was a partner with another guy on a company that was, and we were also right in the middle of COVID, which was wonderful. But we were working in that area, and it amazed me what that area looked like with that extra amount of rainfall. It was just totally unbelievable. Cattle in the area were as fat as I'd ever seen them in my life.
Thank you, sir. Madam Chair, that's all the questions I have. I'll yield the remainder of my time to Chair Thompson.
Thank you, Chair Thompson.
And I will take it. Good afternoon, Mr. McCurdy. Thank you for your testimony. Very helpful. One of the issues that has been raised is the problems with disposal of produce water, both in New Mexico and in Texas. And there are a number of midstream companies that have large pipelines that transport water across the state line. Do you have any idea whether water is going north or going south, and how much?
It is predominantly going south. And I believe the current number that industry is looking at is roughly 2 million barrels a day of water is moving out of New Mexico into that North Culberson Reeves area for disposal within Texas.
Thank you. I was calculating about a fifth of that, just based on the size of the pipeline. Yeah, and to your knowledge, are there any regulations that prohibit that? Either regulations from New Mexico or from Texas?
So again, in transparency, the company that I work for, and again, I'm representing NMOGA here, but we have a pipeline network in Louisiana that brings Haynesville shale water from that play over there, because Louisiana also has geography that's not conducive to disposal. We bring that water into East Texas underneath the Sabine River for disposal over there. There was at one point considerable, as this seismicity picked up in that North Culberson Reeves area, there was concern that someone within Texas, maybe the Railroad Commission, could suspend that water from coming into the state. We don't bring a lot of water via pipeline down that way, but obviously, depending on how that was promulgated within Texas, would that also bar Louisiana water from coming into East Texas, which would be a huge concern. I spoke with an individual with the Railroad Commission. Since I don't have his permission to say his name, I won't say who, and asked specifically about that. I was told, Rick, I'm not going to tell you that there are not water cooler discussions in the commission about that. But what I will say is what we believe under current regulation is that the commission does not have the authority to make that happen. However, the legislature or executive order from the governor could do that. However, it is, to my knowledge, there's nothing underway to make that happen at present. And I'll amend that to say that doesn't mean that if we see seismic events pick up in the future, that couldn't be addressed.
My understanding is, well, no, let's talk about your understanding. Okay. Because I'm sure it's better than mine. There has been discussion in the Oil Conservation Division about limiting the maximum downhole pressures in saltwater disposal wells. Has that happened to date?
That discussion is underway. I will tell you that discussion is also underway within the state of Texas. They have a seismicity review committee that's hosted by the Railroad Commission. That is one of the outcomes of that, is the Railroad Commission is now reviewing, and let me back up a minute. Traditionally, we're associating, and please let me say that I am not a petrophysicist, so I'm not pretending to be an expert in that realm. But the data that we've seen so far says most of the induced seismicity is associated with deep well injection. So they are curtailing that injection, and a lot of it is being moved uphole to a shallower zone. In Texas, that's typically the San Andres zone. We're starting to see the San Andres pressure up in various areas, which is a problem for oil and gas operators, because to reach the common plays, the unconventional plays they're going after now, which are the various Wolfcamp shelves and Wolfberry benches, you have to drill through the San Andres. So now you're having to fight a pressure as you're going down. You typically want to set an additional casing string that you would not have had before, because you want to protect your production pipe from all that water that's being injected in that zone. So in turn, what the commission is doing is taking a look at known disposal pressures in a given area, and then they will come in and look and generally permit a new disposal well based on two criteria. And one is disposal volumes, and it could be 30,000, 20,000, or 10,000 barrels a day. And then historically, what the commission has done is said you get 0.5 PSI per foot as a surface injection pressure based on the depth of your well. So if your well zone, your targeted zone was 4,000 foot deep, you would be allowed 2,000 PSI of injection pressure on surface. What they're doing now is based on known zone pressures in those disposal zones. that can be reduced to 0.25 or possibly less. The concern there from an industry standpoint is if you ask for a saltwater disposal well permit and they come back and permit you for 10,000 barrels a day at 0.25, it's not worth the investment to drill that well.
So that 0.5 PSI per foot.
That was the traditional. And they still are allowing that in some areas, but now they're starting to really look at it and scrutinize it and see if they need to drop that down.
In Texas.
Yes, sir.
And in New Mexico?
They are also looking at pressures. There is a lot of talk underway now that they're also seeing pressure in some of the shallower zones here.
And so if New Mexico did restrict the subsurface injection pressure, they cut it in half from 0.5 to 0.25. What would that do to the industry? First of all, what would it do to the volumes of produced water that could be disposed of in saltwater disposal wells? And then as a result, what would that do to the oil production in the state of New Mexico?
So without going into calculations and figuring out what that exact number is, please allow me to say that the allowed or the available disposal would fall off. So that leaves an operator with two options. You either find another well somewhere else that you can move that water to. And in this case, it would likely be by truck because it would be a decision that would have to be made overnight. So there's not going to be a time to put infrastructure in place. So now you have to truck that water. And so depending on how far you truck it, you may be faced with a traditional 50 or 60 cent a barrel disposal fee, including transportation. And now you may be looking at $3 or $4 a barrel, depending on how far you have to truck that water to get rid of it. That puts an additional expense on the well, also puts additional wear and tear on the roadways in New Mexico, as well as putting more trucks on the road. They're going to hinder the public. The other option is to shut in the well. We shut in the well, we lose that production until such a time when we can find a way to get rid of the water. I think typically, the overall average in the Delaware Basin is 7 barrels of water now for every 1 barrel of oil. So if we cut out 7,000 barrels of water, we cut out 1,000 barrels of oil production. And when you look at it from that standpoint, then that water becomes very valuable on how to get rid of it.
The disposal option becomes valuable.
Yes, sir.
Not the water.
Yes. Well, we have to find something to do with that water or else we lose the revenue. We lose the revenue and the state loses their share of the revenue. And you'll have to forgive me. My company does not make any revenue off oil and gas wells, nor does not make any revenue off oil and gas wells, nor do I. Unfortunately, having been with the operator, having worked for an operator for 11 years, I tend to fall back into that role sometimes by accident.
So the concluding comment, without running the numbers, is if we further constrain the ability to dispose of produced water in saltwater disposal wells, it would have a significant or an insignificant impact on oil production in New Mexico.
My opinion, it would have a significant impact because we are dealing with a balance of water today issue, right? That we constantly have to move that water. I mentioned the 2 million barrels of water a day moving into Texas. If there was some scenario where that was to be cut off overnight, there's literally nothing that would be done immediately but have to shut in that production until an alternative could be found. That would be a significant impact to oil production in the northern Delaware Basin.
And please understand, I am a pretty committed environmentalist. I'm not I don't want to protect the oil and gas industry, but I recognize that revenue from the industry provides something like 1/3 of the support for the state budget in New Mexico. And if we cut that revenue, we would have to either cut expenses or raise taxes to make up the difference. And I think that's an important point. Let's talk about some other things. We've had multiple comments throughout these hearings that there are no studies demonstrating the ability to treat produced water to very high quality. One exception was Mr. Hightower talked about the work done by the Produced Water Research Consortium, but that was, he mentioned just a few studies. I don't remember, there were less than 10 studies, I think. And most of them have not been completed to date, and we don't have data from them. Your testimony, you've provided a large number of references. These were NMOGA exhibits 75 to 127.
Yes, sir.
So that's 52 references. Can you just briefly summarize what is described in those 52 references?
Yes, sir. So it depends on your definition of very high quality water. Okay. Generally speaking, US EPA, most areas consider fresh water to be 1,000 milligrams per liter TDS or less, right? And fluorides will be no greater than 250 or 500 milligrams per liter. If you will look at a lot of those studies where they have done and graded, a lot of it's laboratory evaluation work and things of that nature, they've treated that produced water and easily gotten it. They have results in those studies down below 1,000 milligrams per liter. Now, I will admit, before somebody asked me about it, did they run the extensive list of analysis such as the New Mexico Consortium has developed and referred to as their MPDES plus list? No. That's not. You will typically look at those papers and they will cover maybe 20 or 30 different parameters in water that they looked at. But they're demonstrating how there's several of those papers will talk about organics and how they got particularly BTEX down from detectable levels to below detectable levels. So they're able to remove those organics out of the water. A lot of the inorganic salts and metals have been removed out of the water. So to say that there isn't existing peer-reviewed paperwork and peer-reviewed studies that demonstrate, there are. Now, you can say, well, but there are none out there that reflect 400 constituents. I agree with that, because just in the recent 2 years, mainly through the work at New Mexico Research Consortium, have they developed that list of here's things that we're concerned with and want to make sure that it's not in this water. But there are studies out there reflecting the ability to take a hypersaline produced water and get it down below a maximum level that would be considered for fresh water.
And of these 52 studies, very few of them were done in Mexico State. They were done by other organizations.
Yes, sir. Several of them were U.S. universities. If you will take a look at it, there were some of them done in Italy. There were some of them done in Norway. Some of them were done, I think, a couple in France. So this has been a worldwide issue to take a look at anywhere there's produced water and technology. So it could be a situation to where a membrane distillation manufacturer in the Netherlands published a paper, but they may have used samples of produced water from the U.S. to run through their bench scale testing. So the paper would have been published in the Netherlands, even though it reflected U.S. water.
And there's been testimony about the merits of having peer-reviewed work. Are these 52 references that you provided us with, 52 exhibits? All but a couple of them, I think,
yes,
were published in peer-reviewed journals. Is that not true?
Yes, I would say anyone that's listed as a paper with various corresponding authors, those are all peer-reviewed papers. The ones I would say are not is there's a couple even there, even though they're voluminous, They are white papers, such as the work put out by GWPC, the Groundwater Protection Council, GWPC. You're welcome.
Okay, so I think based on your testimony and the exhibits you provided, it's safe to say that there is a lot of high quality, peer reviewed, published research on treatment of produced water.
In my opinion, there is. And as I mentioned this morning, there are more papers out there than that. I've just pulled in some papers that I was somewhat familiar with and had looked at before and went out and found those to make them available for this hearing.
Let's change gears a little bit. The regulation that's been proposed talks about bench scale, pilot scale projects. Bench scale, I think we all agree, is something that's done in a laboratory.
Yes, sir.
There was testimony provided a couple days ago that pilot scale is not very well defined. And can you give me quantity in terms of barrels per day or gallons per minute or something like that of what would you consider to be the upper limit pilot scale? So that would be the distinction between a pilot scale plant and a demonstration scale plant.
So that's a very good comment you make there, because you are right. There is a wide range of pilot scales being proposed today. The smaller end of that, I would argue, is more of a demonstration plant. Demonstration plant meaning, in my definition, you've taken a bench scale test and you've upsized it to demonstrate how it could work in a real world environment. In my mind, a pilot scale plant is one that is large enough quantity that now you're confident that you could go from that into full scale production at roughly the same economic scale on a linear basis. Demonstration scale plants are typically somewhere in the neighborhood of just say 20, would produce 20 barrels of fresh water a day.
20?
20.
That's a demonstration scale?
Yeah.
That's very small.
And the
800
pilot scale
gallons.
would be 500 to 1,000 barrels per day.
Okay. I think I misunderstand.
Okay.
I think of a demonstration scale as something approaching full scale that demonstrates feasibility, whereas a pilot scale.
Then in that case, then I would reverse how I'm explaining it on my end. In that case, a pilot scale would be the lower end and the demonstration scale. Yeah, I'll go with your language. The demonstration scale would say, this is of a size that we are now confident that we can step up to a full blown treatment system. So a 500 to 1,000 barrel a day could be upsized to a 10,000 to 20,000 barrel a day system. And you would have a high confidence in being able to do that. Demonstration scale would say, pilot scale would say, we took this lab bench work unit and we built a larger version of it and took it into the real world environment.
In your opinion, if we, the Water Quality Control Commission, modified the rule to put in a definition pilot scale, would the industry support that?
I believe we would. We'd have to see what that, to be honest, we'd have to see what that definition is. But again, as long as it was a option to where we can keep moving this research forward within the state of New Mexico, I think that would be favorable to the New Mexico Oil and Gas Association.
Thank you. Another line of questioning. Yesterday, we had presentation by Dr. Vengosh from Duke University. Very well-respected man who's done, a chemist though, not a treatment person. And he argued very strongly in favor of third-party validation pilot testing. Are you familiar with any other type of testing that would involve third-party validation? Now, I'm not talking about simply reporting the data to regulatory agency, but rather where there is actually someone that independent third party is participating in the design, operation, and evaluation of technology.
So one thing I'd like to state up front, even though I have known Dr. Vengosh now for probably 15 years, I've been on various panels with Avner. We have presented to the EPA in different areas. I've been aware of for years the work he and his students have done at the Nicholas School for the Environment at Duke University. I'm consider him well respected by me. Their work, by and large, generally has been anti oil and gas, but they do good work and they do a lot of effort into it, and I respect the work that they do. One thing I would like to say, and I've been in this industry for 44 years. By and large, I understand that the public does not trust industry to monitor itself and say this is how good we're doing. I understand that, and I understand the need for third-party evaluation. One of the reasons would be as we're moving forward, and this would even be perhaps we're further years down the road and we've shown this to be safe and doable, you're still going to need periodically, we need an analysis that go through an accredited lab that has a chain of custody associated with it to show that the sampling techniques met the requirements, hold times met the requirements, the samples were prepared properly before they were submitted to this accredited lab, and then that lab presents the data based on those samples. That's one third party. Another third party can be an engineering firm, and we use that. We use engineering firms to help design this equipment. We can always have a third party engineering firm look at that and say, we agree with this design and we agree with the safeguards that are in place and how it tends to be where they're putting in sample locations and stuff like that. And then in addition to that, like I commented this morning, it's perfectly acceptable for regulators to say, we're going to have a process to where we periodically can come in and inspect your operation.
Okay, so you presented three options. One involves the sampling analysis, presumably of the final product water.
Yes, sir.
Now, it would require sampling and analysis and the intermediate processes within the pilot plant itself.
The comments that I've made publicly for years is I'm not trying to diminish the constituents that are in raw produced water, but we need to focus 10% of our effort on looking at that and 90% of our effort on looking at that highly treated water, because that's the water that would be going into the environment.
And presumably also looking at the residual streams, analysis
Yes.
of the residual streams,
Yes,
because that's going to affect the ability to manage it.
Yes, and I've heard that mentioned several times today, and not diverting away from your question. Industry is doing the things that we're looking at is ways to do this without generating waste streams. Historically, when you looked at saltwater distillation, you would typically, in the older times, it was very common to pull all the divalent cations out of that water prior to distilling it. You would take those out, run them through drop them out, precipitate them out, run them through a filter press, and then transport that off to an environmental landfill. Processes we're looking at today leave those in solution and keep them in the concentrated brine. That concentrated brine will continue to go down a class 2 disposal well.
Okay, so that's doing the third-party sampling and analysis would be acceptable to the industry?
Yes, sir.
And hiring independent organization, an engineering firm or a university or a research institute to look at the design and performance, would you would the industry accept third-party involvement in the initial design of the experimental program, including the design of the equipment?
Let me say,
upfront participation is what I'm talking about.
yes, provided, and I think we could get around the issues with proprietary information, right? As long as we could guard that, then I don't think industry would be opposed to that.
That's exactly what I was going towards. Thank you very much. Okay. Two more questions. Let's talk just a little bit about cost. There's written testimony that has been submitted, and I have no idea who submitted it, but they're talking about cost of disposing produced water in a saltwater disposal well ranges from $1 a barrel to $100 a barrel. Is that true?
Personally, well, first of all, there's not a well out there. Unless you have a well producing 1,000 barrels of oil a day and 1 barrel of water, no one's going to pay $100 a barrel to dispose of that water. I'm personally not aware of any situation, particularly in New Mexico, where someone is paying $100 a barrel. The highest I have ever heard in my career within the U.S. was in northeastern PA, when at the onset of the Marcellus play up there, with no disposal infrastructure in place, we would take produced water and truck it to eastern Ohio for disposal. That on average ran $15 to $22 a barrel to dispose of that water.
Including trucking?
Yes, sir. I would say here in New Mexico, a better value would be somewhere between 60 cents a barrel, and that would be for water that is strictly on pipe and does not see a truck, up to perhaps $4 or $5 a barrel, for particularly like up in areas, say in the San Juan Basin, where it's more of a hilly terrain and truck times are longer to get water to a disposal.
Can't use pipes. Okay, one last line of questions. What is the market price for hydrogen?
So right now, well, the market price is a good question. I know more about what the cost to currently produce hydrogen is, which is typically somewhere in the $5 to $7 a barrel range.
Barrel?
Did I say a barrel? Kilogram. Thank you, sir. Unfortunately, I have a brain that's focused on water. I mentioned I think current usage was something like 10 metric tons or 10 million metric tons per year in the U.S. It's focused predominantly on the West Coast, up in the Northeast, up in upper New York, primarily upper in New York, because they can pull out of the whichever river it is where Niagara Falls is, abundant amount of water. California, because we're going to be green, even though they don't have the water for it as well. And then, so currently for hydrogen production now in California, I believe they do have 4 hydrogen fueling stations for fuel cell vehicles out there. That's why they produce a little bit, generally in the greater Los Angeles area. Most of the rest of the hydrogen within the U.S. is consumed at refineries and also consumed in steel manufacturing process. So that's the little that we typically use. The concept now, and what the current administration would love to see, is to see us move particularly away from diesel trucks to trucks fueled by hydrogen internal combustion engines or hydrogen fuel cells, and build a strong pipeline network across the U.S. to move this hydrogen to where we could use it as a transportation fuel. That would have to be an infrastructure build out, because existing pipelines cannot transport hydrogen.
So if I use following up on if it's $5 to $7 per kilogram, that's fine. What's the projected cost of treating produced water to the ultra pure water quality that would be required for green hydrogen production?
So my guess right now is, assuming we could treat the front end at somewhere in the neighborhood of $1 to $1.50 a barrel, we would likely double to triple that cost to get it to an ultra pure status. Currently, that's not being done anywhere, so I can't put a finite number on it. I can say this, in a previous portion of my career, I was a region technical manager for a service company. The corporate lab was under my purview. We built our own standards for our instrumentation, and we started out building those standards using ultra pure water. This was 2 decades ago, and I bought a ultra pure purification system that would produce 2 liters per day of ultra pure water, and it cost me $15,000 back then.
Yeah, I don't think they're that expensive and to produce ultra pure water in a laboratory, but it's expensive.
Yep.
So the primary treatment of produce water, you're expecting something on the order of $1 per barrel. And that would take it to what level of salinity?
So that would take it to a level of salinity less than probably 500 milligrams per liter. A salinity typical of what we see is a reverse osmosis permeate now, an RO permeate. So as I had shown in my little diagram, that's where we're at now, that the front end of a hydrogen electrolysis facility or green hydrogen would typically be RO. For produced water, we pull that out because typically our produced water is too high TDS for an RO process, and we would put some other thermal process in there.
Okay, thank you. And you just touched on something that I wanted to bring up to the public. Can you treat produced water, Permian Basin produced water, with reverse osmosis?
By and large, no. There are a few zones within the Permian Basin that can. Generally speaking, standard brackish water RO, seawater RO, they're very efficient up to about a raw water of 50,000 milligrams per liter. And after that, they fall off. They can't go much higher than that. I will say there are several companies today, and a couple of them are involved in pilot projects in the Permian that are working with what is referred to as either a cross-flow RO or a counterflow RO. These systems are multi-staged and they're somewhat backwards. You bring a high salinity salt water in on this stage, and it gives, say it comes in at 150, it gives you a permeate that's 70,000 and a concentrate that's higher. That 70,000 moves backwards in the stage to another system. Now it gives you a permeate that's 15 or 20,000 and a concentrate that goes back to the 5th stage. This permeate comes back over here, and now all of a sudden we get a fresh water out of that RO system. They're in the scale up process now to where they determine what economies are going to come out of this. RO on large scale, one of the biggest expense there, number one, is the membranes, particularly if you foul them. And the second thing is energy demand, because you're constantly pushing water against these filters at 1,000 PSI.
Oh, I think the osmotic pressures are much higher than that.
You are correct. That's on some of the lower end. Some of the higher ones are pushing up in the neighborhood. You have to be higher than that because we're looking at 700 to 800 bar.
Thank you, Mr. McCurdy. Those are all my questions.
All right, thank you. We need a break. Let's take 15 minutes, return at 3, and we'll get questions from this side of the table. We are back after a short break. Mr. Wexler has replaced Ms. Olson.
A clear downgrade.
As counsel, as we question Mr. McCurdy. And now we're going to ask for questions from commissioners on this side of the dais. Commissioner Bayless, do you have questions?
I do. First of all, thank you very much for your testimony. I enjoyed that a lot. You mentioned twice, I believe, that the Texas regulators can inspect the facilities. Is it also provided that they can take samples during the inspection?
That is a good question, since I have not been involved with one of those processes up yet, just interviewed them and looked through their permits. I'm aware of the permit requirements saying that we can come in and inspect the facility at any time. I do not honestly recall if it says we can grab samples. However, there are requirements in all those permits, depending on the size of the discharge and the receiving body it's going into, as to what they require you to report on from an analytical standpoint, and how often they require you to report it. And all that information does have to come through an accredited lab.
Thank you.
Sir.
Okay, Commissioner Brancard.
Sorry, I think it's still empty. Anyway, I'll display my technical ignorance here right off the bat and ask you, what is highly polished produced water?
So we typically, currently through the peer-reviewed papers, through the research that's being done, we are aware of certain constituents that can pass through a distillation process. Typically, these tend to be what we refer to as volatile organic compounds, such as ammonia, for one. Methanol would be another instance. Typically, these have vapor pressures lower than water. So before you get to the boiling point of water, they're going to flash off and go with the steam. So we have to come on the downside of that and pick different polishing process. Usually these are absorption processes that will strip those impurities out of that water. Once those impurities are out, then we refer to that as a highly polished water.
Thank you. Okay, so it involves cleaning the water, not making it shiny. Okay.
Yes, sir.
Let me just start then by talking about your direct testimony and this example you have of the hydrogen plant, diagram 1. And you say in your testimony that you're familiar with the proposed rule. Would this schematic meet the definition of an industrial project under this proposed rule?
Yes, sir, I believe it would. With one exception, as I mentioned, half the water in that project will be used for cooling. Typical cooling towers that use evaporative cooling, they flash off part of the water as steam. That remains starts to concentrate up. You can only do that so many cycles, and then you have to replace that water. In a typical industrial process, such as a refinery or a natural gas generation facility that has to have cooling, that water is released through a process called blowdown, so it goes to the environment. If the rulemaking said we do not want that water to be released to the environment through that process, we would have to keep it in a closed loop cycle and then take that water. And as I mentioned earlier, if it is considered, that water is still considered part of the oil and gas domain, we could take that back to a class 2 injection well or to be used in completions. Otherwise, that water would need to be disposed of via a class 1 well if it was considered an industrial waste.
Thank you. That's sort of the next question I have, because I would assume roughly that the numbers that are used on this chart would be the same if this was treated produced water rather than raw water.
Yes, sir. And I had an additional thought that just popped in my head right there. That water that would come off of that blowdown process would typically be, if it went in roughly 250 milligrams per liter, it's going to come off as 2,500, 3,000 milligrams per liter. We could just as easily reroute that to the front end of the hydrogen generation process.
So starting with this 59 kilogram raw water, and then you end up with 25 kilogram wastewater, that's about 40% or plus going into wastewater. And so I think you said this, but maybe you can repeat it. Where does this wastewater go?
So Uh, and like I said, I appreciate you spurring my brain on to different directions. That water that would come off would basically be an RO permeate, or it would, or excuse me, a concentrate, or a concentrate off the electrodialysis unit, electrodeionization unit. I always confuse those two words, and I'm trying not to. The concentrate off of either of those processes could be circulated back around because it would be lower TDS than the incoming produced water. We would mix it into that water, and then it would just repeat through that distillation process again and go through the electrodeionization unit. And any of those, what we would call a reject stream, would just be reverted back around to the front end where the raw produced water was coming in.
Oh, okay. Well, that's good because I was sort of doing very rough math in my head, which is very dangerous to have a lawyer doing math in his head with the numbers you gave and multiplying it by 365 and coming up with, 11 to 17 million barrels of wastewater a year from this facility. But you're saying a lot of this can be recycled.
And the reason I hadn't thought of that till now, because the diagram that I gave you was using RO, assuming you would use RO on the front end. RO reject cannot be put back through an RO again because it's already going to be at its maximum level of treatment. So you would just be inefficiently wasting your time. But if you had a thermal process that could handle water up to 250 or 280,000 milligrams per liter, bringing an RO reject that was 30,000 milligrams per liter back around to that front end wouldn't hurt it at all. And that way you could keep it within the system and minimize those waste streams.
So I'm not sure I completely understood what Mr. Jacoby was testifying to earlier about waste streams. But if you took this wastewater to a disposal well, what class of disposal well would you take it to?
So as I just mentioned, if it was that water that had been polished, there would be some question at some point in time, and that's something that the regulations are going to have to address. You almost have to change the designation of the water. If it's an oil and gas waste, regardless of how it's been treated, and it gets handed off to an industrial process that's regulated by NMED, that's no longer an oil and gas waste. So you almost have to de-waste that water. If you do that, then that reject, if it couldn't be reused in the process, would have to go to a class 1 well. It could not go to a class 2 well. If it was still a oil and gas waste, then it could go into a class 2 well or be used in ongoing completions. If it was an industrial waste, that too could go to an oil and gas completion because there's not there's not a set requirement on the water that can come into a completion. You bring in water, if you brought in fresh water, that's not considered an oil and gas waste.
That's right. There's no, yes. So yes, okay, so thank you. I think now you seem to be on track with what I heard from Mr. Jacoby yesterday, that wastewater from these processes are now being sort of reclassified to such that they would have to go to a class 1 rather than a class 2 well, which obviously is a problem with this proposed regulation because it's telling people to send their waste to a class 2 well.
Right.
Okay.
So might I address that a little further? Just slightly. As I mentioned earlier this morning, the traditional way of treating a produced water and recovering a clean volume involved dropping out a lot of the divalent cations, precipitating them out. Historically, that was a waste that had to go to a landfill. What we're trying to do now is pull some volume of low TDS water out of a produced brine. We're not altering that brine significantly. All it's doing is concentrating up. The discussions, and we have, as an industry, had discussions with EPA regarding that. EPA's consensus has been that as long as you're not substantially altering the ratio of the elements that are in that water, all you're doing is concentrating them up, that still classifies as a class 2 oil field waste. It does not become an industrial waste that would have to go to another form of treatment. That concentrated brine can still go down a class 2 injection well.
Okay, so that analysis would apply to treating produced water.
Yes, sir.
As opposed to putting it through an industrial facility like this hydrogen plant.
Now, again, we start to get into some questions here that have yet to be answered because it hasn't been done. When that produced water comes on the front end of that process and goes through that thermal distillation, and we take the relatively, excuse the term, fresh water, and we push it downstream to go through the electrodeionization, at what point in that process does that piece become no longer oil and gas waste? Does it now become an industrial water? Because then we have to treat everything separately downstream of that, unless we can reuse the waste stream back on the front end, because we can bring that industrial waste into that produced water stream and just push it through the process again, and it just becomes an endless loop.
So the other issue then, I think that also comes to Jacoby's testimony, and when you transform this waste, you also lose certain exemptions, hazardous waste, correct? So if this wastewater had certain constituents concentrated to a level that it went above hazardous waste classification,
yep.
Now this wastewater, you have to deal with it as hazardous waste, correct?
So in certain instances, you're absolutely correct. But if we come through this distillation process and we come through a polishing step behind it, which we would have to, because we have to get very clean water over to this electrodeionization unit. Once we go through there, there's not going to be any hazardous ingredients kick over to that unit. So the waste stream's not going to have it. I heard a public testimony with a lot of concern over the potential for radium to carry through these distillation processes. As I demonstrated, and I believe it was the Pennsylvania example of the treatment plant up at Wysox, PA, and the requirements by the Commonwealth on what they would allow for water to be considered for discharge, radium has to be below 5 picocuries per liter in order to discharge, thus those treatment processes in place. And I'm very familiar with Marcellus water, and there is fair amounts of radium in that water, much higher than most other basins in the U.S., and it is being removed through those treatment processes.
Right. Yes, you could have a separate process just to deal with particular contaminant that's triggering it.
Yes, sir.
Yeah. Actually, I've had to deal with this with our refineries in New Mexico who were triggering hazardous waste levels and had to spend a lot of money. In that case, it was selenium, just to get selenium out of there.
Yes, sir. That in my previous career with Chesapeake Energy, Chesapeake was one of the largest operators in the Barnett Shale in North Texas. That particular brine has a fair amount of barium in it. It's not a problem down hole when barium has a higher solubility at temperature. As you produce that water up hole and in the receiving tanks, the temperature drops, barium comes out of solution. Anytime barium comes out of solution, if there's radium in that water, it comes with it. So yes, we spent some money cleaning up tank bottoms and sending that off to approved low-level radioactive disposal sites.
Just to follow up on Commissioner Thompson's questions about scale, I believe you talked about these pilot demonstration projects somewhere in the range of 20 to 1,000 or so barrels per day.
Yes, sir.
So what I read from this material here, this hydrogen plant is 75,000 to 120,000 barrels per day.
Yes, that would not be a demonstration plant. That would be a full-blown plant.
But they're at this point in the proposed rule, they're both in there as categories. So
yes, and to be perfectly transparent, I'm not aware of any produced water treatment facilities that size currently in operation, particularly in the U.S. Worldwide, we have some seawater desalinization facilities that are that size. Within the U.S., the largest treatment plant we had was the Antero Resources plant in West Virginia, which is currently not operational.
Just let me quick touch on your rebuttal testimony here. Your first topic was dealing with the contention that there's no way of knowing what contaminants may be in produced water. I'm just curious, as a water company, you receive produced water from operators who are drilling wells, and they ask you to go do something with it.
Yes, sir. And by and large, what we do with it now is one of two things. We treat it to a spec where it's suitable for reuse in ongoing hydraulic fracturing, or we put it down a class 2 disposal well.
Now, when you get produced water from an operator, does that operator give you a list of the chemicals that have been added to that water in the drilling process?
No, sir.
So you don't know what you're getting.
No, sir. By and large, we don't. We typically have certain parameters that we require that water meet, meaning it can't contain hydrogen sulfide, dissolved hydrogen sulfide greater than 5 milligrams per liter. It has to have a certain level of bacteria activity below a certain level. And typically that's the only parameters that we ask for, because the purpose of what we're doing now, the constituents in it would not affect that in any way.
And I assume you're aware under the New Mexico Produced Water Act that it specifically states that when an operator transfers produced water to somebody else, the transferee is now responsible for that produced water.
Yes, sir.
And so your response then to that contention is that there are ways of figuring it out, basically, what's in the water. You don't need a list. You can do enough different kinds of testing to that water to figure out what's in there.
Yes, and to be clear, I do not believe I've stated that we're there yet, that we still believe there may be a few unknowns, and that's what the current analysis has indicated. Currently, there's no peer-reviewed papers that reflect that number, because this research is just recently being completed, and that research is in the initial peer review phase. But the research that we've seen over the years, particularly if we go back to Dr. Danforth's paper, said there could be potentially this many unknowns. And as a research, and there are peer review papers out there that reflect this, says now we believe there's this many, we've looked at this water and we think it had this many in it. So we're narrowing that list down. I'm confident, personally, that we are going to get to the point, hopefully in the very near future, to where we understand exactly what's in that treated water.
Okay, so Dr. Balch's testimony states this, and it's also in one of the exhibits that you provided. I believe it's Exhibit 79. It says that pretty much most of the flowback water that's coming from drilling and completion chemicals, that will be pretty much done in the first 30 days after the well is completed. You agree with that?
That generally, yes. And the reason I respond that way is flowback is looked at operators in different basins in different ways. Generally speaking, by and large, industry is not of the contention that flowback fluid is not a produced water. Flowback is a process. Some companies, if you're in the Haynesville Shale, the flowback process ends the minute you start getting deliverable gas out of the well. Some areas, they dictate a time period. If you just mentioned that the first 30 days are flowback, some people may look at the TDS content of the water and say, when we hit this level, we believe we've got through the flowback process and we're in there. This was in the early days, particularly of the unconventional production, where everybody was completing wells with fresh water. That's where we saw a pretty dramatic swing over a temporal period in the constituents in the water, because initially the flowback was relatively fresh. And as more and more naturally occurring, or not naturally occurring, but naturally present produced water was mixed in, we saw that come up, particularly here in the Permian Basin with the abundance of reuse that we see nowadays. That initial production, if you want to refer to it as flowback, is not significantly different than the overall production long-term in the well, because we're taking the water out of other wells and putting them down this new one. So you immediately see that same quality water come back.
Okay. Dr. Balch used the sort of the idea that when you stop seeing much sand in the water, then you know you're past the flow back.
That is true. We had a lot of issues with sand initially up front. There's been a lot of work done to help alleviate that. A lot of people go in with a different size sand at the very tail end of the stage. Some people, depending on what area you're in, will use like a ceramic sand that'll interlock to prevent that other sand from coming out. But yes, up front, particularly years ago, we saw a lot of sand come back during that initial period.
So my question is, would it make sense? Would it make treatment of produced water simpler? Would it make analysis of treated produced water simpler? Would it make the regulator's life simpler if we simply just didn't allow treatment of produced water from the first 30, 60, 90 days of production? And just said that water has to go to a disposal well.
That's a good question. And I'm not sure how I can answer that on a couple of different avenues. Number one, depending on how the well was completed and how it's brought on. If it's brought on through flowback equipment, which is generally designed to capture any sand coming out, then it could be diverted off to another use. Some operators bring those wells on and bring them straight into their existing surface equipment, which means they automatically become mixed with their other produced water, and it would be hard to segregate that water.
In other words, it's complicated.
It's complicated. By and large, the completions that we see in the unconventional world today, I'm not going to say they're benign, but they're relatively low in different chemical constituents. Typically, we see either a friction reducer or a high viscosity friction reducer, which are some variant of a polyacrylamide. We'll see a scale inhibitor in the water, and typically we'll see some sort of a biological control.
Right.
As a biocide, most commonly nowadays, everybody are using processes that are oxidative biocides, so they become relatively immune fairly quickly. Chlorine dioxide, for example. Chlorine dioxide is used in, I believe, 19% of the municipal water treatment plants in the U.S. Peracetic acid's another one. Both of those rapidly decompose in the water. So people have steered away since maybe 20 years ago when we were looking at more biocides like glutaraldehyde, which they have a longer life and things of that nature. And we moved over to these oxidative biocides. Typically, that's unless you're going in with a gel at the very tail end, or where you have to put guar and some other additives. That's the only additives that you see in most of these completions.
Thank you.
You're welcome, sir.
Commissioner Behill, any questions?
I have no questions.
Thank you. Going to the platform, Commissioner McWilliams, do you have any questions? Or Commissioner Rosatos, do you have any questions?
No, Madam Hearing Officer, no questions for me. Thank you.
All right.
I have questions. Sorry, sometimes the platform allows me to unmute myself and sometimes it doesn't.
All right. Go ahead.
Okay. All right. Yesterday we heard testimony from Dr. Vengosh, who stated he believes the rule should have more specificity to it and have specific standards included in the rule. What is your position on that? Do you think that this version of the rule should add those standards?
So I believe that there could be a certain set of standards. I don't know that you're in a position right now to set discharge standards for this treated water, but you could allow a set of standards that would allow continued research in this water along with field projects and pilots. I agree with the statement that we need to continue the data analysis and taking a look at these technologies. And I think ultimately it's going to be a two-step process. It's going to be a process that sets some guardrails for this process to move forward, leading ultimately to a set of standards that would address discharge to
discharged to land or possibly discharged to the surface water.
Okay, but you, at this point, do you think we need to include in the rule a way to be able to discharge, you know, as a demonstration project or as a pilot project as part of this data collection process?
Yes, Commissioner, the purpose of my testimony here is to say that NMOGA is opposed to setting a band in place that would simply say we're not going to go forward with doing this and we're not going to allow this. We would have to have some sort of rulemaking in place, particularly for small scale pilot projects. We do want to be protective of the environment, and we want to do it in such a way that we can gather the essential data without doing any harm to the environment. So there would need to be some sort of regulation in place. If we were looking at a small scale land application, not saying you duplicate Texas. And I hope throughout all of my testimony, I've not made an indication that you need to follow what Texas is doing. I've just given them up as an example. But they have set standards regarding monitoring and analysis in place that if you're going to do this project, this is what you're going to do, and you're going to report this data back to us. And they are specifying what analytes to be analyzed for, how often to do it, where, if we're talking soil, within a plot, where to grab the samples from and how deep. Those kind of standards will need to be developed for these pilot projects.
Understood. As compared to New Mexico, I think you mentioned that New Mexico is ahead of Texas and Colorado in terms of the produced water consortium and these reuse rules, but it sounds like Texas is sort of leapfrog New Mexico in allowing these pilot projects. Do you agree with that?
I would believe I would have to agree with that, the way it was worded.
Do you know what conditions are required that is allowing Texas to discharge into the Pecos River?
So I am aware that TCQ has a set type of analysis that they are looking at. It's also my understanding that they are looking at this expanded list that the New Mexico Research Consortium has developed. Looking at that, so they would have to do the analysis for that full suite of analytes as well. So it's not just, I hope I'm not oversimplifying the process saying that you're going to give us data on 20 different constituents and we're going to allow you to discharge. That is not the case. They were taking a much more extensive approach to this.
And is the Permian water similar in nature, or is there any reason New Mexico wouldn't consider something similar?
If we're talking particularly the lower or the northern Delaware Basin, so right at the state line, that by and large is also Wolfcamp completions. So that's going to be no different than those Wolfcamp completions south of the state line. The little rusty barbed wire fence isn't going to change that anyway. A little bit further northern in the Delaware, you get into Avalon Bone Springs completions. They tend to be a little bit lower TDS, but not much than the Wolfcamp. So essentially, yes, the water is not that significantly different between the two areas.
Okay, thank you. In your role on the Produced Water Consortium, do you think it's the role of the Produced Water Consortium, whether we're talking about Texas or New Mexico, to provide the database of experience to the environmental department?
Yes, I think that's exactly what those consortiums are there to provide for. They're there to generate data that will be significant to the regulators in each state as they move forward with this potential beneficial use of produced water. Several of the universities in both states are doing relevant research in this area, and a lot of it is being funneled up through the consortia in each state, and that's what their role is. The role is to provide this data, provide this to the regulatory bodies in each state so that they can make informed decisions.
And in the last 4 or 5 years that the New Mexico Produced Water Consortium has been in its existence, is it your opinion that they have done this and that they're doing a good job at doing this? data collecting and providing it to the environmental department?
It is my opinion that yes, they are. It is, I will say that it can be a time, what I'm looking for. It takes time to get this done. When you're looking at pilot projects, you go through a process to where you put out an RFP for companies that have technologies to see if they want to apply. It takes a certain amount of time for those responses to come in. Then you need a committee to go through those responses and determine which ones you feel worthy of providing money to for analytical work and that nature. So by this time, we're now through a year. Now we have to run those pilot projects. Unfortunately, and you may find this hard to believe, but pilots don't always come off as planned. Sometimes you think it's going to start in April and you end up starting the pilot in July. So that ends up with delays. By the time you gather all the data and it is sampled in a defensible format, taken into an accredited lab, and the data gets back and you assimilate it, you're now almost 2 years into the process. So now you've got the research. You use that research to build a paper that's going to go out for peer review. Not uncommon for that to take another year. So now we're into a 3-year process and we're starting to see papers come out that are pointing us in a positive direction. Now, from a consortium standpoint, and as I've heard addressed here today, the peer reviewed papers are extremely important and we need that data. But when we're in the research process and we're getting that information back, the consortia is able to start making decisions then. This was a very positive treatment technology. This one was promising, but it needs something extra on the end. And we provide that feedback back to the technology providers. Your process looked great. These numbers look great. You have a problem with ammonia. You need to figure out a way to fix that. So in answer to your question, and I realize I went a little long there, but yes, I do believe the consortia is generating information and data that will help, in New Mexico's case, will help the Environment Department make decisions. And that data is available. These are public consortia. So if you go out to the consortia's website, any of the data through these pilot projects have been generated is available there on that website, as well as to the consortium members.
So do you feel like we have enough of the data in this consortium and released to the environmental to be where we can make these rules today? And also, well, let me just ask that question first.
So if I back up to the statement I made about possibly setting guardrails for these pilot projects, yes, I do believe that we have the data available now to help with setting up those guardrails to allow small scale pilot projects to move forward. Do I believe we're in a position to where we could write a permit for discharge tomorrow? Probably not. We need these pilot projects and continued research work to eventually close this gap to where we can be in that position. Again, I'll reiterate of my own personal opinion that I don't believe we're far off from doing that.
Okay, so you're saying we need to allow these pilot projects to discharge at very small scale, and we're ready for that stage of a project right now, but we're not at the stage for full scale discharge.
That is correct. I would prefer it be like a small scale land application if that's what it was, because this would be something that would be controllable and monitorable, excuse me. I would not be in favor of a small scale project that discharged to a waterway at this point, because it would be harder to monitor that and gather data off of it. That will be something for a little bit later in the process.
And then one final question is related to the public, I guess, being informed of the research, in terms of getting the environmental department to approve discharge, whether it's on a pilot scale basis or a full scale discharge basis. How do we balance the proprietary nature of those treatments with the public needs to feel informed and feel like it's being monitored appropriately?
Okay, and I'd like to make a distinction between the proprietary nature of the technology as opposed to the proprietary nature of any chemicals or constituents that might be in the water. I think The data that's produced, particularly from a defensible data standpoint through an accredited lab, I believe that data should be fully available for the public to review. Any water that would be proposed to be discharged to land in any of these, the public should have access to that. As technology providers are developing this technology, there are advancements being made where intellectual property needs to be protected in that instance. There are ways we can generically describe what the process does without revealing IP, and that would be the proprietary nature that would need to be protected. Not in any way to hide it from the public, but in a way to protect a technology provider's investment in their intellectual property to ensure that their competitors were not able to just swoop up their ideas and take them for their own. But with regards to the data and the quality of the water, that should not be, that in no way should be a protected, that should be available to the public at large.
Okay, thank you. That is all of my questions.
Thank you.
Thank you, Commissioner McWilliams. We'll turn then to questioning from the parties. Mr. Maxwell, do you have questions of Mr. McCurdy? If you were talking, I didn't hear anything, Mr. Maxwell. I believe you're muted. Mr. Maxwell, you're still muted. You can unmute yourself. Perhaps put something in the chat. Did you send him an invite to unmute?
Yes, I did send him.
Well, I see a red microphone. Is there anything in the chat? All right, so Mr. Maxwell will try to rejoin. No, see, we're seeing a red microphone, Mr. Maxwell, on your.
Sees himself.
You just make sure.
I did.
You did.
Yeah, I didn't have a lock, but I did anyway.
Okay.
I sent him a message. I believe he's logged off.
All right. It's raining out there.
Testing. Can you hear me?
Oh, yes, now we can. Thank you.
Okay, excellent. My apologies. That was difficult. It didn't show me muted. Your Honor, I have no questions for Mr. McCurdy. Thank you.
All right. Thank you very much, Mr. Maxwell. Let's see, Ms. Taylor. All righty.
very regularly in their city,
and
so
All right. I would suggest to you that the rulemaking rules are fairly uh, generous, at least the ones as we've drafted them in New Mexico. But Ms. Taylor, do you have a response?
Yes, ma'am. Thank you. Mr. McCurdy is appearing on behalf of NMOGA, not on behalf of Select. And so I am questioning him in his role as a representative of NMOGA.
All right. Objections overruled. Go ahead.
Thank you. Good afternoon, Mr. McCurdy. I'm Liz Taylor, and I represent Select. I'm happy to meet you in person for the first time today. First question I did want to ask is, does concern your employment by Select. Do you think that employment would affect or bias your testimony?
No, ma'am, it wouldn't.
Why not?
Number one, I've been in the oil and gas industry for 44 years now. For the last 15 plus, I've been a strong advocate for the use of produced water within the oil field to replace fresh water use. And then very strongly in the last 5 to 8 years and looking at the potential beneficial use. That was long before my time of employment with Select Water Solutions. So my opinions expressed here today are based a lot on my past history and the things that I've done within the industry. And I'm not here today making those assumptions or based strictly on my employment with Select Water Solutions.
Do you think the use of produced water has broader benefits than just to Select?
Oh, absolutely. It's the New Mexico Consortium has an untold number of industrial participants, as does the Texas Consortium, as does the Colorado Consortium, from operators as well as midstream companies, as well as technology providers. So there's a lot of people interested in this space. Select's definitely not the only one. Select happens to be the largest produced water recycler in the U.S., but that has nothing to do with the potential to beneficially reuse a treated produced water.
I want to just tie up something that Commissioner Brankard was talking about to you about the concentrations of the contaminants in the reject water. Does that relate to the RCRA exemption we talked about a little bit yesterday? Could you explain that?
Yes. So I was here for that discussion yesterday afternoon, or I believe I was here when that came up. That has long time been a concern. This was something back in the early 2010s, NGOs really pushed EPA hard on that the flowback water was different than produced water. Therefore, flowback water was not entitled to that ENP exemption from the RCRA subcategory C hazardous waste regulations. It was the ultimate determination of the Environmental Protection Agency that flowback water was just a part of the production water as a whole and was entitled to that protection. Now, since then, my position has been is I work with the consortia when I look at different technologies, and you can talk to the consortium members because I have brought this up in every one of the membership meetings. When we look at technologies, we need to be sure and we keep an eye on what we are doing with this water. If we, as I stated earlier, we change it significantly in a manner that it could possibly no longer be considered a produced water, then it will be potentially, depending on the constituents in it, it will be potentially considered a hazardous waste. And the disposal expense of a hazardous waste is exponentially higher than that for a produced water.
So let's move on to another topic, the frac focus, which is the database of frac water. And there's been some concern about the use of trade secrets or proprietary redactions in that database. I'd like you to talk a little bit about trade secrets and proprietary information. Are those substances always hazardous?
No, not necessarily. There's many reasons that a chemical manufacturer can go to OSHA and ask for that trade secret exemption. And it may not have anything to do with the hazardous nature of the product. It may be that they have found a unique application for a non-hazardous product. And again, they're trying to protect that from their competitors. So they're asking to keep the name of that ingredient classified. OSHA knows what that ingredient is. The process is you take a safety data sheet that contains every ingredient as listed, along with an identical one that reflects what you're asking for a trade secret process, and you take that to OSHA. OSHA has to look at it and they have to approve that application and allow you to use that trade secret process. Within the rules and regulations, you cannot submit if that product that you're asking for trade secret is a carcinogen and it is in there at a certain level. Though you don't name it, you have to put that health information on that safety data sheet. If that ingredient causes that product to have a level of contaminant that is above what's immediately dangerous to life and health, that information has to be in that safety data sheet. You're allowed to keep the name out, but you're not allowed to hide any dangers that are associated with that product. Another thing that I would like to apply, and I understand this is important to us because we're talking about potentially treating produced water and putting it out, but those regulations weren't developed for hydraulic fracturing. That is developed for all industrial chemical processes within the United States. There are waters and trucks that are transported through water, there are products and trucks that are moved through rail cars and trucks every day. Cities in the U.S. that have trade secret ingredients that have nothing to do with the oil and gas industry. I don't have a problem with doing away with those regulations, but that is something that's going to need to happen at a level. States can have some effect on that. If I remember correctly, Wyoming was the first state to say we will allow no trade secret products listed in frac focus for wells completed in this state. What happens then is typically it's the newer products, the newer chemicals that will be being developed that they want trade secret identification put on some of the ingredients. Those products simply don't go to Wyoming. They go elsewhere.
And if a product in frac focus is hazardous, can people find out what that particular product is?
There is a method within the regulations, and if I remember correctly, this is Federal Regulation 40 CFR 1920.1200 that will go in. It tells you how you go about collecting a trade secret application, but then there's language in there that says if a doctor is treating an individual that has been suspected to be exposed to this chemical and it is something listed as a trade secret in it, that doctor can ask for that information from that manufacturer. The manufacturer is required to supply that information, provided that doctor signs a confidentiality agreement within 48 hours. Likewise, an industrial hygienist who is looking at a group of people that may have been affected by that particular chemical can ask for that information. The company can say they're not going to give it to them. Then that goes before OSHA to determine if fines are in place for not revealing that information. Otherwise, they ask that industrial hygienist to sign a confidentiality agreement or a non-disclosure agreement, and they provide that information.
So moving on to the consortium exactly in New Mexico, are environmental groups members of the consortium?
Yes, they are.
And were you a member of the consortium before you became employed by Select?
Yes, actually, when this consortium was stood up in the fall of 2019, I was an independent consultant. I had my own consulting firm. I had left Chesapeake in June of 2019 and had set up my consulting firm in August. I believe the consortium was officially announced in September of that year. So that's when I had discussions and agreed to join as a consultant because I thought it was an important process and I wanted to be a part of it moving forward. I did not become a Select employee until November of 2021.
And just moving on, have you seen results of testing of the purity of the distilled water from treating produced water?
Yes, as I discussed just previously a while ago, that we're seeing good results come out of the New Mexico consortium. Particularly, Texas is just now starting to analyze water from pilot projects in Texas, so I've not seen those results yet. Seen good results in New Mexico, as well as I've seen very favorable results in the peer-reviewed papers, such as I submitted as NMOGA Exhibit 75 through 127.
And I think you've done this a little bit, but could you describe how pure the water is that can be produced?
So generally speaking, we are getting it down to what would be considered a fresh status, which typically by rule or regulation is below 1,000 milligrams per liter. But in many instances, we're seeing results that are down in the 200 to 500 milligram per liter range on a total dissolved solids standpoint. Total dissolved solids.
And do you know what typical river water, what the TDS in typical river water is? Good river water.
Good river water is typically in that range, somewhere in the neighborhood of 250 milligrams per liter.
And then we've heard from comments from the public in this hearing and elsewhere that some people in the public are afraid of produced water. And can you explain the difference between raw produced water and treated produced water?
Absolutely. Number one constituent in raw produced water is salt. Okay? That is the number one constituent by and large. We oftentimes in this hearing, you've heard produced water referred to as hypersaline produced water. Oftentimes, many times more saline than seawater. Seawater, I believe, was quoted and is normally 35,000 TDS, whereas produced water can vary from 7,000 to up close to 400,000 milligrams per liter TDS. So salt's the number one constituent. It will also contain significant amount of divalent cations, metals, organic, dissolved organics from being exposed to the oil in the formation over years or being exposed to the gas. All of those are going to be a problem for discharge, particularly salt, the salt alone. If I had a pure water that had 150,000 milligrams per liter of salt water in it, or pure salt, I couldn't discharge it anywhere. It would be harmful to vertebrae, it'd be harmful to fish, it'd be harmful to animals, and it would kill plants. So you would have to take salt out of that water or pull water out of that salt mixture. It's no different with produced water. We are trying to extract a level of clean water out of a complex brine, much more complex than just a pure salt water.
And there are other constituents too, other heavy metals and other things. And,
Yes,
and those are removed as well when you treat it.
Yes, that I understand the concern from the public. I would be too, that if I thought that radium or uranium were passing through, whether radium 226 or 228 was passing through, I would be very concerned about discharging that water. But if you take a look at the analysis and you take a look at the pretreatment, distillate, and polishing steps, we see that those radionuclides do not pass through that process.
And the other heavy metals and other constituents.
That's correct.
We've also heard concerns about PFAS in produced water. Do you have some ideas about the source of PFAS in produced water?
So historically, particularly back in the early 1980s, there was a trend where perfluorinated surfactants were used particularly in hydraulic fracturing fluids and gas well completions because they tend to let the well unload the water quicker. That trend kind of died away by 1990. Very seldom are they used today. I still believe if you search frac focus, you may find some rare instances fluorinated compounds being applied, but by and large, not so much. Another source that we see, there are areas to where industry pulls out of surface water, whether it be from a stream bed, pond, river. We see PFAS coming into the process through that. So that is another area where PFAS can get into oil and gas operations.
Would you say, just generally speaking, that PFAS comes more from source water or from what people put into the frac water?
The wells that are being completed today that we are seeing PFAS contamination in, I would be more inclined to say that came in through the source water itself, if that source water was
well, it's a mixed bag there. If it was produced water and eventually this water was treated with something that contained it, it just, as we're aware, it just keeps cycling through the process.
So I don't know that you completed your sentence here, but so would PFAS in the produced water now have an original origin, if I can use that term, in source water today?
It's a combination of the things, Ms. Taylor. Some of it could have come from the earlier use of chemicals, but then again, the PFAS generating compounds were much more abundant through other uses outside of the oil and gas organization than what chemicals have been used inside of the oil and gas organization.
And then just following up on one of the questions from Commissioner Dominguez, you talked about barriers to pilot projects. What did you mean by a barrier to continued investment in pilot projects in New Mexico?
So particularly if we put a ban in place or we make it significantly difficult to look at these small scale pilot projects, particularly for land discharge, to where we can determine how this water might affect some sort of agriculture or some sort of plant and growing, it just makes it difficult for us because there's no way you can do that in a closed loop environment, or it gets very expensive. You can go out and take an abandoned impoundment that's lined, truck in 3 foot of dirt and do it there to where it's all contained. But now you have bringing the dirt in, and eventually you're going to have to close that impoundment. So you're going to have to do something with that as well. The point I was trying to make with that barrier is, if it was me and I was investing money and I'm saying this is how it's going to be done in New Mexico, and again, I'm not trying to pit the two states against each other. I'm just making what would hopefully be a common sense argument that if I say Texas will allow me to do it this way and New Mexico says it has to be done this way, then I'm going to go over here and run that pilot.
I don't think the court reporter can say.
Oh, sorry.
So if the
bar in Texas was much lower than what it is in New Mexico for performing that pilot, then we would likely move the pilot opportunity over to Texas.
I think the proposed rule also has a general ban on any discharge ever.
Yep.
Correct?
Yep.
What's the impact of that ban as proposed in the rule?
So today, no impact. But if I've got the data available tomorrow that says we can safely do this, now we're looking at a year plus, maybe 2 years before we would have that opportunity here, because it's going to take some amount of time to go in and repeal that ban.
So do you think that would chill investment in New Mexico if the ban remains?
Most likely, yes.
All right, thank you. I have no other questions.
Thank you, Ms. Taylor. Commissioner Chair Thompson has a clarifying question.
One question to clarify. Proprietary chemicals have to be reported to Frac Focus.
Yes.
And the composition of those chemicals is secret. But if someone requests, can they get the safety data sheet?
Yes, they can. And let me clarify that. To my knowledge, no one claims a proprietary nature for the name of a particular chemical, but that chemical will have a set of constituents, and perhaps one of those constituents they will claim a trade secret process. Everyone has a right. If we have a product called A1 and it has a list of constituents and one of those is trade secret, the public included has a right to reach out to that company and say, I would like to have that safety data sheet for product A1.
Thank you.
You're welcome.
Okay. Mr. Cox, do you have questions of this witness?
No questions, Madam Hearing Officer.
Thank you. Mr. Hightower.
I really only have one question.
Yes, sir.
Rick. In the current regulations, the way they're proposed, there's a discussion of pilot projects, bench scale projects, and demonstration projects. And in your discussions with Chairman Thompson, there was somewhat of a disconnect. Would it be appropriate within the regulations to maybe put some definitions of quantity-wise to help address those maybe differences in what people think are pilot, demonstration, bench?
Yes, I would agree with that statement, Mr. Hightower. Obviously, from the chairman and my discussion at that point, we were describing identical processes, but calling them two different things.
Correct.
And so I do believe it would benefit if there were definitions that said, this is what is considered a bench scale project. This is what's considered a pilot project. This was what we considered a demonstration project.
While you have the chance, would you like to make a recommendation on maybe a range for the commission?
So typically speaking, I believe if I take a look at most of these projects I've looked in the past, bench scale would generally be something in the neighborhood of, let's say, less than 5 barrels capacity per day. Most of them tend to be in the multiple liters per day type thing, but let's say less than 5. Pilot projects most likely are less than 50 barrels of production per day. And then a demonstration scale project would be typically less than 1,000 barrels of production per day. And that is a produced distillate that would be committed.
So you're talking about produced distillates. So if you're doing 50% recovery, so you would multiply that by 2
yes,
for the amount of produced water.
Yes, sir.
So in the consortiums projects that we have, we've had a couple of projects at Bergendorf that were 20 barrels a day. Those would be considered, in your opinion, not bench, but pilot, small pilots, or?
Well, so I've suggested a range, and perhaps we might need to discuss that range to better define it.
Okay, all right. Okay. So that we've had some in the field through the notice of intent through NMED, a number of companies. One company had a project that was 500 barrels a day. Another company had a project that was 100 barrels a day. Would those be classified as demonstrations for you, or would those be classified as pilot projects?
So,
which?
So we may need to bump up that pilot project because, in my opinion, and understand now that we've agreed on the definition of demonstration scale project, in my opinion, I have a high level of confidence that that demonstration scale project, those results, both from a capability aspect as well as an economic aspect, could be scaled up to a large scale project. I don't have that high level of confidence in a pilot scale project. So what I'm trying to state, 100 barrel a day project, I don't know that I have a confidence that that could be moved to a 10,000 barrel a day project. So we may have to stretch that pilot scale a little bit.
Okay, but you've given us some initial guardrails to think about, and I think that that's fine. So I think you've answered that question. I think that that addresses some of the disconnect we have within the different consortiums in the different states as to what's a pilot, what's lab, what's a demonstration, what's a bench scale. I think that would help. So thank you for your discussion.
Thank you.
Thank you.
Thank you. Mr. Davis, do you have questions?
Hello, Mr. McCurdy.
Good afternoon.
I'm Tim Davis. I represent Wild Earth Guardians. I wanted to thank you for your description of the trade secret process related to safety data sheets. I've got a few follow-up questions about that. You testified earlier that any member of the public could have access to the safety data sheets. Is that correct?
That is correct.
And you also testified that there is a trade secret exemption related to the OSHA regs at 29 CFR 1200 sorry,
Nice.
1910.1200.
And Mr.
Correct?
Mr. Davis, you're a little loud.
Sorry. I'll try and find the right zone here. I just want to ask if it's your understanding that when a trade secret is claimed for purposes of a safety data sheet, that means that there is no unique chemical identifier for that trade secret chemical that would be disclosed on the SDS.
Oftentimes that is the case because that can vary because some of those chemical identifiers, commonly referred to as CAS numbers, those cover groups of chemicals at times. And so I've seen instances where a trade secret has been claimed, the CAS number has been listed. But if it is a unique chemical with its own unique CAS number, they will remove both of them as a trade secret.
So just to be clear,
Yep.
there is no requirement that, you hear me? Did I just cut off? It appears that I was not effective at solving the problem myself. Sorry, right here? Right here? Okay. Don't move.
I commiserate with you.
Yeah. Let me start over. Just to be clear, there is no requirement under these OSHA regulations that a trade secret chemical is disclosed with a CAS number, which is a unique chemical identifier. Is that correct?
But again, there are occasions where those unique chemical identifier numbers are defined to a particular group of chemicals. That there can be more than one chemistry that are very similar to one another within that group that cover the same CAS number. So you could have a trade secret and then have a CAS number behind that. But most commonly, if the chemistry is unique, trade secret is claimed and there will be no CAS number listed beside it.
And there's no requirement. The reason it's not listed is because it's not required to be listed if it's truly a trade secret chemical.
It is my understanding, you are correct. It is my understanding that, as I mentioned, when you take those two versions of the SDS to OSHA, if it has a CAS number associated with it, the version that they have that is bare will have that information on there, but will not be required to be on the one that labeled trade secret.
And one last question about that is, therefore, the general public or even regulators with the state of New Mexico will not have access to the CAS number for those trade secret chemicals.
That is correct, with the qualifier that if it does have health information for that product that would pose a danger to the public, that information does have to be on the safety data sheet.
And I wanted to ask you a few more questions about that as well. You mentioned that we're talking about an exception to the trade secret non-disclosure requirement for healthcare providers.
Right.
So a healthcare provider going through a series of steps as outlined in that regulation could obtain the unique chemical identifier, a CAS number, for a trade secret chemical.
Right.
You said that is also, though, only available to the healthcare provider if they sign an NDA.
That is correct.
Is that a non-disclosure agreement?
Yes.
And so therefore, once that healthcare provider obtains this trade secret information, they can't disclose it to the general public or regulators.
That is correct.
I'm going to move on to another topic. Do you agree that chemicals in frac fluid become constituents of produced water?
Now, I'm not being cagey. Yes and no. Some of the chemicals that are placed into frac water react with the formation and go through a transformation process. The easiest example there is hydrochloric acid. Hydrochloric acid, it's limestone in the formation. It transforms into calcium chloride in water. It is no longer hydrochloric acid once it's spent. However, there
There are other chemicals that will return back with the produced water and will be in the produced water in their original form.
So it's fair to say that some of the chemicals in a frac fluid will become part of produced water.
Yes.
Do you agree that some constituents of frac fluid are subject to trade secret protections?
My experience has been over the years looking at various frac fluid disclosures, particularly through Frac Focus. You do see instances. I believe I've seen the number quoted in several papers before, somewhere in the neighborhood of 8 to 12%, perhaps, or in that general ballpark, that there will be constituents that have a trade secret identifier within that compound.
Therefore, these trade secret chemicals do not have to be disclosed to regulators.
That is correct.
Do you agree that this proposed rule contemplates pilot projects, bench scale projects, industrial projects that would, among other things, characterize produced water that comes from fracked wells?
Yes, and one thing I'd like to reiterate, so a lot of those chemicals that we're talking about that go in with hydraulic fracturing and come out with that flowback water, we're going to have the ability, and as I said, we're getting very close to the point where there are no unknowns in this treated water. So we will have the ability to know if any of those chemistries have made it through that process.
So I want to turn to your rebuttal testimony at NMOGA 151. The very bottom of the page, I'm looking at lines 19 through 22. This is something that I believe earlier in the day you actually quoted, but I'll wait for you to get there.
Thank you.
Yeah. Earlier in the day feels like a few days ago at this point.
All right, you said 19 through 22?
Yes.
Yes, sir.
So you were asked in this this part of your testimony generally about characterization and some of the challenges, and you were responding to some of the challenges about characterizing produced water that were raised by other parties. Is that fair to say that you were asked about challenges with characterization?
I believe that is correct.
And you responded that there were two possible avenues. And I'm just going to read it. One, lower the salinity of produced water so that it can be analyzed by suitable, approved analytical techniques. Or two, improve instrumentation and techniques so that a highly saline produced water can be accurately analyzed. Is that correct?
That is correct.
And you did not suggest simply requiring disclosure of chemicals that are used in frac fluid. Is that correct?
That is something I don't believe I can advocate for, because that's something that consortium I don't believe would have any potential. I don't believe NMOGA would have the potential to push that to existence.
Let me ask you another question that's related. Would you agree that the disclosure of all chemicals used in frac fluid would make it easier to characterize produced water that originates from frac wells?
So one of the things we have seen in the past, there is at least one of the major pressure pumping suppliers, which are the hydraulic fracturing pressure suppliers. They took a position that they were not going to allow any trade secret claims for any of the flat fluid additives they had. They took the position that they said, here's what we'll do. We'll tell you that we use product A1, B2, C3 up here. And then down here, we'll say of those three products, they all contain these ingredients. None of them are listed as a trade secret. That allows some sort of proprietary information regarding which of those constituents went into which of the three products I identified, thus helping prevent one of their competitors from figuring out what they were using in a product. That's primarily what trade secret disclosures are used for, is to where you can keep a competitor from identifying what products you've developed. So do I believe that that helps both the public and regulators understand what's in the fluid as opposed to trade secret, well, obviously that would be the case.
So do you agree that disclosure of all chemicals used in a frac fluid would make it easier to characterize the produced water that originates from a fracked well?
So, and I'm not dodging that question. I believe we are seeing improved analytical techniques that are going to help us identify all the chemicals that are in produced water, regardless of knowing what chemistry was used in hydraulic fracturing. Would it make it easier? Perhaps so. If you have approved analytical techniques in a high saline matrix for that particular chemical. Otherwise, we move to a method to where we improve the analytical techniques, as I suggested, or we move that water to a lower TDS standpoint to where there are approved analytical techniques to look for the various chemicals that are in that water.
Let me try something else here. You spoke earlier about targeted and non-targeted testing. If you don't know the constituents of a sample that you're analyzing, you would use non-targeted testing to try and gain some understanding of what constituents are present in that sample.
So we would use a combination of the two because we do have a good idea of approximately 90% of the constituents that are going to be in that water. So we would use targeted analysis for those where applicable. Non-targeted analysis is predominantly being used to identify those unknown compounds.
You can't use targeted testing for an unknown compound. Is that correct?
I think it's a fair statement.
You can't use non-targeted testing to quantify chemical constituent, correct?
No, I do not believe that is correct. That is the most recent, and I think I use that in my testimony, the most recent research that we have through the New Mexico Consortium identified 12 unknown compounds through non-targeted analysis, or identified that there were 12 yet to be determined, yet quantified each of the 12 at typically part per billion levels in that water.
Let's assume you have a sample of produced water in which you know every unique chemical that was used in the frac fluid. For that sample, you would not need to use non-targeted testing to identify any chemicals that would have been introduced via frac fluid. Is that correct?
I can't say that that is correct because we're having to identify other constituents in that water that may have not been placed in there through the hydraulic fracturing process. There could be organics from the formation that we do not have a firm identification on that we need to identify. Additionally, that there has been research done in the past that when we run frac fluid into a formation, we can see the release of some of the minerals that are in the formation that weren't in the frac fluid when it went in there. Pyrite's one example.
Let me see if I can restate the question. If you know every chemical via a unique chemical identifier, a CAS number, that's in frac fluid, for each of those chemicals, if you want to test their presence in a treated produced water that comes from that source sample, you use targeted testing.
So yes, if when you word it like that, if I knew every single chemical that would be in there and I wanted to determine the concentration of those chemicals in that water, then I would use targeted analysis for those chemicals.
If you have a different sample in which you do not know the CAS number for each chemical constituent in the frac fluid, to characterize that water, you're going to need to use non-targeted testing.
So once again, and I promise you, I'm not trying to be argumentative. In both instances, we would employ non-targeted analysis as well. Non-targeted analysis is used to identify unknown substances that are in the water. There are potentially other unknowns other than the trade secret chemicals that were placed into the water. So even if I knew 100% disclosure of all the chemicals that were placed into the water, I would still deploy non-targeted analysis as part of the analysis process to ensure there were not any unknowns in there that I was not known. In both instances, I would employ both targeted and non-targeted analysis.
And maybe the fault is mine through the wording of my question, but I just want to make clear that I'm inquiring into characterizing the produced water for purposes of finding those chemicals that were in the frac fluid.
Yes, sir.
So in that instance, if you know what's in the frac fluid, you can use targeted testing. If you don't know what's in the frac fluid, you have to use non-targeted testing.
Yes. So allow me to reword that, and you see if you agree with how I'm interpreting it. If I know every constituent that was put into that water and I'm wanting to identify those constituents, I could do that just through targeted analysis. Setting those constituents aside and looking at a separate water that had some components that had a trade secret and did not have a unique chemical identifier, I would have to use both targeted and non-targeted analysis to help identify those compounds. Is that a fair way of how you're?
Based on the statement you just made, would you agree that the disclosure of all trade secret chemicals, all chemicals used in a frac fluid, would remove a layer of complexity to the characterization process of produced water coming from a fracked well?
It should. All right. Not again, not to be cagey, but you're absolutely correct. If we have trade secret claims with and not we do not have unique chemical identifiers with those products, that adds a layer of complexity to determine what could potentially be in that water.
And I have one final question. Are you aware that the state of Colorado has passed legislation that requires the disclosure of all chemicals that are used downhole? Thank you, Mr. McCurdy. Madam Hearing Officer, I have no further questions.
Thank you, Mr. Davis.
Thank you, sir.
So we should take just a 10-minute break because otherwise we will go too long if we try to hit the 5:30 mark. Let's just take 10 minutes, come back at 4:35. Ms. Nasi?
Good afternoon, ma'am.
And I appreciate your in-depth knowledge specifically of the requirements from Texas. So I'd like to talk to you in detail about that, okay?
All right.
So is it your understanding that pilot projects in Texas, first and foremost, require a permit for pilot projects?
Yes, with understanding that they're not really referring to it as a permit. The Railroad Commission is currently referring to it as a letter of authorization, but essentially it is a permit.
And that's because it requires notice.
Mhm.
Could you, I just noticed something before when you were talking to Mr. Davis. It's really important for the record if you could say yes or no, whatever your answer is, instead of even yup.
Okay, yes, ma'am.
Okay, thank you so much. So even though it's called a different thing, you know what a permit requires. One is notice, right?
Yes, ma'am.
The other is specifically in Texas, they require notice to all surrounding landowners, correct?
For a land application or for a surface discharge? And by surface discharge, ma'am, I mean to a waterway or a stream bed.
I don't know that what I'm looking at. It just says before you can get an authorization to conduct a pilot study. These are the requirements that it says. So I'm not sure if it distinguishes actually.
Okay. If I can say this, and that may be why they're referring to these as letters of authorization instead of a permit. I've read through the requirements for a letter of authorization. I do not see requirements in there for a like public comment period, or typically these pilots are small in nature. So they're generally the landowner is going to be inclusive all the way around the pilot itself. And it will be the landowner that is requesting the letter of authorization.
And do you think that it is consistent with public health and the environment to require, if a permit is required, that specifically all the surrounding landowners are notified?
If that is what is required for a permit, and I'm not arguing with you that it is, then yes, that would be required. If these letter of authorizations are conducted in such a way that it is the landowner and he owns the land all around the pilot project, he has been notified.
And there's limits in scale, limits on location and gallons per day, correct?
That is correct.
There's also a technical review of each application. Is that correct?
That is. Are we referring to permits now or letters of authorization?
This just is talking about authorization to conduct a pilot study.
Is this under the Railroad Commission?
It is, sir.
Okay.
So, do you believe that a technical review of each application would be warranted in New Mexico?
Yes.
In addition to a public meeting on each permit application, do you believe that what should be required in New Mexico is that all information regarding the application and the technical review and the determination be provided online? So in our case, it would be on the NMED's website.
I would agree with that. I believe that, as I said, I do not believe the Railroad Commission's letter of authorization requires a public comment period, but it is my understanding that the technical review, the data from the technical review will be available to the public through the Railroad Commission.
And you would agree that that would be appropriate in New Mexico?
Yes, ma'am, I would.
And the other thing is that the application and all the information is available in both English and Spanish.
I think that would be fair considering where we are geographically in the US.
And you would agree that that should happen in New Mexico as well.
Yes, I would.
Now, there's required specific information regarding oil and gas, oil and grease.
Yep.
Yeah, oil and grease, chlorides, sulfides, dissolved materials, petroleum, hydrocarbons, and norm. Those are required to be disclosed.
I believe that is correct, and it is my understanding that the technical evaluation is going to involve a much larger list of constituents than just those.
And would you agree that if this commission should adopt a standards for a pilot project, that at least all of those things should be required to be disclosed?
Yes, I would.
Do you agree that if there was a pilot project in New Mexico, and basically, if you could allow me to not have to repeat that for every single thing that I'm going to go through, but
Okay.
I would like you to assume that.
Yes, right now we're talking about pilot projects in New Mexico.
Correct.
Yes.
And can I just dispense with that first phrase, but you understand, right?
Yes.
That I'm asking you about. If this commission were to allow permit process for pilot projects, that these following things that I'm going to ask you about should be required in New Mexico. Is that fair?
That's fair.
Require full disclosure about how the applicant would propose to dispose of all the residual concentrated waste.
From the pilot project.
Correct.
Yes.
Characterize the source fluids with specificity, including levels.
Please allow me, I'm just trying to be sure that I clearly understand. The source fluids mean the water that was intended to be applied as part of the pilot project.
The produced water that was intended to be.
That is currently required under the Texas process as well.
And you would agree that that
Yes.
would be fair to include here?
Yes.
A schematic of the treatment process.
Yes, I believe that would be fair.
In New Mexico.
Yep.
Characterization of the treated fluids and their consistency in quality, meaning all levels of constituents other than H2O.
I believe that would be fair. If I can clarify that, as I've stated earlier, we have developed lists. The New Mexico Consortium has what they refer to as their NPDES plus list, which is an extensive list. If we could limit it to that list, that would be great, because otherwise we're expanding to unknown processes that I would not know how to comply with.
Where is that list?
That exists. You can get that through the New Mexico Produced Water Resource Consortium. It is referred to again as their NPDES plus list of constituents.
And you think that that's on their website?
It should be, or if not, you should be able to reach out to them for that. I believe that's somewhere in the neighborhood of 400 different constituents or analysis.
So you think that those 400 constituents that that the consortium has listed in the NPDES plus
yes,
should be required to be disclosed to NMED?
Yes.
And that is in terms of not only the fluids themselves, but all levels of constituents, correct?
That is correct. So that would be both. And when you say not only the fluids,
what other constituents would we analyze for that list? It would have to be a liquid.
Sir, I don't know the answer to that, but
Okay.
I'm just reading what it says
Well,
on the
so-
Railroad Commission's
so-
site, and it says characterize the treated fluids and their constituency in quality. And then it says parentheses, levels of constituents other than H2O.
Okay. So if you will allow me to say that I would agree that that list should be analyzed for the raw incoming water, as well as the water that was intended to be applied via the pilot, I would agree to that statement.
And sir, just to be specific, you're talking about produced water, correct?
Yes, ma'am.
Identify the constituents of concern.
Oh, I understand. That's where we're going here. So that would be up to NMED out of that particular list of constituents. Obviously, there's a lot of things in there to be concerned about. I would say there was a ranking. It's one constituent may not be as concernable as one over here that's extremely hazardous. So I would allow NMED to go with particular notice. We want to know these levels here.
A description, a full comprehensive description of the reuse scenario.
I think that's fair, yes.
A comprehensive description of the water treatment methodologies, in parentheses, i.e. modalities, and how they will directly affect the reuse scenario.
I think that's fair.
And, you know, you were talking with a couple of other attorneys before, and I think that what you said is that in the pilot projects, you would favor full disclosure of constituents, but that the methodologies, the exact way, the instrumentalities, I'll call it, that still be allowed to be not disclosed.
So, if you'll allow me, I would advocate that the general description of that be allowed. Like I could come to you and say, this is a thermal treatment process that is going to recover a clean water vapor from this produced water without going into it's going to have multi-stage eductor size, this size and all. That would be intellectual property, but I could give, our industry could give a general description of exactly what's going to occur in that treatment process. Right.
Now, what I noticed further on the Texas Railroad Commission site is that at any point, first of all, NMED for us would be able to deny an application. Would you agree with that?
Yes.
And also that the NMED, like the Railroad Commission, could ask for further information,
Yes.
could require limits on some parts of the application and allow the others,
Yes.
could modify the request for a pilot project or the permit for a pilot project on any legitimate basis within the scope of these lists of things that we're discussing.
I believe that would be fair, as long as the regulatory body felt they had a declarative need, a scientific need, that we have a concern from this standpoint. We're not going to allow this. We have a concern until you can demonstrate that it can meet a limit. I would agree to that statement.
Back to the list itself. List any process and or treatment chemicals used at the facility that may be present in the produced water to be land applied, include an estimate of the concentrations that may occur in the produced water to be land applied, include material safety data sheets for each chemical.
They need to update their website. We don't call them MSDS any longer. And to be clear, they're not referencing any chemicals that may be in that water coming in. They're specifying what have you added during this treatment process. You need to disclose that. And if I understand that regulation correctly, yes, you do have to supply the safety data sheet with it, but there's nothing in that wording about trade secret information. You don't have to go into constituents. You have to disclose we used hydrogen peroxide on the front end to oxidize and remove iron.
For instance,
we had to use a certain chemistry as a flocculant to remove solids from the water prior to it going into this desal. That is information that they're going to want to disclose in that permit, along with the name of the product, safety data sheet with it, what was the concentration used in the treatment process.
provide a representative water quality analysis of the produced water and the treated produced water.
Yes.
Provide soil sampling in the application area to establish background soil chemistry to support viability of the present soil to support crop growth. Soil analysis should include sodium absorption ratios, soil pH, calcium, phosphorus, potassium, and magnesium.
And I apologize. I was going to wait till the end to say yes, that I would agree with that rather than respond to each one of them.
Thank you. So what I want to say is that provision is basically to keep your company or oil and gas honest, right? Because you got to do a pre-soil analysis to determine what the constituents in that soil are, for instance. So that if it's all contaminated after, they can't say it was that way from that way before.
And I advocate that on many of the pilot projects, not only just in this space, but when I'm looking at perhaps a new chemical application in a hydraulic fracturing, I want to know the results prior to us adding that, to where I'll know, did it get better? Did it get worse? Right? So yes, background samples need to be taken to where we know what starting point we're at.
Provide an application rate in barrels of the treated produced water that is irrigating the crop.
Yes, I believe that should be done.
Identify constraints associated with the proposed reuse activity.
So an example of that would be if you identify some sort of elevation change on that particular plot of land, then it may be necessary to put a berm on the lower side of that property. So in the event of a rainfall, we do not see runoff from that pilot project.
And then there's a whole slew of administrative considerations as well that are included. So you have referred to some of them. One is that the pilot study permit is only good for 1 year.
So that is correct. There is a provision within the LOA that it can be extended for an additional year.
Yes. If the activity is in good standing.
Yes.
And there's also quarterly monitoring. And again, the analyses have to be tendered to the NMED, and the NMED would have to disclose that in real time on their website.
Yes, and it is my understanding, and I would expect New Mexico to do the same thing. I believe Texas, I think I heard the description earlier today. For land sampling, they use what's referred to as a 5-spot. We have samples in each corner of the plot, as well as one is in the center. That's also what you do once a quarter, as well as this chemical analysis of the raw and treated produced water once a quarter. I would expect the same here.
And sir, there's also a financial security.
Yep.
And I'm wondering, If you could elaborate about that.
So that is caused some interesting discussions. Typically, when we look at financial security, we're talking to oil and gas companies that have generally deep pockets, or at least we like to believe they do. With these LOA processes and the letter of authority being issued to the landowner, then the landowner has to get assistance with getting that financial assurity. Typically, that's done through the technology provider he's working with or the operator that's supplying the water for the project.
Yeah, so if the applicant wasn't a landowner here, but was someone like yourself, Select Water Solutions, and because you applied for an RFI, right?
Yep.
That's a
Or-
yes, right?
Or, excuse me, we submitted information for the RFI. That wasn't an application process. It was a information gathering tool. But yes, we did reply response to that.
And not only Select Water Solutions, but you yourself are the person.
I was the lead point for that project. Yes.
Okay. So so let's say Select Water Solutions was applying for a permit.
Sorry. Yes.
Thank you. Was applying for a permit. Select Water Solutions would have to give some kind of financial security, and maybe that's for NMED to discern the specific details, but financial security is definitely one of those things that should be included.
Yes, let me agree with that completely. Part of the image that this industry has faced from the past have been typically smaller companies that have walked away from project and left cleanups to the states to consider. And if the financial securities they're not there to provide for that cleanup cost, then it's a cost of the state. And I'm not in favor of that. If, first of all, we intend to do no harm, but if we do harm, then it's up to us to clean it up.
And so we talked about quarterly and a final report at the end, correct?
That is correct. And there are certain time limits associated with all that, that within this certain period, you have to have that report back in.
Inspections.
Yep.
So that would also be a commitment on behalf of NMED to this body that they would in fact perform those inspections and then tender that information back to the Water Quality Commission. Is that also correct?
I believe that is correct as well.
In Texas, the pilot projects go right to the equivalent of our Water Quality Commission, the Railroad Commission, and there's no sort of in-between agency like the NMED, right?
So under the current guidelines now, that information goes straight back to the Railroad Commission. Not sure if there may be a division within the Railroad Commission that information would go to for review. I know the people that we're currently working with within the Railroad Commission that are kind of construing all this and working up the guidelines. At present, with this being an NMED process and the Water Quality Control Commission falling underneath the NMED, correct? Not under OCD. So that's the difference in Texas. Those projects are going to be handled by the oil regulator, whereas here they will be regulated by the environmental. At some point in the future, once we get past, if we get past that pilot phase for land application, there is a possibility that PCEQ could become involved with those larger applications. That is at least my understanding of the discussions between those two regulatory bodies.
And I think that the last thing that is required, and I would hope that you would also agree is necessary for a pilot project here, is the certification under oath by an individual, that an individual is responsible vis-a-vis whatever entity that applied for the permit.
I have no problem with that. I'm fully in favor of accountability. That's why projects such as I'm lost the acronym now, but some projects within the state require certification by a professional engineer.
Okay, so onto a different topic.
Madam Hearing Officer, is it possible to get a clarification here? Because from my reading, the Texas system, it's an actual permit, but it's not clear if the questions are regarding permitting with NMED or the NOI process, which is what's in the rules.
All right. So I think the witness was speaking to the letter of authorization that's offered in Texas.
That is correct.
Right. Like, Ms. Nanasi is asking, she's consistently saying permits and relating to NMED, so it's not clear to me which she's referring
Oh, I
to.
see. Okay, so you want to pursue the clarification from Ms. Nanasi?
Yes.
Okay, go ahead.
I'll do it with the witness, right? That's how.
If you can just answer the commissioner's question, when you're asking him about the Texas letter of authorization system, are you comparing it or contrasting it or relating it to?
So she's asking if it would apply to what NMED's proposing, I think, which would be the NOI, but she's using the word permitting, which is not on the table right now.
I see. Okay.
My answer to you, and then I'll ask the witness, is we don't believe that the notice of intent is legal. That's what our position is. And so our position is that a pilot project requires by law under 7013-4D a permit. And so that's my answer to you. My question to you is, sir, if anything that I asked you was unclear, I'm asking you about all those requirements that I just asked you about individually and listed basically in my questions. I'm asking you, should those be requirements under a permit for a pilot project in New Mexico?
So allow me to answer this way, and then you can correct me or we can clarify. If all the requirements that we just walked through differ in any significant way than what's under the current NOI process that's been proposed, then they would have to be considered as a separate process. Is that a fair statement, or is that a fair answer?
What I'm saying is New Energy Economy's position is that the NOI process is illegal, unlawful, and that the reuse in any way of produced water off the oil field under 70-13-4D requires a permit. So I'm talking about New Energy Economy's rule, not NMED's rule. So what I just asked you, all those things,
Yep.
Do you believe those requirements are necessary for a permit process for pilot projects?
So no, I'm not trying to be cagey. I'm trying to be sure I use my words correctly. Regardless of how it's identified, I believe a pilot project that was going to utilize treated water outside of oil and gas operations should have those requirements.
Thank you so much. In NMOGA Exhibit 7, your resume, it states that you serve on the Technical Steering Committee for the New Mexico Produced Water Research Consortium.
Yes, ma'am.
Were you aware of an independent audit that is part of the record in this case as NG, that's Norm Gom, 14, of an independent audit of the New Mexico Produced Water Research Consortium that was finalized in December 2022?
Okay. Yes and no. I was aware that the audit was conducted. I was one of 6 members of industry involved with the consortium that was interviewed by the 3 auditing individuals from NMSU, I believe.
However, I have yet to see a final of that audit available. I have requested to see a copy of that audit, and it has never been provided.
Would you be surprised to know that, well, it's in the record, so you can ask
Okay.
your counsel to see it. But would you be surprised to know that that independent audit recommended that the technical steering committee be eliminated?
Essentially, I have no problem with that. We have, outside of having a meeting initially when we were setting this thing up, that is not an ongoing working group.
Would you agree with this statement that the purpose of treating produced water is to sell the water for reuse and save on disposal costs from injection wells?
The purpose, I would not agree with that. Okay. What I would state is the treatment and use of oil and gas water or produced water outside of oil and gas is to reduce the volume that is going to disposal, because we have disposal volumes that are beginning to cause us issues. And in order to continue growth of oil and gas opportunities within the state of New Mexico, we're going to have to resolve those disposal issues that produced water. Ultimately, this will not be a money-making endeavor for the oil and gas industry. It will likely be an additional cost to the oil and gas industry, because as much as I would like to see it happen, I don't believe the ultimate treatment and recovery of this water is going to be as cheap as how we dispose of water today. Now, it may be as cheap as how we will have to pay to dispose of water 5 years from now, but not today. But the industry is fully aware, without additional avenues, that we will likely see some form of curtailment in oil and gas activities going forward. I've made this statement before. If we were in a situation to where we did not have an outlet through hydraulic fracturing for use of a lot of this water, we would start putting some hard brakes on continued development right now, because we would not have an avenue for this water to go through. Excuse me.
Do you believe that the reuse of treated produced water helps limit the need to use fresh water for fracking?
Absolutely.
Is it your position that investment into recycling and treatment projects is a way to reduce the amount of fresh water needed for new wells while reducing the volume of produced water needed to be managed?
Yes, I think that's a fair statement.
Would you agree that Select Water Solutions is a service company in the oil and gas industry that specializes in water solutions?
Well, it's in the name. But yes, ma'am, I would say that. I will make a statement, and this is a factual statement, that currently, of all the midstream water companies, Select Water Solution is the largest recycler of produced water in the U.S.
And half of your profits come from the Permian Basin. Is that correct?
I would think that. I'm not one of our financial or part of the Treasury Department, but I believe, just looking at it, that would be correct.
Madam Hearing Examiner, may I approach?
Yes.
Madam Hearing Examiner, for the record, this has been uploaded to Dropbox as New Energy Economy Exhibit 34. And Ms. Jones, may I ask, would you please, and just for the record, this is the master's project proposal submitted by Carly Osborne to Dr. Avner Van Gogh, was cited in his May 6th rebuttal testimony that is cited throughout his testimony, including a link, and he testified about it. And so I wanted to talk to you about this report. Okay. And I wanted to ask you if you would read, if you could go, Ms. Jones, please, to the second page where it's highlighted. And so let me just ask you something before I continue. You started to work at Select Water Solutions in November 2021, correct?
That is correct.
And so, you know, though, that Select Energy Services was the name of Select Water Solutions up until about a year and a half or so ago.
June of last year.
Okay. So if you don't mind, could you please read into the record the highlighted portion before you on page 2 and then 3?
Yes, ma'am.
Thank you.
This master project investigates the water quality of produced waters generated from the unconventional oil exploration in the Permian Basin and the treated water generated from a treatment site. As part of this study, 15 water samples were collected at the Chiltepin recycling plant in Pecos, Texas, prior and after treatment that involved temporary storage of the oil wastewater in open reservoir that is managed with a continuous treatment of aeration to the pit. Water samples were analyzed at Van Gogh Lab in Duke University for major elements and dissolved organic carbon, DOC. The data show that the Permian produced water is highly saline, fluoride up to 27,000 milligrams per liter, 1.4 times the salinity of seawater, with high concentrations of ammonium, boron. Excuse me, would you like me to read the numbers that they have there?
If you could, please.
Okay, stepping back to ammonium, 175 milligrams per liter, boron, 50 milligrams per liter, and DOC, 220 milligrams per liter. This water quality infers that disposal or leaking of the Permian wastewater to the environment would cause major damage to the ecological system and contamination of water resources. The data show that the water quality of the treated water is indistinguishable and that untreated than that of untreated, and thus the recycling process in the site does not reduce the salts and contaminants potential of the Permian produced water.
And then, sir, would you, and Ms. Jones, could we go please to the next page? And I would just like you to read the last highlighted portion, sir.
Yes, ma'am.
Can I just, I mean, it might short circuit everything. Typically you can't just read stuff into the record unless it's admitted. We actually don't have an objection to this simply being admitted. It was significantly discussed yesterday by Dr. Van Gogh, and probably it's helpful for the commission to just see the paper.
Yeah, I was going to ask actually, particularly after the readings yesterday from the book. I mean, I didn't even hear a question from you following his reading of that first lengthy passage, like, do you agree with it, for example? So is there any reason not to offer this for admission?
First of all, thank you to Mr. Wexler for having no objection to New Energy Economy Exhibit 34. I would like to read this last one, and then I will ask some questions to follow up on that. And that's the only thing else that I'd like to read into the record.
Okay. Good. Yeah.
May I ask a question? Dr. Van Gogh's testimony refers to a master's thesis. This document is a master's project proposal, or is it, the chair should know better than I about what the difference is, if there is a difference. I don't know. Is this the same document as Dr. Van Gogh was referring to?
This document is the same document that was in a web address in his testimony, in his direct testimony. But it is not a thesis. A thesis represents a piece of completed work that has been presented typically to a committee and approved. This is a proposal. Not clear that it's been approved by any faculty or committee at Duke.
Go ahead, Ms. Zanassi.
Would you, sir, please indulge us and just read that last paragraph on page 4?
Yes, ma'am. The plant was constructed to treat produced water for reuse for new hydraulically fractured wells, as it can be sold at a lower price than fresh water and save on disposal costs. It is with this intention that the technology is vetted, but not clear conclusion of treatment capability can be determined without testing samples with potential methods identified. In this project, the primary evaluation for treatment was to determine the change in composition of the treated produced water. Currently, the recycling plant is not operated.
And sir, you are familiar with this Chiltepin plant?
So this Chiltepin plant is not operational. It has not been operational since my time at Select.
But you are aware of it?
And can I say that yes, along the lines of I'm aware of the 16 plus recycling facilities we have in the Permian in operation right now that do the same sort of treatment that this plant did.
And but this Chiltepin plant is no longer in operation, correct?
It is not it has not been since I've been here.
Okay. And there's no disputing that Select Energy Services is the precursor to Select Water Solutions.
So to clarify that, through bolt-on acquisitions over a several-year period, Select Energy Services had approximately 12 different subsidiary companies, all maintaining their own identity and name and ways of invoicing and ways of doing this, which was becoming a nightmare. Last year, the decision was made to consolidate everything under one company name. Thus, it is now Select Water Solutions. And under that, I say consolidate everything. You have Select Water, Select Chemistry, because we have a chemistry division. And then we have a rental division that they held out separately because it's not related to water that's referred to as peak oil field rentals. But yes, it is the same company.
And you understand that this master student tested the produced water that went into this facility and tested the post treatment.
So this is where we need to start making distinctions, because we're talking exclusively in here about treated produced water as being potentially applied. This is not that water. This facility was never intended to produce that. This facility, and you look at the results of their analysis, is doing exactly what this facility was intended to do, because this water is going to be used in ongoing hydraulic fracturing completions, not released outside oil and gas operations.
But the fact is that post-treatment, the chemicals that were identified and discussed in this report, there was no scientific analytical difference between the produced water that went into, maybe call it feed water, and then the treated produced water. Is
If-
that correct?
Yes. Would you allow me to explain what
Sure.
we try to remove in these facilities? There are essentially three compounds that can affect hydraulic fracturing chemicals that are used in operations. That is dissolved iron in the water, suspended solids in the water, and dispersible hydrocarbons in the water. So these facilities are designed on the front end to be treated with an oxidizer, most commonly either hydrogen peroxide or ozone. That oxidizes the iron molecules. They then go through a chemical flocculation, coagulation, and flocculation process, which brings all these suspended solids and iron particles and dispersible hydrocarbons together. They then go through a process that's referred to as dissolved air flotation. Dissolved air lifts all these contaminants up to the top where they are paddled and skimmed off to where they are treated and be prepared to go to a disposal. That is all that is removed from this produced water. None of the salts, minerals, or metals outside of iron are removed in this treatment process.
Mrs. Nasi, would you come to a good stopping point?
Good stop now.
All righty. We will adjourn for the day then, begin at 9 in the morning with any public comment there is to be given and complete your questioning after that. Thank you.